Almighty God, we give thanks to you, the creator of the universe, the most beneficent, the most merciful, and humbly beseech you to direct and prosper the deliberations of the members of this house here assembled, for the advancement of your glory and the trust and welfare of the people of Trinidad and Tobago. Grant that peace and happiness, truth and justice may be established amongst us for all generations. Thank you very much.
Or affirmation, announcements by the Speaker.
Honorable members, I have received communication from the Honorable Saddam Hussein, member for San Juan Barataria, the Honorable Sean Sobers, member for Tabaquite, the Honorable Jerlene John, member for Couva North, who have requested leave of absence for the period 26 November to 28 November 2025. The Honorable Hanson Narayan Singh, member for Claxton Bay, and Mr. Hans Devines, member for Diego Martin West, who have requested leave of absence for the period November 26 to December 3, 2025. And from the Honorable Penelope Beckles, member for Arima and leader of the opposition, who has requested leave of absence from today's sitting. The leave which the members seek are all granted.
Prime Minister's questions.
Member for Roodal Opino.
Thank you very much. Mr. Speaker. Mr. Speaker, to the Prime Minister. Can the Prime Minister confirm whether UDCOT awarded contracts for the Invaders Bay and San Fernando waterfront projects to International Project Initiatives Limited Consultancy Services?
Honorable Prime Minister.
Thank you, Mr. Speaker. I am very happy that members opposite are interested, if not captivated, by the revitalization plan or blueprint. And it would be remiss of me not to remember and remind us that for 10 years, under your leadership, those on the other side, there was no investment in the economy. There was only stagnation under your watch. This question, number one, about projects, Invaders Bay and San Fernando waterfront, contracts for projects there. I think that question will be better posed to the Honourable Minister of Works and Infrastructure, who has responsibility for those projects. She's currently in the UAE as part of a foreign ministerial delegation pursuing investment for our revitalization plan and our blueprint. I so advise. Thank you.
The next question I have on the list is for Port of Spain North.
Prime Minister, sorry, Mr. Speaker, I have a supplemental question.
I think we had crossed that bridge already. And as you are aware, you are a member of a discussion, you are party to a discussion in another place where we've had made some progress. There has been some progress on it, as you know. We've convened the committee, and there has been some progress. So let's not take up time.
Mr. Speaker, I need your direction. Mr. Speaker, when you rule on... Mr. Speaker, no, please.
Mr. Speaker, on what standing order is the Honourable Member rising
Mr.
on?
Speaker.
You have already ruled, and we are Prime Minister's questions, please.
Well, if we are making, if the member wishes to make an inquiry of me, I will invite him to do so.
Thank you very much. Thank you very much, Mr. Speaker. Mr. Speaker, when you rule on this matter on the last occasion for Prime Minister's question, you or the House was not, our attention was not drawn to the fact that there was a practice direction of this House by former Speaker Wade Mark that allowed supplementary question to the Prime Minister on questions filed for the Prime Minister to come here and answer. So I'm drawing to your attention, Mr. Speaker, that there is a practice direction in this House dated 2014. Mr. Speaker, I am...
No, well, I've heard you on that. And I think that that practice note, as you are very well aware, without disclosing the discussions which took place at another place, and I think you know that that members are enjoined generally from revealing the discussions which take place there. But, as you are aware, and perhaps you may not be aware, but those standing orders came about as a result of long discussion. I am answering you and you're not paying attention to me. Is it that you wish me to sit whilst you have a conversation?
Mr. Speaker, I am hearing you. I am listening to you.
Right.
I don't have to look at you.
Right.
I am listening to you.
As you are aware, those standing orders which were enacted in 2014 and passed in this House were passed with the participation of all the members of the House. I have in my possession the Hansard of the committee meeting, and if I am required to read it, I will. I don't have it here, but I have it in my chambers, where the issue of supplemental questions was phrased frontally at the committee. Okay? And there was a clear, unambiguous, unequivocal, and unmitigated statement of someone who, that member shall remain nameless, who attended and observed Prime Minister's questions in the UK House of Commons and came back and reported to the committee that no supplemental questions were permitted in the UK House of Commons. The way the questions are in the UK House of Commons is that you're allowed 6 questions. There are no supplementals. You can do whatever you please with your 6 questions, whatever time you wish to make of your 6 questions. You may do so. Right? So that's how, and that is why I am further fortified in my view that the decision to leave out supplemental questions out of Standing Order 26 was not a mere omission or oversight. It was done by the committee on a collective basis based on the clear representations made by a member of that committee who is a sitting member of this House today. Right? So it seems to me that we've moved past that. I gave the House an undertaking that I would convene the Standing Orders Committee as quickly as possible. We tried. Because of the unavailability of your good self and your other member, we adjourned it. And, no. In all fairness, the member for Roodal Lopino did ask for a meeting the following week, even though it was adjourned, and we accommodated. Because of the urgency of it, we convened. We've made good headway. I don't want to disclose the nature of the discussions we had in that other place, but as you are aware, we made good headway, and there is a plan going forward. As I said, I am further fortified in my view that it was a deliberate decision to leave supplemental questions out of Prime Minister's questions. There could be no other explanation having regard to the utterances made at that committee meeting. And further, when that discussion took place at the committee, they went on to discuss other things. And I can produce the Hansard for you if you so desire at some point in time, because I have it in my possession. Right? So let's move on. Member for Port of Spain North St. Anne's.
Thank you very much, Mr. Speaker. Mr. Speaker, it is on standing order of clarity and joining the conversation, albeit late, that you are having with us. Mr. Speaker, when one looks at standing order number 2, subsection 1, it clearly states, number 2, in any matter not provided for in these standing orders, resort shall be had to the usage and practice of the House of Commons of the United Kingdom, which shall be followed as so far as they may be applicable to this House, and not inconsistent with these standing orders. That is what we were discussing before. However, separate and apart, it goes on to say, or with the practice of this House. Mr. Speaker, what has come to our attention since the last occasion, and Mr. Speaker was referring to it, is that in 2 prior Houses, if I may call it that, the 2010 to 15 period.
I accept that, and I addressed it in the other place.
If I may complete the question, Mr. Speaker. Mr. Speaker, a proposal was put forward for supplementals, as Mr. Speaker has discussed, with respect to prime ministerial questions pursuant to Standing Order 26, where it is clear it does not expressly provide. However, to fall back now on the practice of this House.
Mr. Speaker, this is an abuse of the House. This is a clear abuse of the House.
I am
There's a
addressing the
process
Speaker.
to use the Standing Orders Committee to ventilate these matters.
I am addressing the Speaker.
Members are being obstructionists. There's a committee to address these matters. Let us proceed, please, with today's sitting of the House.
I am standing. Can both members have their seats? I addressed that, Member for Port of Spain North, I addressed that issue. The accretion of time principle, I addressed that in the committee. I accept that there was a practice note.
If I may be permitted, I was interrupted by my friend. Mr. Speaker, just my duty is to assist the House. My duty is to assist the House and the Speaker, despite the position of those on the other side. Mr. Speaker, what I am referring to is a practice of the House. It is clear that from 2015 to 2025, for 10 years, the practice of the House...
Mr. Speaker, this is an abuse of the Parliament.
We have addressed that. We have addressed... All right, you see? Let's not start on that. We have addressed that. I summarized it as the accretion of time principle. And the members who were present at that other place will tell you that I addressed it. My own view was that it was wrong then to take a part of the standing orders that exists for Standing Order 28 to lift it in an arbitrary manner and impose it on Standing Order 26 was not done in accordance with the process. Full disclosure for the benefit of members of the public, I have asked for the source material which guided that decision. I've been provided with some material which I'm not entirely satisfied answers my inquiries as to it. As a noted administrative lawyer, Port of Spain North, you would know the principle of ultraviolet. You would know the principle of residual power. Residual power is not a catch-all phrase to tell you to do whatever you wish to do. You're a noted public lawyer. All right? Beauty lies in the eyes of the beholder, Attorney General. But let's move on with that. Might I remind members that we've eaten up 15 minutes of Prime Minister's time on this? So I'm going to call on the member for Port of Spain North, St. Anne's West, to ask his question, which is listed at number 2.
Thank you very much, Mr. Speaker. Mr. Speaker, through you, would the Prime Minister advise whether after her meeting with high-level executives from Nutrien last week, will Nutrien be restarting their plants in Trinidad and Tobago this year?
Honourable Prime Minister.
Thank you. Mr. Speaker, some of you may recall that before I came into the chamber last day for the sitting of this House, I met with Nutrien together with the Minister of Energy, the Chairman of NGC, and the head person who came out of Canada to represent Nutrien for discussions. In that meeting, it was agreed that dialogue would continue with the technocrats from NGC and technocrats from Nutrien. So conversations are ongoing, and that dialogue is to discuss what is the best way forward for both parties. And that is all I can report at this point in time. Thank you, Mr. Speaker.
Member for Port of Spain North, St. Anne's West.
Thank you very much, Mr. Speaker. Question number 3 to the Prime Minister. Would the Prime Minister advise whether Shell has received confirmation within the past 30 days from the government of the Bolivarian Republic of Venezuela that it may continue to proceed with plans to explore gas from the Manatee side of the Loran Manatee gas field in a deunitized manner as per the hydrocarbon agreement between the government of Trinidad and Tobago and the government of Venezuela, which agreed to deunitize development dated 2019.
Honorable Prime Minister.
Mr. Speaker, I find this question to be passing strange in that the honourable member is asking me to talk about things between third parties, which is Shell. But maybe the minister has information. I'm really glad he will share it with us. To the member for Port of Spain North, St. Anne's West. Our Minister of Energy and NGC have been addressing all energy-related matters on a consistent and timely basis. And when we have more information, we will share it with this Honourable House and with the public at large. But I do believe the Minister flew to Venezuela, what was it, 15 times? And maybe he has information. If he'll be good enough to share it with the public, we'll be very happy to receive that information. At this point in time, I cannot speak for Shell and the arrangements for Shell. I thank you, Mr. Speaker.
Questions on notice, questions for oral answer.
Member St. Anne's, Leader of the House.
Thank you most kindly, Mr. Speaker. Mr. Speaker, with respect to questions on notice, I would like to ask for deferral of question 12, 13, and 16 for an additional 2 weeks, so members would be able to provide those answers.
Questions number 12, 13, and 16, the answers to those are deferred for a period of 2 weeks. Member for St. Anne's East.
Thank you, Mr. Speaker. Mr. Speaker, question number 1 to the Minister of Education.
Mr. Speaker, it was over the past 10 years that the PNM government failed to provide laptops for all Form 1 students. And so the delivery of the 18,000 laptops is planned to coincide with the commencement of distribution to Form 1 students by the end of this term of this academic year. I want to thank our Honourable Prime Minister for reigniting this program. The total units have been delivered by the vendor in 3 scheduled deliveries. 2,500 units were delivered yesterday, November the 25th, 2025. With the remaining units scheduled as follows: 8,500 units on December the 3rd, 2025, and the final 7,000 on December the 23rd, 2025. But crucially, Mr. Speaker, the distribution of laptops to the schools is scheduled to commence tomorrow, Thursday, November the 27th, 2025. In August 2025, Cabinet agreed inter alia that TSTT be designated as a state enterprise to supply the 18,000 laptops and accessories for students entering Form 1 in the 2025-2026 academic year. Part C of that question. The estimated cost of supplying the 18,000 laptops and accessories is $135 million. Part D. TSTT was engaged through a Memorandum of Understanding, an MOU dated 17th of September 2025, and will utilize the Public Procurement and Disposal of Public Property Act to procure suppliers of laptops. Thank you very much, Speaker.
Member for St. Anne's East.
Mr. Speaker, did TSTT itself procure, or was another contractor used through TSTT?
Minister.
Mr. Speaker, that answer can be provided in writing.
Thank you very much. St. Anne's East.
Thank you, Mr. Speaker. The process used to select the suppliers, would the minister be aware if it was sole select or whether it was competitive tendering?
Minister.
Mr. Speaker, the tendering process was conducted by TSTT, so the details can follow in writing.
St. Anne's East.
Mr. Speaker, this is just to clarify, when the member indicates it will be displayed in writing, what exactly is the position from the Parliament to ensure that the answer comes to?
I'm sorry, I beg your pardon?
When the minister indicates that the answer will be supplied in writing,
yes,
what is the process that will allow the answer to be supplied to the members of the opposition?
I think the usual process will apply, which the clerk is very familiar with. So I think you can rest assured that the usual process will be employed. So if you can move on.
What is the usual process?
Why is he answering? Don't you write?
Thank you, Mr. Speaker. Mr. Speaker, question number 2 to the Minister of Education.
Minister of Education.
Mr. Speaker, the school supplies and book grant for fiscal 2025 was allocated no funding by the then PNM government. It was the Honorable Prime Minister Kamla Prasad Bisesa who saw the need for restoring that funding in the mid-year review. For the 2025 cycle, a total of 31,344 applications were received for the school supplies and book grant. After removal of duplicate submissions, 28,444 legitimate applications remained for processing. Based on the 7,499 monthly income cutoff established for 2025, 20,000 applicants were assessed as eligible and all were processed for payment. To date, 19,914 book grants have been successfully distributed to eligible applicants. As of November the 7th, 86 applicants fall into the following categories: 72 applicants whose checks have been prepared but not yet collected at the district offices, 10 applicants whose checks require reissue, a process currently being addressed by the Treasury Division, and 4 applicants for whom payment will be made upon presentation of the required letters of administration. Payments will therefore be completed when the 72 outstanding checks are collected, the 10 reissued checks are processed, and the letters of administration are presented for the 4 deceased payees. Thank you, Mr. Speaker.
St. Anne's East.
Thank you, Mr. Speaker. Mr. Speaker, question number 3 to the Minister of Education.
Minister of Education.
Thank you very much, Mr. Speaker. Mr. Speaker, the National Maintenance, Training and Security Services Company Limited, MTS, has indicated that the records of the company show 329 projects were completed out of a total of 412 projects between June and August 2025. The number of projects quoted in this question is not accurate based on the records of MTS. It must also be noted that there was a substantial cumulative increase in projects over the period June to September 2025 in advance of schools reopening, due to there being numerous infrastructural issues being reported by respective schools on a daily basis. This resulted in the continual addition of programs approved as emergency works that were independent of the planned July-August vacation repair program. Despite this, Mr. Speaker, all schools were open on schedule on September the 8th. Mr. Speaker, MTS has also advised that the total contract sum of the 329 projects is listed as $93,782,822.58. The final cost of the projects cannot be determined at this time, as the Ministry of Education has not yet received invoices for these projects from MTS. MTS was the project manager for all 325 projects. No funds have been remitted for the projects to date, as invoices have not yet been received by the Ministry of Education. However, during the period May to September 2025, the following sums have been remitted for outstanding payments for works completed prior to May 2025. $361,327.97 under the Infrastructure Development Fund, IDF, and $30,088,376.63 via the RBC fixed rate term loan. The Ministry cannot estimate a date for the remittance of all funding to be paid to contractors for projects completed during this period, as the invoices are currently outstanding. Once all the invoices are received from MTS, the Ministry will submit requests to the Ministry of Finance for the release of funds. Procurement for the 325 projects was conducted by MTS. MTS indicated that their records show a total of 314 school repair projects outstanding as at June 2025, comprising 271 projects under the July-August 2025 Vacation Repair Program and 43 emergency works independent of the Vacation Repair Program. MTS has also indicated a total of 145 projects were not completed during the July-August 2025 period. This represented 62 vacation repair projects and 83 emergency works. MTS has also indicated that as at September 2025, there are 149 school repair projects ongoing. This figure comprises 53 vacation repair projects and 96 emergency works. Thank you, Mr. Speaker.
St. Anne's East.
Thank you, Mr. Speaker. Mr. Speaker, considering that the Minister has admitted that for none of the projects completed in the June to August period, payments have been made, and quoting a figure of 93.7 million, could the Minister indicate whether the funds are available to pay contractors who have completed this work and are expecting to be paid in the very near future?
Minister.
Mr. Speaker, that question does not arise out of this question.
Okay. St. Anne's East.
Mr. Speaker, considering that the Minister indicated that there were 412 projects that were to be done, and 145 of these projects were not completed at that time, could the Minister indicate if the 149 projects as of September 2025 are now ongoing at schools?
Minister.
Mr. Speaker, those projects are continuing through the MTS, and as soon as we have an update, the information will be supplied.
St. Anne's East.
Thank you, Mr. Speaker. Mr. Speaker, considering that contractors would not have been paid for 329 projects from June to August, and 149 projects at least are still ongoing now, could the Minister indicate if the lack of invoices that have not been received represents sloth by the MTS company, which are responsible for producing the invoices so that contractors can be paid on time?
No, I'm not going to allow that for the reason why. For the reason is that you're asking the minister to pronounce on the state of mind of a third party, a corporate third party. I'm not allowing that. You're asking him to pronounce on the state of mind of a corporate state of mind of a third party. So let's move on. Next question. All right, so no other questions. Can I call now on the member for Roodal?
Thank you very much, Mr. Speaker. Mr. Speaker, question number 6 to the Minister of Homeland Security.
Minister of Homeland Security.
Mr. Speaker, let me address the question from the member for Aruka Lupino. It is quite confusing, however, I must say, that the last regime failed to provide this nation with proper CCTV cameras for the protection of our citizens. However, on every occasion I have answered this in this house, I will answer it any way you want to. Because it seems to me that these cameras, because of the $25 million attached, seems to be attracting the attention of the persons on the opposite side. However, I want to tell you something. Remember where I came from, eh? Remember where I came from. Because if the question continues to plague, I will tell you whose daddy is working where. Anyhow, Mr. Speaker. Mr. Speaker.
Answer the question. Come on. Minister, just proceed to answer your question, please.
Mr. Speaker. All right. In an effort, Mr. Speaker, to ensure prudent use of public funds, the Ministry of Homeland Security have solicited quotations from reputable companies from India, China, and the United States. All suppliers offered significant lower prices. That was previously quoted, the amounts. Mr. Speaker, in light of this, the procurement was cancelled in order to save the ministry and provide the officers with relevant bulletproof vests and vehicles where that money could have afforded. Thank you.
Thank you very much, Mr. Speaker. Mr. Speaker, to the Minister of Homeland Security. Minister, was there a legally binding contract between the TTPS and a supplier on this particular matter?
You can ask whether there was an executed contract. Whether the contract was legally binding is not for the minister to say. That's a legal question. I will permit you to ask whether there was an executed contract between the parties.
Thank you very much, Mr. Speaker. To the Minister. Minister, was there an executed contract between the TTPS and a supplier for the provision of 3,000 body cameras for the TTPS?
Speaker and member, I suggest that I should explain, however, that although the arrangement was made, not 1 cent was paid to the persons. And I don't want to quote in law for you because you're a lawyer. Thank you.
Roodal Opino.
Thank you very much, Mr. Speaker. Mr. Speaker, to the Minister of Homeland Security. Minister, can you explain to the House whether there exists a contract between the TTPS and a supplier for the provision of 3,000 body cameras to the TTPS?
Well, I think that's the same question you just asked, right? So you can move on to your third supplemental.
Through you, Mr. Speaker, to the Minister of Homeland Security. Minister, can you state whether legal proceedings have been initiated by the supplier against the TTPS for the cancellation of this contract?
Minister, are you aware of that?
Mr. Speaker, I have no idea as to where the...
Roodal Opino.
Thank you very much, Mr. Speaker. To the Minister of Homeland Security. Minister, can you state whether or not it is your ministry that instructed the TTPS to cancel this contract between the TTPS and a supplier for the provision of the body cameras?
No, I'm not going to allow that. I'm not going to allow that. All right, so can we move to question 7?
Thank you very much, Mr. Speaker. Mr. Speaker, question number 7 to the Minister of Defense.
Minister of Defense.
Well, if the shoe was on the other foot. Mr. Speaker, the former COTTR was sent on leave on Thursday, 7th August 2025, and rescission was Sunday, 10th August 2025, not 24 hours, as the question suggests. And the gravamen of the question was the reason, which I give now. The reason was non-compliance with Regimental Standing Order number 11.
Yeah. In South?
Mr. Speaker, can the Minister of Public Utilities question to the Minister of Public Utilities?
No, Policeman South, I think the practice is you refer the question number 8 to Minister of Public Utilities. In order, for economy of time, for economy of time, we don't read the question, we just identify the number. Minister of Public Utilities.
Thank you, Mr. Speaker. Mr. Speaker, as of June 27, 2025, a total of 336 CPEP core contractors were terminated. CPEP does not employ the workers, but the amount of ghost some CPEP contractors who were running, members opposite might be quite familiar with that.
Question, Mr. Speaker,
yes.
rising on that. Seeing that you are quick to call ghost, how many ghosts have you particularized or identified as persons who were drawing money under CPEP and not working? How many?
Minister?
Mr. Speaker, I think the honourable member might be quite familiar with all the legal action that they have taken on this matter and how many losses they have had at the court. Mr. Speaker, if they were more concerned about workers under the guise of what they are really concerned, which are really the contractors, some of whom sit among us today, Mr. Speaker.
The question. Yes, I'm permitted one more, Mr. Speaker.
Yes.
Whose decision was it? Who made the decision to terminate those contractors?
All right, that does not rise from your question. That's not a legitimate supplemental. Let's move on. Member for Laventille West. Oh, no, sorry. I wanted to ask. Diego Martin Ortiz, the final supplemental.
Thank you very much, Mr. Speaker. Based on the response given by the Minister, to wit that CPEP does not employ the workers, what I do know is that CPEP paid the wages. So how many workers were paid prior to the termination of the program?
I don't think that supplemental question arises from it, so I'm not allowing that. Okay, I'm going to call on Laventille. Member for Laventille West.
Mr. Speaker, question number 9 to the Minister of Rural Development and Local Government.
Development.
Mr. Speaker, if we have to bring the whole truth to this Parliament, the opposition will never ask this question.
Never.
In the short time that I am allowed, in the short time that I am allowed, I cannot list the incidents of radio talk show hosts who get paid under this program and never report to work.
Not once.
Members of the opposition bench, relatives who listed who never report to work. What I can tell you is that when we came into office, we met 928 workers on paper. Mr. Speaker, with the number of employees who never reported to work, some of them who were living outside of Trinidad and Tobago.
Yes.
Termination letters were issued for all 928 contract workers, some of them who, as I say, we couldn't even find them to give them a letter. Some of them only turned up to receive their letter.
They was in jail.
There were also 130 public servants who have been absorbed into the Ministry of Rural Development and Local Government and assigned to various municipal corporations throughout Trinidad. Thank you, Mr. Speaker.
Member for Laventille West.
Mr. Speaker, supplemental question. Could the Honourable Minister indicate what notice was given on the termination letters to the said URP workers?
Mr. Speaker, the members on the other bench, several of them are involved in matters and representing former workers of this program. They have received copies of those letters and they are sending numerous legal letters to the Ministry of Rural Development, and we will deal with every one of them.
Every single one.
So to ask this question, Mr. Speaker, to ask this question, it is actually the same process that the PNM government used in 2015 to fire people 1 week after the election. 1 week.
Laventille West.
Deeply grateful, please, Mr. Speaker. Can the Honourable Minister indicate, in light of termination notice going out to the workers, whether the 1 month's payment in lieu to the URP workers were paid to date?
Thank you.
Laventille West, the way the question is framed, the primary question, I am disinclined, but Minister, if you are inclined, answer.
Mr. Speaker, Mr. Speaker, because of the millions of dollars that have been wasted under the previous government with the URP, millions, hundreds of millions of dollars, I want to advise that audits and investigations are being conducted. It is standard when you have termination or end of any contract, whether it is in the public service or wherever it is, these things have to be audited before payments are made, and all the financial regulations and requirements will be adhered to by this law-abiding government.
Until West.
Thank you, Mr. Speaker. Mr. Speaker, based on the response by the Honourable Minister, can the Honourable Minister indicate what timeline for the audit report to come to an end, please?
Sir?
Thank you. Mr. Speaker, Mr. Speaker, those things are not in the hands of the minister or any political person. This is a process of the public service. There is an auditor's department, and they treat with it as they see necessary, and they follow the rules. It's not in my hands.
San Fernando East.
Thank you, Mr. Speaker. From the question asked, how many staff members were relieved of duty at the URP program? She didn't say staff.
I think that was asked and answered already.
Mr. Speaker, she did not mention the staff. I asked specifically about the staff. Mr. Speaker.
I think the original question was, can the minister indicate how many workers at the unemployment relief program have been sent home and or terminated? And I think the minister answered. So I rule asked and answered. Thank you. Okay. Member for Aruka Lopino.
Thank you very much, Mr. Speaker. Mr. Speaker, question number 10 to the Minister of Public Utilities.
Minister of Public Utilities.
Thank you most kindly, Honourable Speaker. Honourable Speaker, for the purposes of the listening and viewing public, I refer to the question raised by the member for Aruka Lopino, which first asked how many contracts were awarded via the sole select process for MTS during the period April 29, 2025 to present. A total number of 0 contracts were awarded via the sole select process. 0. I also want to point out this was not the practice used when MTS fell under the member for Aruka Lopino and the member for Diego Martin Northeast.
Who was running the canteen?
I will tell you more about that, Prime Minister. The second question, the total number of contracts awarded and the dollar value. The total number of contracts awarded for the period under review are 620 projects in the sum of $120,285,307.41, VAT exclusive. The other part of the question asks the names of entities, companies, or individuals who were awarded contracts. Mr. Speaker, I advise and confirm that all contractors were selected using the same method of engagement that have been applied over the past 10 years under the People's National Movement administration. Further, Mr. Speaker, those contractors came from the OPR list. But I want to assure the national community that no member of the government and their family received any contract, as opposed to what happened when my friends opposite wing government. Mr. Speaker, you will be surprised to know that down to the canteens in the school, you know, the member for Barataria, San Juan, used to tell us how much you're going to eat. but there was eating plenty, real plenty, Mr. Speaker, in MTS. And if they ask more questions, Mr. Speaker, I warn them, be careful of the answers.
Speaker. Mr. Speaker, supplemental question to the Minister of Public Utilities. Question number C, the sub-question number C, Minister. The names and the entities, the individuals who awarded the contracts.
Mr. Speaker, Mr. Speaker, I don't think the honourable member was listening when I said those contractors came from the list provided by the OPR.
Very much, Mr. Speaker. Supplemental question to the Minister. Minister, do you have the names, the entities, and the individuals who awarded the contract? I understand the answer you are putting forward that they were from an approved list from the OPR. The question or the supplemental question is, do you have the names and the entities?
Minister, are you able to supply that now for economy of time? Because there are 7 minutes left on question time. So it's a matter.
Mr. Speaker, I answered the question.
Thank you. Mr. Caesar, 12. West.
Deeply grateful, please, Mr. Speaker. Question number 14 to the Minister of Sports and Youth Affairs.
Minister of Sport.
Thank you, Mr. Speaker. Mr. Speaker, the Ministry of Sport and Youth Affairs, through the Urban Development Corporation of Trinidad and Tobago Limited, UDCOT, continues to take active steps to ensure that the necessary works at the Laventille Community Swimming Pool are completed in a timely and efficient manner. UDCOT has provided the Ministry with an estimated breakdown of works for completion of the Laventille Community Swimming Pool. However, funds will need to be identified in order to facilitate timely scheduling. The Ministry remains committed to working closely with UDCOT to ensure that the Laventille Community Swimming Pool is restored and made available to the residents of Laventille as soon as possible.
Laventille West.
Deeply grateful, Mr. Speaker. Can the Honourable Minister, in light of the Honourable Minister's response, can the Honourable Minister indicate what are the estimated works to be carried out?
Minister.
Mr. Speaker, the Ministry received a breakdown of the works, variation works, on the 10th of November. And as I said to the Minister, we are working closely to complete the works. These works should be completed by the end of the second quarter of the financial year, between January to March.
Laventille West.
Deeply grateful, Mr. Speaker. Honourable Minister, can you indicate the quantum or the estimated cost of these works to be carried out within the second quarter, please?
Speaker, through you, Mr. Speaker, the estimated cost of the works is $90,000.
Member for Diego Martin. Oh. No. Why is the authorization? All right. I'm going to give leave for Aruka Lopino to ask the question number 15, filed on behalf of the member of Diego Martin West.
Thank you very much, Mr. Speaker. Mr. Speaker, with your approval, may I pose question number 15 to the Minister of Sport and Youth Affairs.
Minister.
Mr. Speaker, between January to March, a contract a lot of workers, 141 employees were employed for intake of the Civilian Conservation Corps. However, no cohort was enrolled, so they were serving ghosts. They then further renewed the contracts from the 1st of April to the 30th of June, a next 3-month contract. No cohort was enrolled. So there were 114 employees sat there serving ghosts. But, Mr. Speaker, the Trinidad and Tobago Gazette number 81 dated May the 23rd, 2025 assigned responsibility of the Civilian Conservation Corps to the Ministry of Defense with effect from May the 12th, 2025. This assignment remains under the amended schedule of the Ministry of Defense by Trinidad and Tobago Gazette number 146 dated October the 4th, 2025. As a consequence, Mr. Speaker, the Minister of Sport and Youth Affairs is unable to provide any response to the question.
Roodal.
Thank you very much, Mr. Speaker. Mr. Speaker, question number 17 to the Minister of Sports and Youth Affairs on behalf of the Member of Parliament for Digo Martin West.
Minister of Sport.
Again, Mr. Speaker, again, the Trinidad and Tobago Gazette dated May the 23rd, 2025 assigned responsibility of the MILAT-led Academy Training Program, the military training program, to the Minister of Defense with effect from May the 12th, 2025. This assignment remains under the amended schedule of the Minister of Defense by the Trinidad and Tobago Gazette number 146 dated October the 4th, 2025. And as a consequence, the Minister of Sport and Youth Affairs is unable to indicate when the next intake of the MILAT students would be enrolled.
Thank you very much, Mr. Speaker. Mr. Speaker, and to the Minister and the Member of Parliament for La Hoqueta Talparo. Minister, these questions were posed via questions and notice. Did you consult with the Minister of Defense to respond to these questions and these matters?
Not permissible. That's not permissible, and any event time is up. The 40 minutes allotted to question time is up. Your reference to Standing Order 2910. Questions on the order paper for oral answer which remain outstanding at the expiration of 40 minutes shall be answered in writing by the minister to whom the question was addressed, who shall immediately pass copies, and I think we're all familiar with it. So we will employ that process in order not to take up too much time.
May I draw your attention to Standing Order 2910 that allows the opposition, the member of the House, to serve notice that the unanswered question in the order paper may signify to the clerk at the table his desire to postpone the question to a later sitting. And I wish to issue the notice that I desire for those questions to be postponed to a later sitting.
Permitted that had you not skipped over the operative words here. However, at any time before the expiration of question time, before the expiration, it's here. This cacophony of objection that I'm hearing today, this is in the standing order. It says, however, at any time before the expiration of question time, a member having an unanswered question on the order paper may signify to the clerk at the table his desire to postpone the question to a later sitting. But you don't lose any advantage. All that it tells you is that the question is then converted to one in writing, in any event which I have the jurisdiction to do, and gives you a more fulsome answer in any event. So you don't lose any. you're not, let me put it this way, you're not put at a disadvantage. All right? So time's up. I'm sorry. Mr. Caesar.
Mr. Speaker, point of order.
Yes.
Under Standing Order 32, I raised a matter of privilege with you. Thank you.
Privilege.
I have received 3 matters of privilege raised by the members in order in which I received them for Aruka Lupino, Diego Martin Northeast, and Couva South. I received those matters, some of them at 1 o'clock, 2 of them at 1, the last 2 at 1, and 1 at 11, after 11 this morning. Those I have not had time to consider. I will defer my decision on whether or not it meets the threshold for leave at a later date.
Public business, government business bills, second reading.
Honorable Attorney General.
Mr. Speaker, I beg to move that a bill entitled An Act to Establish the Offense of Home Invasion, and in that context, to provide that a person has no duty to retreat when acting in self-defense or defense of his property, to provide that a person may use defensive force, including deadly force, to protect himself, his property, or another person in his dwelling house, and to provide for related matters, be now read a second time. Mr. Speaker, I'm not sure, but there's a lot of crosstalk and noise. A cacophony of noise. I'm not sure what is going on. I'm not as easily distracted as some of my shallow members, friends on the other side, but still I am. If I may be allowed to read my contribution. Mr. Speaker, I beg to move that this bill, an act to establish the offense of home invasion, and in that context, to provide that a person has no duty to retreat when acting in self-defense or defense of his property, to provide that a person may use defensive force, including deadly force, to protect himself, his property, or another person in his dwelling house, and to provide for related matters be now read a second time. The citizens whom this government represents have long been clamoring for protection from criminals who every day defile the sanctity of their homes, invading, killing, beating, robbing, violating, and traumatizing individuals and entire families. Over the past decade, when my colleagues opposite were in power, home invasions became so pervasive in our society that ordinary citizens across the country were left feeling terrified and jaded by the horror stories which were frequently reported in the media. Home invasions in Trinidad and Tobago are typically for the purpose of and/or result in other serious crimes such as murders, crimes against the person, burglaries, and robberies. Yet there is no actual criminal offense or categorization of crime for the home invasion itself. This is a matter that has been addressed in many territories, Ireland, Canada, many of the federated states, and territories in Australia. For a number of years, serious crime, that is serious crime now, has been recorded by and analyzed by the Crime and Problem Analysis Branch of the Trinidad and Tobago Police Service, CAPA, and also reported, taken up in the statistics provided by the Central Statistics Office. There's a document which they produced, Population, Social, and Vital Statistics in respect of the period 1975 to 2022. And in that official report, on the total number of serious crimes reported to the police between 1975 and 2022, there's an 8-year period from 2015 to 2022, in respect of which a provisional record of reported murders rose from 420 in 2015 to 605 in 2022. By 2024, the figure was 624. That is an indictment that shall live in history around their necks. In another report titled Crime Rate Statistics for 2015 to 2024, the authors found that the rate of serious crime in a population of 100,000 had increased during the period from 2015 to 2024. In 2015, the rate was 825.0 per 100,000 individuals. Over the period, the figure rose to close to 1,000 per 100,000 individuals. Mr. Speaker, that is a serious problem and a serious indictment on them all, especially those of them who held office in the Ministry of National Security. The state of crime and criminality in this country was, for us, untenable. It was left to fester for a decade by my friends opposite. This government promised to deal head-on with crime. From the root causes to the manifestations of it, and we are not afraid to deal with gang-related crime, gang leaders, and the perpetrators and bullies who have terrorized this country for the last 10 years without check. We have taken decisive action in the interest of all of our people to disrupt the relationship between gang leaders and their troops. And Mr. Speaker, that initiative has borne fruit. The figures disclose that. As we are all aware, solving the problem of crime is not a quick fix. There is no single magic pill to cure this problem. It requires a concerted, consistent, strategic approach that empowers and equips the protective services to interdict and arrest criminals. It requires us simultaneously to ensure that the justice system is fully functional and brings criminals to justice in the shortest possible time. And it empowers citizens to protect themselves, to feel safer in their homes. The bill which we bring to this House today deals with the latter. The essence of the bill is to allow citizens to defend themselves and their property by using deadly force, if necessary, when their place of abode is invaded by criminals. In so doing, we ensure that we protect those citizens who are faced with the kinds of horrific situations that we all pray as individuals never to befall us. The government intends to protect these citizens in a number of ways. One of which is the tabling and the laying and tabling of the legislation that is before us. Another of which is to ensure that those citizens who qualify are able to get licensed firearms commensurate with the threat to their persons, their families, and their friends. Practically all of the members on the front bench opposite have not one, not two, not three, sometimes 4 and 5 firearms. Oh, yes. Yet they tell ordinary citizens, none for you, and they get to the point where they have to donate to the police. They have to donate to the police weapons which are of dubious legality. Mr. Speaker, when we speak of home invasions in narrative terms, the fact is that it is not up to now by itself a prosecutable offense in and of itself. Housebreaking is an offense, burglary is an offense, robbery is an offense, but home invasion is not. My friends opposite cared so little about the citizens that voted for them in the first place that little or nothing has been done by way of the drafting of sound legislation to add protections to our citizens from criminals for an entire decade. And that provides the context for the reform which we seek this afternoon. In the lead up to the general election, we promised that we would bring this legislation to Parliament, and today we fulfill that promise. Mr. Speaker, if you look at the bill, philosophically, it is based on a long-established maxim that a man's home is his castle. There's a rule that stems from Symon's case. It's a 17th century English decision, which establishes that there's an exception to the legal duty to retreat from an attacker. The doctrine is that a lawful occupant of a dwelling house has the right to use necessary force, including deadly force, against an invader. This is what we are now doing, without retreating from that individual, if the occupier reasonably believes that the invader would commit an offense against him or others in the dwelling house. In considering this piece of legislation, questions arose as to the sufficiency of the doctrine at common law in present circumstances. For Trinidad and Tobago, the question was whether the doctrine should be reformed and how should home invasion be addressed. I referred those questions to the Law Reform Commission of Trinidad and Tobago after the Prime Minister directed me to do so, to develop a policy position for our country. And I am pleased to see that the Commission conceived of recommendations and a bill that was accepted by this government, well suited to our criminal justice system, is now before us. In its policy paper, the Law Reform Commission, the policy paper is titled Protection Against Home Invasion in Trinidad and Tobago, an examination of Stand Your Ground and other self-defense laws. The Commission found that the act of home invasion was not specifically criminalized, as I mentioned earlier, and that the Castle Doctrine, while it remains relevant, required clarity in terms of its application in our modern society. We proceeded on a series of public consultation exercises. Those were done by the Law Reform Commission and members of the government. I believe that the opposition may have done some of these consultations as well. It is my understanding that the Commission focused on the sufficiency of existing law to address home invasion. This involved determining the key elements of the activity, how they differed from acts such as trespass, forcible entry, forcible detainer, which activities are already regulated by legislation, but which does not expressly include or could be reasonably inferred to include the key elements of home invasion. The Commission drew upon the various local and international media reports, studies of incidents in Trinidad, generalized elements of home invasion. They also looked at legislative precedents throughout the Commonwealth and in certain parts of the United States. They came up with a series of proposals with respect to home invasion itself. Number one, they said a physical intrusion into a specific class of premises used primarily for domestic living, for varying individual and family arrangements, that should be the center of their attention. The intrusion, we said earlier, a physical intrusion, the intrusion into the premises should be, the focus should be, the method of entry would, in Trinidad and Tobago, often involve deceptive entry, as in the case of 6 persons who pretended to be police officers recently in November the 5th, 2025 in Siparia. And they said, alternatively, they may physically force entry, they may use surveillance to gain access, they may disable alarm systems, or use a combination of those tactics. Those who resist may or may not succeed in stopping or driving away their attackers. There may be individuals known or unknown to the invader inside the premises at the time of the intrusion. Mr. Speaker, only just last week, a senior government official was robbed at a home in Belmont in front of an elderly person and child. That experience was reported in the Trinidad Express 4 or 5 days ago, on the 21st of November 2025. The invader's approach often involves physical assaults, threats, intimidation of the occupants. The invader uses these actions to command, overpower, and diminish resistance from those individuals. The invader intends to use the opportunity of the successful intrusion to commit crime, including appropriation of property, crimes against the person, and so on. Finally, sometimes other acts, intentional or not, lead to the death of occupants. Murder or manslaughter are all too common during home invasions. The cases are numerous, the stories horrifying, and the traumas to families and communities can last a lifetime. Mr. Speaker, these features distinguish home invasion as a different type of activity from others explicitly criminalized in Trinidad and Tobago. The Commission's findings were partly guided by its study of local conditions, international scholarship, and by comparative assessments of legal developments in other common law jurisdictions. They looked at the Federated States of Australia, they looked at Canada, they looked at England, Wales, Ireland, and specific states in the United States. The stand your ground doctrine, which they came up with, is a unique and evolved legal doctrine that reflects elements of America's early jurisprudence, constitutional law, and social history. It's not the same as the English castle doctrine. That's evident by the rulings of the early American courts. English common law required a duty to retreat and gave priority to patriarchy in property rights. There was a duty to protect one's family and self-preservation. The Americans were different, and their position was also influenced by the proliferation of firearms to defend occupiers. Now I turn now to the recommendations of the Law Reform Commission. Bearing in mind the factors that I outlined earlier and the evolution of the law across the Commonwealth, the Commission recognized that reform was imperative and that the law should be modernized. They made the following recommendations. 1, codification of the Castle Doctrine to complement the current legal framework of the criminal justice system. 2, specific criminalization of the act of home invasion. 3, specific creation of 2 statutory defenses to the act of home invasion. First, relating to self-defense and defense of another against a home invader. And the second, which is slightly new, relating to the defense of property against a home invader. Now I'll turn quickly to a summary of the bill. It's only 9 clauses in length. The bill interpolates the Commission's recommendation. In crafting certain sections of the bill, the Commission drew upon the Criminal Code, RSC 1985 of Canada, the Criminal Code Compilation Act of Western Australia, Criminal Law Consolidation Act of South Australia, Criminal Act of Queensland, Australia, Criminal Law Defence and Dwelling Act 2011 of Ireland, the Criminal Justice and Immigration Act 2008 of the United Kingdom, and mutatis mutandis, they looked at the provisions in the Florida Statute, Chapter 776 of the State of Florida. The bill targets criminals by making them criminally liable for invading the homes of others by creating the offense of home invasion. At the same time, where home invasion arises, the bill provides occupiers with 2 new statutory defenses, the defense of person and the defense of property. The use of the defense is subject to safeguards to prevent misuse and to ensure protection of the law and due process. This empowers law-abiding citizens who lawfully occupy dwelling houses to stand their ground to defend themselves, others, and their property. The offense of home invasion, in brief, is the unlawful entry into, this is what is contained in the Act, the unlawful entry into a dwelling house with intent to use or threaten force. It may involve the use of weapons, firearms, or explosives. The offense will cover acts such as injury, grievous bodily harm, grievous sexual assault, rape, death, theft, or other property damage. But the offense is aggravated in the law, which I hope that you've read, by factors such as gang involvement, involvement in organized crime, invasion in the presence of children, senior citizens, persons with disabilities, or vulnerable persons. Regarding the defense of the person or self-defense, the occupier would have no obligation to retreat. He may stand his ground and use defensive force, including deadly force, if he genuinely believes it is necessary to prevent imminent death, serious bodily harm, grievous sexual assault, rape, or the commission of a serious offense. When assessing the occupier's honest belief, the court would evaluate the reasonableness of his response based on factors such as the nature of the threat, the weapons involved, the relationship history, and whether his response to the threat was proportional. In terms of the defense of property, the occupier may use force to prevent entry, remove an invader, protect their property from threat or damage, stop a criminal offense from being committed inside the dwelling house. The bill states that the use of deadly force would be justified if it is reasonably necessary to remove an intruder or to safeguard property. In relation to both defenses, the bill also provides that a person assisting an occupier in good faith, the Good Samaritan, may use the same degree of force as the occupier. To prevent abuse of the measure, the bill provides that the defenses would not be valid if, one, the individual against whom the force is used has a right to be in the dwelling, the force used against the invader is grossly disproportionate, the occupier had been engaged in criminal activity, or an individual is a law enforcement officer lawfully executing duties, and the occupier knew or should have known at the time that that was so. Mr. Speaker, the bill is 9 clauses long, and I think I have given an overview of it. If I can just be permitted, Mr. Speaker, to say a few words to some of my colleagues opposite, and in particular to the member for Ruka Lopino. And in the context of self-defense, of course, I noted that the member, the good member, said publicly yesterday at a press conference that he was not afraid of the UNC. Now, I hear my colleagues saying the UNC is not afraid of him as well. But I want to assure him that this bill provides for self-defense, and he should not be afraid of anyone. But it reminded me, Mr. Speaker, I have a young son, and when he was 4 years old, he would tell me, I think perhaps on the first occasion when I tried to turn off the light when he was about to go to sleep, he said, you know, Dad, I'm not afraid of the dark. He was terrified. But I went close to the switch and I said, you know, I need a night light for him. So I didn't turn on his, I left him with the light on that night. Of course, after that I got a night light for him. And I just want to tell the member that I have night lights. His face reminded me, because there was some terror in that face when he said, I'm not afraid of the UNC.
Terrified.
But I have a night light for him, and I will share it with him. I still have it. Okay? Mr. Speaker, and on a personal note, I've never been referred to the Privileges Committee. I've been here since 2003. And I welcome my visit to the Privileges Committee, if so be it, because I wish to face my accuser and explain the truth behind it. Mr. Speaker,
That should be explosive.
With those few words, Mr. Speaker, I beg to move.
Honourable members, I shall now propose the question for debate. The question is that a bill entitled An Act to Establish the Offence of Home Invasion, and in that context, to provide that a person has no duty to retreat when acting in self-defence or defence of his property, to provide that a person may use defensive force, including deadly force, to protect himself, his property, or another person in his dwelling house, and to provide for related matters, be now read a second time. Member for Port of Spain South.
Mr. Speaker, in answer to the Honourable Attorney General's last segue and utterances, we say on this side, yea, though we walk through any valley, any shadow, we fear no evil, because we are comforted by the rod and the staff. That's our side. Mr. Speaker, as I enter this debate, any life lost is sad. But any innocent life taken on a mistaken belief that a person is a criminal or has criminal intent, that is a travesty of justice. In this life, it's not a dress rehearsal. This is life. And for that deceased, there's no return. There's no jury. There is no opportunity to present his or her defense. And what about the person who actually does the act? What about that trauma? This is not, Mr. Speaker, a situation where a person has an opportunity to apply for bail if he falls afoul of this law, to present his defense, to say it was a mistake. This is what happened to Maria Florida Rios Perez, a mother of 4, who innocently found herself going to a wrong home to say she was about to clean it. She was killed. There is no return. She's dead. That is the mischief of this bill, Mr. Speaker. There is a problem, and we admit that there's a problem. Crime and the protection of property and persons' personal security is a problem. But this bill is not the solution. This bill is a disproportionate, lazy, populist policy from an indolent and lazy, incompetent government who does not want to do the hard work. It is the bill and it is the piece of legislation of an administration who I say is hell-bent on destroying the very fabric of this society called Trinidad and Tobago, where we say that every creed and race must find an equal place. This bill is a floating jurisprudential fig leaf, Mr. Speaker. It is vague, it is obscure, and it offends the principle of legal certainty. Before we examine this bill, and I want to take the time for the public and examine this bill clause by clause in detail to show what we say is egregious about this bill. This bill cannot be taken in isolation, Mr. Speaker. You like to say context. I would like to take this bill in the context of the actions of this government since they assumed office in April 2025. It is critical as we debate this bill that we see a government and we understand that this government simply cannot be trusted. And on this side, as the representative for Port of Spain South, who I am hearing the cries of the constituents who have elected me here every single day, we say that they are targeted certain segments of this society. Third, and the example I give to you, and I put this bill into context, Mr. Speaker, 35,000 jobs, CPEP and URP lost. That is a target of this government, of people in this society. The cancelling, Mr. Speaker, of the Independence Parade on one day, whilst they pamper, set and parade themselves.
The Speaker, please, 48-1. We are dealing with home invasion here, and he's speaking about Independence Parade.
Yes, what is saying, let's skip along.
Mr. Speaker, I will slowly do what I have to do today. The cancelling of that parade one day and the pamper setting at the Taruba Stadium the next day on the guise of
Mr.
protection.
Speaker, 48-1.
It's irrelevant. Come on. I've politely told you to skip along. What I really meant to say was, look, let's get to the relevant part of the bill.
I heard thing about night life, I heard thing about gangs, and nobody said anything. But you tell me to skip along? I'm not skipping. I'm slowly riding. Yes, that's what I said, fat boy. That's what I said, fat boy. Mr. Speaker, this bill is no different. This bill is no different from the attacks of this government on people who are expressing their views on social media when they won this election purely on social media. So, in the examination of this bill, we say it is not just about property. It is about trust. It is about justice. It is about fairness. And it is about a society at work which we say is under attack. The government seeks to pass this bill that gives citizens the right to use potentially deadly force against anyone who they perceive to be a home invader with no duty to retreat. That is the essence of the bill. It is against this backdrop that we on this side would want to examine this bill clause by clause to identify the mischief, to identify what we see is the undermining effect of our societal norms and values by this very pernicious bill. It purports to protect homeowners, but it creates far more dangers than it resolves. It undermines the Constitution, it invites vigilante justice, it threatens vulnerable persons, and it endangers all citizens of Trinidad and Tobago. The opposition supports firm action against violent criminals, and we understand what is being faced. But, Mr. Speaker, a law designed to protect citizens must never put innocent persons at risk. It must not override constitutional rights that are guaranteed unnecessarily. It must not create more opportunities for bloodshed inside the very homes it is claiming to protect. Let me now do a clause by clause, Mr. Speaker, a clause by clause on this bill to show and to support the point I am making. The Honorable Attorney General did not condescend to a clause by clause, but I will do that because I think it's necessary that the population understands what is going on. Mr. Speaker, I start with clause 3, the interpretation section of this bill. The definitions are everything in law because a definition tells you what you're working with. And clause 3 exposes the true danger of this bill. Dwelling house and curtilage. It says that the bill says that a home includes yards, garages, driveways, shared hallways, temporary structures, even boats or vehicles used as homes. If someone enters these spaces, the occupant may just legally use deadly force. Think about it, Mr. Speaker. A dispute between tenants may end up in a potentially deadly situation. Mr. Speaker, a confused elderly neighbor, as happened in Tobago.
Correct.
As happened in Tobago. All now are ripe for potentially lethal encounters. Let us go to Home Invader and see what Home Invader says. A home invader, according to the definition of this bill, means a person who knowingly enters or remains at a dwelling house in which he is not an occupant with the intention to carry out a home invasion. Mr. Speaker, when this definition is taken at its face value, it broadly describes anyone. It could be a guest who refuses to leave, a tenant in a landlord-tenant dispute, a person entering by mistake, even someone, Mr. Speaker, seeking shelter. This is the mischief of this bill. In other words, if we are correct, ordinary social life is being equated with violent crime. Someone presenting those Watchtower magazines, Mr. Speaker, what happens then? Mr. Speaker, this bill is pernicious and it has far-reaching consequences. Let us look at the definition of occupant, Mr. Speaker. May I take you respectfully for that? Occupant, everyone from owners to tenants and family members to employees, visitors and caregivers may now use deadly force. That is not the Good Samaritan principle, Mr. Speaker. That is opening up deadly force to anyone and all and sundry. And we say that's the danger of this bill. Clause 4, stand your ground. And I don't want to misquote it, Mr. Speaker. Mr. Speaker, may I allow to, thank you kindly. Stand your ground, clause 4. This clause removes the duty to retreat. Even if you can walk away safely, you are now legally allowed to escalate a confrontation. Is that the society that we wish to create in Trinidad and Tobago? International studies are clear. The Honorable Attorney General read the law reform report. What about the international studies that says that stand your ground laws increases fatal encounters? They do not prevent them. Do we want to increase fatal encounters in Trinidad and Tobago as a solution to crime? Clause 5 creates the offense of home invasion and penalties. Home invasion now includes entering unlawfully and staying after the invitation is withdrawn. If for the season we can afford alcohol, Mr. Speaker, and you parang the wrong house, you know what happens? Stand your ground. Stand your ground. Don't do it again. Using or threatening force, inflicting injury, stealing, or destroying property. Mr. Speaker, how could stealing have a consequence of death? How? In what society that respects human dignity could stealing have the consequence of death? Penalties are draconian. 20 years for a basic offense, and we understand 25 years if the offense is aggravated. But the fly in the ointment is that even if there is no intent to kill, there is still this penalty. And now I want to use my experience as a criminal attorney to give the public a warning about the perniciousness of this act. Do not trust this government and what they sell you. When you examine this bill alongside the real estate of our justice system, a chilling reality emerges, because members and citizens of Trinidad and Tobago, this bill does not allow you to use it and kill someone and escape the scrutiny of the courts, You still have to go through the judicial system. So let's examine that step by step. It does not take away the oversight of the court. And what it does is it widens the scope to those who can use violent force like ordinary citizens. But an ordinary citizen having the belief, so we flip the bill and we understand. So we're not talking about the invader, we are talking about the citizen in the home who has used what they consider lawful force, might end up being an accused in a courthouse for murder. What happens then? Our current judicial system, we cannot bury our heads in the sand, means that for murder, what does bail say, Mr. Speaker? Only in exceptional circumstances are you allowed to obtain bail for murder. So you say you're using stand your ground, so you're emboldened. You went, you qualify for your firearm. It's now liberal, the system is liberal. You use it, yes? You now kill someone you say was invading your home, but you're before the courts, Mr. Speaker. The first thing, if you're charged with murder, no bail, unless it's exceptional circumstances. But let's see how long your case will take to come up. They haven't created a special court like as was done in Hines and the Queen in Jamaica. They didn't do that. And even if a special court is created for this, that will create inequality of treatment for others who are awaiting murder trials for over 15 years. So that's not a solution. So you're before the court. And what that means in practice is that someone who may have made an honest mistake could find themselves relying on this piece of legislation, charged for murder, being denied bail, and remaining on remand in custody for over 10 to 15 years. I have not heard anyone, I've not heard the Honorable Attorney General address that issue. What about the chronic backlog in the court cases? Even with a jipper, this cannot be cured. Under this bill, pardon? Under this bill, Mr. Speaker, even if the person is acting in self-defense, public of Trinidad and Tobago, do not be fooled by the hype of this government. They fool you all once in April. Don't be fooled in November. You end up before the courts, having to face murder charge, pay proper defense attorney to raise a defense, and you say, I was standing my ground. Correct? The bill would exponentially increase the number of serious charges with no bail awaiting long periods of trial. Mr. Speaker, ordinary people could now face life or death consequences for mistake, misunderstanding in simple disputes. And that is the point I wish to make. I will no longer gild the lily. I will move on. Clause 6, home invasion. Clause 6 of this bill seeks to create a new offense called home invasion with severe penalties, culminating in the death penalty for loss of life during the offense or during the commission. On paper, it may appear to be a response to an increase in home invasions. But, Mr. Speaker, let us be clear. The problem in Trinidad and Tobago is not the absence of laws. It is the failure to enforce them properly. And that is what a PNM government did by amending the Miscellaneous Criminal Justice Act, appointing not just 3, but 13 criminal masters to speed up the process. That is what we did. Because we understood that there was a need to increase the capacity in the criminal justice system. Having one courthouse, a full courthouse designated for criminal matters, including virtual hearings and VAC centers. We already have a robust criminal law under the common law. Sections of the Criminal Offences Act addresses burglary, armed robbery, trespass, grievous bodily harm. Sections of the Offences Against the Person Act criminalizes assault, sexual offences, and murder, and the firearm legislation strictly governs the possession and use of deadly weapons. These laws that exist now provide sufficient tools for law enforcement to protect citizens. This is not legislation, but this is implementation, it is policing, it is judicial follow-through, it is using a system with some vigor, what we have. Yet, Clause 6 does not address enforcement. It radically expands criminal liability, criminalizing ordinary scenarios that previously would never have been considered an offense. What about a tenant refusing to leave during a lease dispute, holding over? What happens to a tenant at will? A tenant at will now can be killed. That's what happens to a tenant at will. A confused, vulnerable guest, a family member or a child who lingers into a common space, because common spaces are now defined, Mr. Speaker. The bill conflates every domestic situation with the potential of a violent home invasion. Under Section 4, offenders can face murder charges and death penalty even where there is no intent to kill or to do grievous bodily harm. This bill must be rejected. It is to be rejected, Mr. Speaker, because it is, in our view, it is draconian, it is disproportionate, it is dangerous, and most importantly, in the delicate balance that is Trinidad and Tobago, it is socially reckless. We say it will not make homes safer. What will it do? It will encourage the use of lethal force in trivial situations. It will exacerbate domestic disputes. It will undermine the public trust in law enforcement, and it will most importantly put vulnerable members and segments of this society at risk, including the elderly, children, and most importantly, persons with mental illnesses in Trinidad and Tobago. The reality is that law-abiding citizens already are at risk, not because the laws are absent, but because enforcement is not as it should be. Yet data shows, for example, let us look at the detection rate. Let's do some science. The Trinidad and Tobago Police Force data shows that detection rates for burglary stand at 15%. Introducing radically expanded definitions and extreme penalties will not solve that. It will not increase that rate. It will create more violence inside the homes. Mr. Speaker, the opposition does not oppose effective measures against violent intrusion. But Clause 6, as is drafted, is not a solution. It is a danger. A danger. And we say that it ought to be rejected. Let me go now to Clause 7. Mr. Speaker, much of what I have to say about Clause 7 applies mutatis mutandis to Clause 8, because they are different attaches, but it's the same principle that applies. So let us look at Clause 7, that of self-defense. Mr. Speaker, on its face, Clause 7 appears empowering, but upon closer examination of this clause, it raises profound questions about consistency, fairness, and practicality. Let us begin by reading into the record the government's own wording of Clause 7. Clause 7 states that an occupant has no duty to retreat and has the right to stand his ground against a home invader and use or threaten to use defensive force. That is the starting point. No duty to retreat. The occupant must stand his ground, act instinctively, act immediately, act under pressure. But then, Mr. Speaker, when we turn to clause 7.2, this is where the contradiction emerges, because although the government said there's no duty to retreat at clause 7.1, 7.2 subsection K requires the court to consider where there was a possibility that the occupant could have safely retreated. In other words, when the occupant in the heat of the moment says, I am relying on stand your ground because I have no duty to retreat, the court, in analyzing the situation at the end of the day as the ultimate arbiter, will consider and will have to consider under 7.2K whether there was a possibility of the occupant to retreat. So on the one hand, subsection 1 tells an occupant, you need not retreat, stand your ground. But on the other hand, subsection 2, subsection K says, after someone is injured or killed, the court is asked to evaluate whether the occupant should have retreated. Whether or not the occupant should have retreated, how does that bring back to life? How does that resuscitate the dead? Let us say that there was a ground for retreat, and the court held there's a reason. What happens to the family of that person who will now have to deal with, well, you know, the perpetrator, the homeowner, the person who is claiming under this bill could have retreated? What does that mean in a society of Trinidad and Tobago for the family? Where is their recourse in this bill? Where is their recourse? How are citizens meant to reconcile these two instructions in real time? Are you supposed to consider, well, I shall retreat, but you know if I don't retreat, the court will consider if I have to retreat? That is the real-time assessment of these two incompatible clauses, Mr. Speaker. Mr. Speaker, clause 7.1 imagines a scenario of intense pressure. As Justice Volney used to say, in that split second, anything can happen. But juxtapose 7.1 and 7.2, when the court must examine up to 14 separate factors. Mr. Speaker, with the greatest of respect, here is what the court has to look at on one of the factors: the nature of the threat, the imminence of force, the availability of alternative responses, the weapons, age, gender, mental health, prior history. When a homeowner, when a person claiming self-defense is acting under the Dutch courage of stand your ground, bear in mind that a court, even if you don't consider it citizens of Trinidad and Tobago, a court will consider all these things and weigh up your actions in this context. Mr. Speaker, with the greatest of respect, how can any citizen in the dark of night, awoken from sleep, possibly contemplate all these 14 factors which the court must contemplate? Even a trained police officer, like the member for Tunapuna, honorable member, who boasted, do not process that thought process in the heat of the moment. So I concede some considerations can indeed arise naturally or instinctively, but not all, Mr. Speaker. And that is why we say that the introduction of this bill needs to be, there needs to be a retreat. There needs to be a retreat. And retreat doesn't mean defeat, you know. All retreat means is you're giving sober consideration, Honorable Attorney General. Therefore, the factors in 7.2G, the court also considers prior threats, past incidents, domestic violence orders. Those may be rapidly and reasonably contemplated. But are we expecting a homeowner to consider age, gender, physical capacity to assess the threat? These things, people of Trinidad and Tobago, under this legislation is going to happen in real time. And the point I am trying to make is that these clauses are not have no sibling in a real-time event. They are post-incident judicial analysis, which the occupier or the person under threat ought to consider before acting, and it's precisely my point. Clause 7.2 is not asking occupants to do these things. It is asking the court to do it after the act, Mr. Speaker. How is that reconciled? I don't know. And not just do it, but after someone is seriously injured, as a young teenager Yal was, or killed, as Flores was. Let us be honest. You are giving citizens the legal and moral permission to carry out violent action, potentially deadly action, solely based on an immediate subjective point, but you're not telling them about the dangers. Mr. Speaker, I now go to the clause. Mr. Speaker, may I ask for my additional 15 minutes, please? Mr. Speaker, clause 8, no duty to retreat as it relates to property. It gives an occupant an absolute discretion to use and threaten force. Mr. Speaker, here is my problem with this. While defending property against a criminal offense is a laudable goal, ordinary disputes for property that arises, misunderstandings or mistakes, can be interpreted as home invasion. And people can be targeted unnecessarily and unfairly. But here is my main concern about this bill. Since when in Trinidad and Tobago we have equated property with life? When did that happen? When did we descend into that abyss? That you say, well, I defended my property, I kill you. When did that happen? I understand self-protection. That's one thing. Have we descended Trinidad and Tobago to a place where you say, in defense of my property, I'm allowed to take your life? That is a mischief that cannot be cured. And it is, I say, it's unpardonable. The broader implications, Mr. Speaker, it is unprecedented in Trinidad and Tobago and our legal traditions that has always prioritized life over property. And this clause is dangerous in every aspect of its incarnation. The broader implications, Mr. Speaker. Taken together, Clause 8 expands the use of force beyond self-defense into preemptive and retaliatory strikes. It legalizes vigilantism. It encourages the escalation of domestic dispute, and it places a very heavy burden on the judiciary to go back in time and interpret Section 7.2 K and G in a way that you give the homeowner the right to say, I want to stand my ground. Section 8, in removing the duty to retreat, tends to give people what I consider, Mr. Speaker, Dutch courage. 8.1 gives the occupant no duty to retreat and permits them to stand their ground and use violent force. But, Mr. Speaker, what happens now is that persons can use this section, to my mind, disproportionately. And what it does, Mr. Speaker, we say not only does it encourage vigilantism, it is not a safe piece of legislation, and it is not justified in a society that recognizes the mores and rights of our Constitution. Mr. Speaker, I go to Clause 9, assisting the occupant. Mr. Speaker, I now address a troubling provision in this bill that allows any person, not just an occupant, to intervene in a so-called home invasion and use the same degree of force as the occupant. Mr. Speaker, I know you recall the case of transferred malice. What does this do? So an occupant who has a guess, the guest can extrapolate a risk and use the same force as the owner whose life is perceived to be at risk? How could this bill make any sense to right-thinking citizens of Trinidad and Tobago? This is not a minor detail, you know. It is a fundamental shift, and one that turns private citizens into armed enforcers and private homes into zones of violence. We, on this side, we oppose this in the strongest terms. It expands lethal force beyond trained occupants, opening the way for grudges to come forward, opening the way for vigilante justice, Mr. Speaker, opening the way for arbitrary actions which take people's lives. And I go back, Trinidad and Tobago. Life is not a dress rehearsal, you know. Whatever your life view is, this is life, you know. When the person dies on this sphere, they're dead. It drastically increases the risk of wrongful killings and tragic mistakes, and it authorizes in a way that we say that is not justifiable the use of force. What happens to a wrong address, a panic guess, mistaken identity, vulnerable people, tenants, restaurants, domestic workers, the elderly? They all become at risk because of this clause. We say that it undermines the rule of law, due process, and the constitutional protections that are enshrined in our laws. It normalizes violence by giving a legal owner and some occupant, an arbitrary occupant, a cover for armed intervention, and it promotes shoot first, ask questions later. This bill and this clause does not preserve our homes. It transforms our homes into potential crime scenes, and it labels it self-defense. If the government was truly interested in safeguarding households, then it will concentrate on law enforcement, timely justice, and beef up crime prevention instead of doing what is being done now. And I therefore urge this House to reject this clause in its entirety. Clause 10, the exception. Mr. Speaker, how much more time do I have? Just asking. Thank you, Mr. Speaker. Clause 10, the exception. I now turn to that clause, which sets out the exceptions under which self-defense and stand your ground provisions do not apply. On the face of it, clause 10 seems to offer safeguards, but Mr. Speaker, the so-called safeguards are inadequate, and we say illusory at worst. They do little to neutralize the dangers embodied throughout sections 7 and 8. The phrase grossly disproportionate force, it is too vague, and in any event, it is too late. Who will consider this grossly disproportionate force in the heat of the moment? Seriously, Mr. Speaker, are we serious? Section 10b says the defense fails where the degree of force used by the occupant is grossly disproportionate. But what constitutes grossly disproportionate? The bill does not define it. The court will have to look at all the circumstances. I suppose they will have to examine the factors under 7(2) K and G and say, well, they're grossly disproportionate. My point is, though, does the homeowner in real time have that latitude? And the answer is no. And similar views, that's why we said, and I said in opening, that this law offends the concept of legal certainty. In short, grossly proportionate is an after-fact filter, and it is not a preventative check for the unjustifiable loss of life in this country, particularly if I link it and I juxtapose it to the concept of defending property. When did property equate itself to life, though? When did that happen? I missed something. Or is it April 28th? Subsection 10, C, D, and E disclaim protection when the occupant is engaged in criminal activity. This is standard and it's necessary. But the danger emerges from the earlier clauses. The bill defines home invader extremely broad and allows the use of force even against persons whose presence was previously lawful, Mr. Speaker. And that is the beef that we have with the broad tenets of this bill. Mr. Speaker, Section 10(3) deals with mental impairment and intoxication, limited and reactive. It's not preventative. Section 10(f) excludes protection of any occupant using force while substantially affected by voluntary consumption of drug or alcohol. While commendable, it only addresses one narrow risk. It ignores the widespread risk of mental illness and genuine misperception, panic, gender bias, racial bias, social bias. None of that is addressed by this piece of legislation. In a split second, all of these factors could be taken into account. That is why we say this bill ought to be rejected. Mr. Speaker, the bill expands the definition of dwelling and associated places. It allows defense of property and removes the duty to retreat. What we would want to advance here, Mr. Speaker, is that the common law seems to be very adequate as it stands now, or better equipped to deal with the situation or the dangers that the government says pose at this time. This bill fails to prevent murders based on misperception, fear, and prejudice. And prejudice is something that we must address in Trinidad and Tobago, Mr. Speaker, because we live in a land that prejudice, unlike any other country, prejudice exists. The use of deadly force to protect property. I still can't wrap my head around that. The violent escalation of domestic disputes, tenancy conflicts, mental health crises, innocent mistake, erosion of constitutional protection for life and security. If this House and if this government is serious about protecting its citizens, not to empower them to kill under suspicion, then Section 10 is not enough, and they ought to reconsider Section 7 and particularly Section 8. I went through the sections, Mr. Speaker, to show the dangers that have been created with this piece of legislation. After careful consideration of this bill, along with the definitions and powers that they create, I submit to this House that this bill is not a safeguard for citizens. It's a dangerous license for lethal force and unnecessary violence. It buys and it ties right into the psychology of violence, Mr. Speaker. The bill, by giving wide discretionary powers to individuals to use deadly force, often based on fear or suspicion or misperception, undermines the rule of law. It erodes trust in justice and runs the risk of turning our homes, neighborhoods, societies, and communities into scenes and into abysses of violence. Simple misunderstandings will now be escalated into lethal situations. For these reasons, and for these reasons, the opposition submits that this bill ought to be rejected in its current form. If this government truly wants to protect persons from violent intrusions, there's a safer, more just way to do that. We advance a solution. Preserve the existing criminal laws based burglary, assault, trespass, offenses against the Persons, Firearms Act. Strengthen law enforcement and policing. Improve prevention of crime and social investment in the society. The social investment and the erosion of, Mr. Speaker, that is why I was thunderstruck by the objection taken by the Honourable Member for Oropouche East. The erosion of people's jobs creates a society that is unjust. And they can't live it down, not even Mr. Collateral Damage. Craft legislation that is narrowly calibrated to protect life and not property. Craft legislation directed to protect life. Don't equate property with a life. And finally, Mr. Speaker, I would want to say reasonableness and proportionality is absent from this bill. Anything less than that is a surrender of public safety and a betrayal of justice. It's a danger to innocent lives, and it's a betrayal of the people of Trinidad and Tobago and our way of life as a country in Trinidad and Tobago. When one segment feels disenfranchised, the whole country suffers, Mr. Speaker, because we all have to live on this rock called Trinidad and Tobago. With these few words, I make my contribution, and we reject this bill in its current form. Thank you, Mr. Speaker.
Randy.
Mr. Speaker, let me start where my learned friend left off, where one section of the society feels disenfranchised. The whole society suffers. The whole society and a great deal of law-abiding citizens have been disenfranchised in their own homes in the last 10 years. So, who is he speaking about being disenfranchised? Because it obviously has to be the criminal class. And I realize that my learned friend left his criminal defense attorney lawyer hat. Well, he should have left it. But he walked over with his criminal defense attorney lawyer hat from the court and brought it here. And what I find disturbing is when my learned friend made the reference saying that this bill targets the constituents of Port of Spain South. What is he saying? What is he saying? I'm on my legs.
You said it.
You said it. Yes. Yes.
Oh. Remember, he didn't actually say that. So clarify that.
Yes. How does the bill target the constituents of Port of Spain South? And what, hold on, and what I find...
To the honourable member, like he's stick breaking his ear?
Port of Spain South.
My apologies.
All right. Okay. Member for Toko Sagre Grande, I don't recall a member saying that. If you wrote it down, that's a matter for you.
Mr. Speaker, and what I found really disturbing is that my learned friend spent much of his contribution talking about constitutional rights. And whose constitutional rights he was referring to? I have to ask. No, I have to pause at this juncture to pay homage to the members of the Law Reform Commission for the excellent and scholastic job they've done. And this, what they have done, and much of the bill, and my learned friend ended by conceding it, that much of the bill, much of what you see here in this bill is the common law. That's what it is, the common law. So what the Law Reform Commission did is they brought the different parts of the common law that are applicable, and they've made it relevant to home invasions. That is what occurred. So I don't know what all the big song and dance is about,
and that the population should be afraid of us. Because what we've done is we've brought the existing common law and codified it into statute. Much of what you see here already exists. And the beauty of it, of codification, is this. As it stands now, before this bill is passed, the ordinary citizen does not know what his rights are when he's faced with a bandit at 2 o'clock in the morning in his house. The ordinary citizen does not know where to find the law on self-defense. Today I realize that even some lawyers don't. You have to go to Privy Council judgments, you have to go to judgments of the Court of Appeal, make sure that they are not conflicting with each other, and you have to basically understand what the common law is. The ordinary citizen does not have the wherewithal or the time or the expertise to do that. What this bill does is to codify much of the existing common law. And all of the complaints my friend made about much of this is after the fact. This bill, in essence, codifies and makes easy reference for members of the public, law-abiding members of the public, to know in advance, first of all, that the law of necessary self-defense as contained in this statute is there to protect the law-abiding, not as my learned friend has said. So the first thing is, my learned friend tried to attack the concept of duty to retreat. The common law says, in essence, you do not have a duty to retreat. That's the first thing the common law says. The second thing is that I don't have to wait for you to strike first. If you are in my house, and I make this point with reference to what my learned friend said about property. If you are in my house at 2 a.m. in the dark with you and your friends, should I wait to see whether you are here to steal property alone? Yeah. Or should I wait to see whether you are here to rape my daughter who you may have been looking at? Or whether you are going to kill me because I identified you? No, that is not how the law works. And all of the complaints my learned friend made, we are in essence saying there is a presumption of legality. We are saying, in essence, that if you come into my house at 2 a.m. and you are armed and I am outnumbered and I get the opportunity, and the common law says that, once I have the opportunity to strike you, I don't have to wait. Unlike what some people think, your back, if the bandit's back is turned but he's still in my house at 2 a.m., what should I do? Wait for him to turn back around? Figure out if he's a dwen? That's my opportunity, and the common law says, and this law says, that I, in the circumstances, can protect myself and my family. And remember, Mr. Speaker, as I stand up to address this House, my mind goes back to a constituent I met very early in my tenure. This lady lived in what they call unplanned communities, squatting lands, that has no electricity. And she was the victim of a home invasion. Her daughter was raped. And as a result of that, her daughter is now a shadow of herself. The daughter is now a mental patient as a result. So what is my learned friend suggesting? And he comes up with all of these, he conjectures, all of these hypotheses. What if it's a neighbor? What if it's a child? And what his whole contribution was what if. And he has no client to defend here. It's one thing, Mr. Speaker, if you have written instructions from a client who already committed an offense and is telling you, I was in this house for this reason or that reason or the other reason, and you are advancing his defense in court. But our clients here today are the law-abiding citizens of Trinidad and Tobago. So much of what my learned friend came here to say today was about what if and what if and what if. In essence, making up instructions in what is not a court of law. We are here to strengthen the law so that we protect the innocent who have a constitutional right to property that he doesn't seem to know or value, who has a constitutional right to security of the person so that they are not raped and robbed, who has a constitutional right to life. And we've seen home invasions in this country where persons were raped, there was robbery, they were wounded, and there were instances of death. What should we do? But he ended his contribution by saying, you know what? We in the PNM are offering solutions. Now, I want to know why he didn't offer these solutions in the last 10 years. They always have solutions after the fact. He did nothing in the last 10 years. He said it was disproportionate. He said it offends the principle of legal certainty, which it does not, because a citizen can go up online and pull this up and now have certainty as to what the true legal position is and what he is allowed to do in a home invasion, whereas he couldn't do that before. Now, I want to deal with what he called Clause 7, and he deals in essence with the law of self-defense. Now, a lot of what my learned friend from Port of Spain South said was not accurate. Well, most, or not even half of the most, as my friend would say. And he says in essence that a homeowner should be afraid because that homeowner could turn around and be charged with murder, and that the offense here, section, he made reference to the section, which in essence is existing felony murder. It simply codifies it. So the same scare tactics he uses to frighten the home invader and say this bill doesn't protect you, in fact it does. Because he says, what if it's a child? Or what if it's a neighbor? Or what if it's a dispute? All of these are answered in the factors listed out. What I have in here is 6.1, he said it's 7.1. It says, subject to section 9, an occupant has no duty to retreat. And the population must know that when a man is in your house, and this bill, let me make it clear, is self-defense, necessary self-defense in the context of a home invasion. It is not self-defense in the context of Juve mourning or self-defense in the context of something happening on Frederick Street and somebody snatch your purse. This is self-defense in the context of home invasion, in your castle, in your home. And I don't know what my learned friend wants when somebody is in your home. So it says, you have no duty to retreat. It says, and in determining defensive force and how you use defensive force, you have a right to stand your ground and use or threaten to use defensive force against the home invader where the occupant honestly believes that that imminent threat is there. Yes, he's about to be harmed, that his life or the life of another person was in immediate danger or threat of danger. What is wrong with that? And that is already the common law. So I don't know what his complaint was about. He has no duty to retreat if he believes that his actions were necessary and reasonable to defend or protect himself or another person in the course of that home invasion. He has no duty to retreat if he believes that the defensive force used was proportionate and to the threat he honestly believed to exist. But my learned friend said, in essence, it was disproportionate. And he made reference to a number of things being disproportionate, but I want to know this. How is 20 years disproportionate to a man who comes into your house looking to rape, rob, and possibly kill? How is that disproportionate? What does he want? 5 years? And to come back again and rape and rob again? It is very proportionate to the very real threat that persons continue to face. So you're on this occasion, because my little friend has said nothing, he talked a lot of nothing. On this occasion, we have to know whether they on that side are on the side of law and order and protecting citizens, or whether they are on the side of the criminal class. Let me read from the bill so that we demystify what he has said. When determining whether defensive force was reasonable, the court shall take into account the nature of the threat or force, the extent to which the force was imminent. So if they are outside running away, then the threat is not imminent. The bill pulls out all of what is contained in all of the major common law cases and spells it out here for you. Whether there were other means available to respond to the potential use of force, that is here. The role of the occupant. Let me answer him when he said, what if it's a child? Look, it's right here in the bill. The size of the home invader, the age of the home invader, the gender of the home invader, the apparent physical capabilities, and so on. So if it's a child, and you are like me, 240 pounds, and it's a, and well, San Fernando, he says 340 pounds. If it's a child, and you see that it's a child, 2 o'clock in the morning, then of course in that situation, the law does not permit you to pull out your licensed firearm and shoot the child. That's right here. So that all of these scare tactics that my friends sought to raise, all of that is answered right here in the bill, if he bothered to read it. History, whether there was a domestic violence history, the nature, duration, and history of any relationship between the parties. So if it's a landlord-tenant situation, then obviously he didn't come here to rob. He come in to say, well, listen, I'm a tenant at will, and so on. The law, this law, as my learned friend seems to suggest, does not say, well, your neighbor come, he's a tenant at will, and he come in your yard, you can pull out your gun and shoot him down. The law does not say that. The law makes it very clear that they look at the nature and history of the parties to the incident, whether there was any prior use of force, whether there were any protection orders under the Domestic Violence Act, history of interaction or communication between the parties, the proportionality of your response. So it says, in essence, that if the so-called tenant, he says, who's a tenant at will, if he's 80 years old with a walking stick and say, well, you can't throw me out on my lass, you cannot come now and take a pickaxe and start to beat the man to death and say, well, you're in my yard. No, you can't. Because this very law says you can't. So everything my learned friend has said is rebutted by simply reading the law. Is it proportional for an old man neighbor, tenant at will, shaking with his walking stick, coming in to dispute the tenancy? Is it proportionate to take a pickaxe and beat him until he leaves and next thing he's dead? That's right here in the bill, it says no. The law looks at mistaken belief. Beckford and the Queen comes to mind. Whether there was a possibility that you could safely retreat. So my friend is saying it creates a zone of violence. No, if there really is a duty to retreat, an opportunity to retreat so that you don't have to escalate it, then you can. Again, this law does not seek to create violence, it seeks to protect the law-abiding citizens in very dangerous situations. Right. Right here again, so that the public knows that my learned friend was engaging in scare tactics. That having regard, the court shall take into account, having regard to the circumstances, an occupant acting for a legitimate purpose may not be able to weigh to a precise degree, the common law says may not be able to weigh to a nicety, he may not be able to weigh to a precise degree the exact measure of any necessary action he has to take. And it says in essence whether he honestly and instinctively thought it was necessary for a legitimate purpose and any other compelling factors. So, Mr. Speaker, all of this is the common law. The common law has always said that, in essence, one, when you are under attack, and in this case, let me go again, 2 o'clock in the morning, the bandit have a gun in his hand, and he turn his back. Some people like to say, well, his back was turned, you should not shoot him. The law has always said, and thankfully it's codified here, that you don't have to wait for him to strike first. You don't have to wait. You don't have to, the court is not going to hold you to account to say in that situation, you know what you should have do? You should have wait and see what you do. That has never been the law, and it's here now. The law says when you are in that situation, you are entitled to act to repel that home invader and to repel him if need be, if necessary, right here again in clause, if necessary with deadly force. And once, looking back at it, it was proportionate. Once the bandit had cutlass and you pull out your licensed firearm, it's proportionate. What the law says in essence, if it's 3 little 12-year-old boys and all they have basically is metric rulers and stuff like that, you can't pull out your matic and lick them down. You cannot. So all of that is captured here. So I don't know what my learned friend was seeking to signal. Set of scare tactics. And let me go back. It makes it again clear the boundaries within which this operates. That is why the definition section makes reference to curtilage, whether it is the property you are seeking to defend is surrounded by a fence or not, or a natural boundary or not, or a combination of both, and so on. Once it's not a public place, it says in essence what deadly force is. Deadly force, according to the bill, is legitimate in keeping with the common law, and it says any force, deadly force means any use of force that is likely to cause or creates a substantial risk of causing death or grievous bodily harm. And defensive force means the justifiable and reasonable use of force by a person acting in self-defense. I have to commend this bill to you, Mr. Speaker. I have to commend it because it codifies all of the concepts of reasonableness. It codifies all of the concepts of proportionality, and these two concepts of reasonableness and proportionality are addressed squarely in the bill and with a great degree of certitude. So the public is not in any way misguided as to what their true Now, I heard, but my friend might say I misheard. And I want to answer, it does not remove the duty to retreat. I just read it here. In the whole list of factors, you have no duty to retreat. But right in the factors the court would take into account, the court would look at it and say, if in the circumstances there was an opportunity to retreat, to not escalate violence, then the court would look at that as a factor to determine whether you were honest in your statement that you were defending yourself. Because, again, by example, if the man is running away, the threat is no longer live, then why are you escalating the situation? You are no longer in harm's way. So, in essence, there's still not a duty, but the court looks, in essence, that whether there was an opportunity to retreat. And all of these factors are factors the court, not only the court looks into it, the investigators, the director of public prosecutions would have to look into it. And if looking into it, he sees that there was no need for you to use violence, then that is a safeguard, and the police and the DPP would act. Once you act unreasonably, and that has always been the law, if you act reasonably, honestly, and with proportion, with a degree of proportion, then you are always protected by the common law, and now you are certainly protected by this bill. Now, yes. Now, Mr. Speaker, I have done, like my friend, I don't think he's done much criminal cases in the last few years. He's not much of a civil lawyer. But what one must take account of, since people are saying Trinidad and the Caribbean is a zone of peace, one simply has to read the CARICOM impacts report, and Trinidad, which is part of CARICOM, in essence is not a zone of peace. We have one of the highest murder rates in the world. One need only look at the statistics with respect to home invasions, which are on the rise. And this, we say, is a very good solution. Because what we are doing, we are laying the groundwork at this juncture, and very soon, as the Attorney General has said, we are going to equip the citizens with what some on the other side have 3 and 4 or 5. The citizens are going to be equipped. We in this country have to look at how other first world systems operate and how they protect. One has to look at the fact that only 15% or so of home invasions are solved. What does that say about us? On the one hand, you are complaining about how long it takes when you are inside, but on the other hand, 50 out of 100 are caught. That must be cause for concern, and it is our responsibility as a government to seek to protect all of our citizens who are subjected to these sorts of things. And it is a misconception to think that home invasions happen only in middle class and upper middle class and rich areas. Because right in places in the constituency of Toko Sandy Grande, I can make reference to places like Tattoo Trace, Brabande, and all of these places. You can make reference to these places, and there are quite a number of places in these large squatting communities where home invasions are a real thing and happen with regularity, so much so that the bulk of persons do not even bother to report it because they feel, and they might be justified in saying, so if detection rate is only 15%, then what are the chances? So a responsible government has to look at the laws and to see how the laws can protect the victim, see how the laws can protect the citizen. And this is what this bill does. This bill does not seek to protect the rights of the bandit class. This bill seeks to strike fear into the minds and hearts of the bandits. The bandits must know when they come into your house, and very soon we will give the citizens the tools. The bandits must know once they come into your house that there might be a chance, a real chance, that they might not be going out. The bandits must know it's better to, and the homeowner must know that it's better to be judged by 12 if it comes to that than be carried by 6. The bandit must know when he comes in with firepower that your firepower will be matched. The bandit must know that the citizen is protected by this law so that when he goes in, he may not come out. And that is the type of deterrent that we as a government have to provide. As my friend from Tunapuna says, they must know flowers bring in slow singing. They must know that on the night they come into your house to rob and rape and steal, that in a few days, that their parents might be singing a Jim Reeves song, a Rock of Ages. But what we cannot do, and what they are suggesting, what we cannot do is come here, sit on our hands, and do nothing. That would be irresponsible. So I don't need to go too much into what my learned friend from Port of Spain South has said, because he has said very little. I think the intention was to take up 45 minutes of saying practically nothing. When you read the bill, every single issue, without fail, every single issue is right here in the bill. All of the what if this happened and what if that happened is right here in the bill. Everything is addressed comprehensively by the work of the Law Reform Commission. So that there's nothing to be concerned about, and you have to show the public, we all have to collectively show the public that we are here about protecting the law-abiding and dealing with the criminal class. So I call on my friends on the opposite side to stand up and stop engaging in scare tactics. So I want to deal with two last bits, because as I said, there's not much more to say.
Do you wish your 15 minutes?
Not all of it, but yes, please. Some of it.
Okay, go ahead.
Yes, please. My learned friend from Port of Spain South made reference to what is in essence murder felony. And this part says, where a person kills or is party to the killing of another in the course of carrying out the offense of home invasion, he and any other person engaged in the course of furtherance of the commission of that offense is liable to be convicted of murder. I have to ask, Mr. Speaker, what is wrong with that? If during the course of a home invasion you kill an occupant, should you not be liable for murder and the consequences that go with it? What is my learned friend really saying? But what my learned friend did not say, in essence, is that this really deals with what they call felony murder, which is already Section 2A of the Criminal Law Act as passed in this House in 1997. To bring back what is called felony murder, and contrary to what my learned friend is saying, the penalty here, whilst you are liable to be convicted for murder and with a penalty of death, there is still a discretion in the court. The death penalty here would be discretionary. We have also taken note of the fact that, like one of my constituents, who is now, as I said, a shell of herself and a mental patient as a result of being raped in a home invasion, we have also taken account and created an aggravated form of home invasion. So that if you commit a home invasion as a gang member in organized criminal activity, or you commit it in the presence of a child who is likely to be traumatized for life, or a senior citizen, or a disabled person, or an otherwise vulnerable person, the penalty is increased to 25 years. So we have added that extra deterrent. Now, my learned friend says, in essence, that we should not equate property with life. I don't know what the complaint is, but my learned friend needs to read the legislation, and of course there's a dichotomy. And of course, the law says, in essence, the type of force you can use to defend someone other than yourself. And it makes a distinction. In fact, it spells it out, what are the factors that are taken into account and what you are allowed to do when it's defense of property. And a big song and dance was made about defense of another. From my recollection, I don't want to misquote the case, but Mr. Speaker, I know that you are a very seasoned, probably almost decorated appellate lawyer, but the case subject to correction is Williams and the Queen on defense of another. So my learned friend from Port of Spain South was making a big song and dance about saying that you are, why are you bringing this piece of legislation that you are not defending yourself, you might be defending someone else. What sense does it make? If someone is in your home, you invite someone in your home, and someone enters your home to kill that person or to harm that person, what is my learned friend saying? That you should just stand up and watch? And my learned friend cannot be saying that because Williams and the Queen, from my recollection, doesn't say that either. Williams and the Queen is common law and says you are entitled to act in defense of that other person, and you are entitled to use deadly force in defense of that person if it is reasonably necessary and if you honestly believe that the person may suffer death as a result of the attack. So, when we included such a clause here, it was simply to be wholesome and to cover all of what the common law has already provided. So I have to close at this point, Mr. Speaker, by saying I commend this bill to all of Trinidad and Tobago. Maybe it's a little late. They had their, I don't know what they call that. I followed, I think it was probably one or two consultations. And the consultation seemed to center around, I don't know, it didn't seem to center around the victim, the law-abiding. Again, it was a series of what-ifs. So I have to hope that my friends on the other side would do as their own constituents want, because many of their constituents are victims of home invasions. So you have to do the responsible thing and put your stamp of approval to a law that gives protection to the citizen so that when things happen in their house at 2 a.m., that they are not the ones who are being carried by six. We have to act in a manner that is responsible so that we offer protection, legal protection, being prospective, looking forward, telling citizens that these are your rights, these are your responsibilities, this is what the law allows in such situations, and this is how you are entitled to respond in such situations, rather than leaving the citizen to guess as to what their true rights and responsibilities are when they are faced in that situation. And knowing that it is now firmly embedded in statute that you have no duty to retreat, that you can stand your ground, and that the law will not expect you to wait to a nicety the exact measure of your response, that you are entitled to respond once you honestly believe that you are under attack, and that you are entitled to use whatever force you deem necessary in that situation. Because obviously, the court is not going to hold you to their own standard, because the court was not in the situation. The court was not there 2 a.m. in the morning and would say, well, he should have done something differently. The court is going to take into account, as this bill recommends, the court is going to take into account the level of anxiety and stress that you are under, knowing that your children could be raped, robbed, and possibly killed. And the law is going to allow you prospectively to deal with it as you see fit, once you honestly and reasonably act in a manner that is proportionate. And the law is going to protect you. Mr. Speaker, with those few words, I beg.
Member from Port of Spain South, I recognize you, but as you're aware, the tea break is 6 minutes away. I don't know whether you would prefer to start now and come back, or whether we take the tea break now and you start after the tea break.
Mr. Speaker, it may be more useful to take the break now.
Yes, very well. So we take the break and we'll come back the usual 5:15. Sitting is suspended until 5:15. Thank you very much.
The Honorable, the Speaker.
Waterspain North.
Thank you very much, Mr. Speaker. Mr. Speaker, I appreciate the opportunity to join this evening's debate, and in particular, to bring the truth to the debate and to set out for the population exactly what has been put before this House in terms of proposed legislation in the form of a bill. The first point that I'd like to make, Mr. Speaker, is that as the member for Port of Spain North St. Anne's West, and as with all of the members on the opposition side, we are not only acutely aware, we are deeply concerned as citizens with the state of crime, the levels of crime, and what is being experienced in Trinidad and Tobago. That is not unique to Trinidad and Tobago, but it is something that all of our law-abiding citizens are concerned about. How is it that crime, and in particular violent crime, affects the citizens of Trinidad and Tobago? But as someone who believes in due process, someone who believes deeply in the entrenched provisions of the Constitution and the importance of our constitutional rights, we on this side are always cautious to ensure that law that is being proposed is proportional. Law that is being proposed, you see, because law is not about smoke and mirrors. Law is not about emotion. Yes, the drafting of law, the genesis of law may come from an emotive place, but when you get down to the brass tacks and the business of developing law, you must extract the emotion. And from the two previous speakers on the other side this afternoon, we had one who was very passionate, but unfortunately, very misleading in his contributions as to what precisely the bill states. And I will get to that in a short while. You see, we must find a balance, and there must be legal and proportionate ways, Mr. Speaker, to address the issue of crime. Thanks. And I'd like to start at the outset by stating, as we heard statistics from one of the previous speakers, and a shallow boast that crime levels are down. Yes, there are certain crime levels that are down, but that is because 9 months of the year, 9 months out of the year of 2025, Trinidad and Tobago would be facing the provisions of states of emergency. In this year alone, we've had 2 states of emergency, one which was recently extended. So to sit here and to listen to false propositions that because something is being done in some different area outside of the provisions of the state of emergency is completely misleading to the population. So we must balance the law, and most importantly, Mr. Speaker, we on this side are very cautious that law-abiding citizens should not be misled, and that the law should not make it more difficult for law-abiding citizens. And despite all that we've heard by those on the other side so far, I will carefully and with focus show how the legislation that has been introduced here this afternoon, the proposed legislation, actually makes it more difficult for people. Because yes, there is an element that is a codification of the law of self-defense. But to hear a proposition by a previous speaker suggesting that, well, we brought law, we bring a bill because what it is doing is making it easier for the layperson to find the law, That is the most ridiculous proposition I've ever heard. But I am not surprised because of where it fell from. The second point is that unfortunately, and it's borne itself out here this afternoon from the utterances of the first speaker, making propositions and suggestions that there is no way legally, and in the full sum of light, it can be fulfilled. And then secondly, unfortunately, from the previous speaker, what we have heard is a repetition of promises as to what the legislation does, but now the legislation is before the House, and it simply does not do 99% of what the member for Toko Sandy Grandi misled the population with here this afternoon. And I am putting the population on notice because they may be fooled. He is a criminal law practitioner, or was, and now he is the Minister of Defense, holding a portfolio of authority to tell anybody that you can shoot a person in the back when their back is turned to you and they are running away, and shoot them before they shoot you, but shoot them in their back, has to be one of the worst pieces of advice that can be given to any law-abiding citizen. So please, through you, Mr. Speaker, all law-abiding citizens, this bill that is before the House today, which is different to the one that they took to public consultation. I had people reaching out to me, even this afternoon, saying, look at Clause 10, and I had to say, hold on, you are obviously looking at the bill that the UNC tried to sell to the population, but did not come to the House with. And they did not inform the population that all of their consultations that they went out there with, today they've come with a different piece of legislation to this House. And the fundamental difference is that they have taken out the provision in the previous utterance, and they have taken out the provision that calls for special majority. They have taken out the provision where they went to the population previously and asked the population to discuss and to consult. They have taken out the provision that requires a special majority. And in that provision, it says they infringe our constitutional rights and our entrenched rights. The question that arises immediately is the questions. One, why are you misleading the population, even in what you've brought, what you went to them with? And secondly, but more importantly, why are you taking out the need for constitutional protection? And they may come here with all sorts of reasons, but those are the first red flags that we face as we look at this legislation here today, Mr. Speaker. We on this side agree that Trinidad and Tobago has absolutely no dedicated law dealing with the crime of home invasion. And that is one of the things this legislation does. But I put forward the proposition to Trinidad and Tobago right here today, Mr. Speaker, as Mr. Speaker himself knows, to create the crime of home invasion, which is a good step and a step in the right direction, creating and codifying a crime of home invasion, which doesn't currently exist, taking it out of common law and making it a crime. You don't require this bill. All you need to do is put that definition, that specific crime, in one of the existing pieces of criminal law legislation. So do not come here today, as you like to do, and try to mislead the population with the bravado. And the irony of starting off the debate in the manner that it started off, talking about firearm ownership and how firearm ownership would help in a situation of home invasion, could not pass. Because the same person talking about that and selling to the population here today, talking about, oh, well, licensed firearm users and persons who will get licensed firearms are better equipped in a situation of home invasion, and standing up here as an invitee on the floor of this House to put forward that proposition in a most, not disparaging way, in a most disrespectful and dangerous manner. I want to remind the population, through you, Mr. Speaker, via an article in the Guardian newspaper on the 15th of June 2020, titled, "Former AG Robbed at Balandra Beach House." Former Attorney General John Jeremie was held up at gunpoint and robbed during an invasion at his beach house in Balandra over the weekend. According to a police report, at about 11 a.m. on Saturday, a gunman entered Jeremie's premises at Toko Road, Pangalas village, and pointed a gun at him, forcing him to comply with the instructions given. Jeremie told police the gunman robbed him of his iPhone, his licensed firearm with ammunition, and $7,000 in cash. Jeremie told police he was not injured during the incident, but was left highly traumatized. The suspect escaped. And to come here this afternoon to tell the population that these 9 clauses will assist in a home invasion, the hypocrisy and the irony does not escape me, and nor will it escape the population. Because the same proposition you're making, if you have a licensed firearm, you will be able to handle a home invasion. He failed. And I am going to point out to the population using facts and studies how dangerous certain elements of this are here this afternoon. Because you see, we are concerned on this side that in the continued smoke and mirrors that takes place with the other side, they must not be looked at. This bill must not be looked at in isolation. Because the promise of firearms to persons who legitimately should and may hold firearms does not fall within the province of the government. But we have learned, especially from that side, that they are willing not to tell the population the truth. The second pillar that they've attached to this piece of legislation is gated communities. And they both speakers this afternoon on that side said that this is not legislation in isolation. We on this side want our citizens protected. All of our citizens. I listened with concern at the previous speaker from Toko Sandy Grandi as he put forward propositions, and he attacked my colleague from Port of Spain South, saying that he is selling the story of one side of society but not a next. I say here categorically this afternoon, and without fear of contradiction, that we on the opposition side are here to protect every member of society, including the vulnerable ones that they mock every single time we come to Parliament. Those 30 and 40,000 workers who are now not employed, the most vulnerable in society, who will not qualify for firearms. But there are those financiers who may. And there is nothing wrong, I say again, if you are qualified and you're legitimate to hold a firearm. But it is not the panacea. And this legislation is far from being an aspirin for a headache. And it would be irresponsible of us on this side, knowing what we do and having studied what we have studied in jurisdictions that have similar legislation, to sit by idly and to allow the emotive conversation taking place at public consultations, which found itself on the Parliament floor this afternoon by the government, to allow that piece of wool to be pulled over the eyes of the population. We will not do so on this side. The responsible public servants in a body called the Law Reform Commission produced a report on stand your ground legislation. Very useful report, because what they did, Mr. Speaker, through you to the population, is they compared legislation that exists in many different jurisdictions around the world. And importantly, they put the pros and the cons. And we've heard this afternoon from previous speakers mention of the castle doctrine versus stand your ground. So I'd like to start there by telling the population, because you see, castle doctrine is a good one, but it exists now. That is the common law now. There is no duty, and I'm telling the population, as it exists now, there is no duty or obligation on a homeowner who he or she or their guests in the lawful occupation or being inside their homes. There is no duty or obligation on you to retreat if armed bandits, armed criminals come into your home and face you down. So as the law currently stands, if you are a licensed firearm owner, and this legislation is not about firearms, because as a homeowner, you have a right to defend yourself and to be misled, the attempts by the other side to mislead the population to say that this legislation now takes away your responsibility or reduces the level that a court would look at you in those circumstances is completely false, because it does the exact opposite, as I'll show in a short while, Mr. Speaker. So just to tell the population, to assist the population, lest they be misled, as happens very frequently, a good comparative note was done by the Law Reform Commission, Mr. Speaker, through you. The castle doctrine and stand your ground laws have been described as, quote, affirmative defenses for individuals charged with criminal homicide. The castle doctrine is a common law doctrine. Common law means it's not codified in statute. And that is what exists here in Trinidad, stating that an individual has no duty to retreat when in his or her home or castle, and may use reasonable force, including deadly force, to defend his or her property, person, or another. Outside of the castle, however, an individual has a duty to retreat if able to do so before using reasonable force. I will show how this legislation here today, so that is the common law that exists. I will show here today, Mr. Speaker, how the legislation that is being introduced actually now puts an obligation on homeowners in circumstances to retreat and puts burdens on them that are different to how the law currently exists. And to sit here and to be misled by the government once again, telling them this law is taking that away and now you could shoot a man in his back 2 o'clock in the morning. And then using playful analogies as though it's a joke we're dealing with here about it is better to go out. It is better to be judged by 12 men than to go out being carried by 6 in a jovial manner. Unfortunately, it is not a joke. And unfortunately, it is very serious, Mr. Speaker. And it goes on in this report to talk about the pros and the cons of stand your ground legislation. Mr. Speaker, I just want to refer to a couple reports and more usefully, a proposition that was put forward to the population by your good self in May of 2023. Very, very useful legal analysis, Mr. Speaker. And it is Stand Your Ground and the Law, written by Mr. Speaker on the 3rd of May 2023. Useful. Within recent times, there's emerged a spirited, if not oftentimes borderline acrimonious public debate on the issue of the right of a homeowner to mount a defense of deadly force in the face of perceived grave, imminent, and perhaps deadly attack. Like a prophet, Mr. Speaker, that is exactly what is taking place here today, 2 years later, plus, in a debate right before your eyes. The need to find a fair and proportionate response to a current and pressing societal problem is indeed both urgent and necessary. While there are good points to be made for the enactment of a special statutory formulation designed to set out exhaustively and preserve the rights of homeowners, perhaps this cause may be better served by a close and thorough examination of the common law of self-defense. Words of caution that could not have come at a better time and are 100% accurate today as we look at legislation before us, proposed legislation, as it was when it was written in May 2023. The author goes on. In this instance, there is no need to proceed on what may amount to be an ill-conceived legislative dash to enact specific provisions which already form part of the common law. And if those on the other side had listened and understood the cautions that were being raised here, we would not be here today looking at a slapdash piece of legislation that actually does the opposite of what they say. This legislation, this proposed legislation, this bill, does the opposite of what those on the other side are telling the population they intend to do. The author goes on, in my respectful view, the common law in relation to self-defense has at its heart the underlying fundamental notions of the stand your ground principle, whilst labeling this discrete principle of common law with a sensational banner is somewhat attractive. It must not be forgotten that the common law of self-defense already offers the same degree of protection to persons and homeowners that a separate stand-your-ground legislative provision would provide. 100% accurate. The common law already does what those on the other side are trying to fool the population about. In short, there is no need for new legislation. What is needed is clear and unmistakable policy guidelines which cover both the investigative and prosecutorial stages of the criminal justice system, with particular sensitivity to the cases involving home invasions. One proviso to what the author said, Mr. Speaker, and I started with it a short while ago. Home invasion as an offense, a criminal offense, does not currently exist in the law. That is the only thing I would add to that. Bring legislation, use legislation to create a specific offense, because the law as it stands now, common law and other pieces of the legislation as set out by the Law Reform Commission provide homeowners with the defense that is necessary. All this bill does is complicate it and add obligations that make it even more difficult for a homeowner in circumstances. And I'd like to put on record, because I'm sure there may be some on the other side who this may have passed over, and not because of their own fault, but because they're obviously being misled by those who should know better. Population of Trinidad and Tobago, there's nothing in this bill, nothing in this bill. If you as a homeowner shoot and kill someone who has entered your premises, there's nothing in this bill that prevents you from being charged for murder. There is nothing in this bill, Mr. Speaker, that prevents that legitimate homeowner with a firearm or using a weapon, a knife, a baseball bat, whatever it is, to defend your own family in your home from going to trial in the criminal courts, being arrested, charged, and then having to face a trial, because all the defenses they say this bill provides, you have to now go into court and convince a judge and a jury that it applies to you. So don't fool the population that there's this piece of legislation that now allows you, as a homeowner, to take another life of a criminal or criminals in your home, and you do not run the risk of being charged and being before the criminal courts and having to go through all of the trials, tribulations, and trauma of a criminal trial and defending your good name after having defended your family in traumatic circumstances. Because you see, the population has been sold and they've been told that this bill somehow miraculously extracts one from that. Mr. Speaker, back to the Stand Your Ground and the law authored in May 2023. Usefully, the law of self-defense is to be found in the advice of the Privy Council given by Lord Morris and Palmer versus R versus the state. In that case, the following principles emerge. And this is the law as it stands. One, a person who is attacked, has every right to defend himself. Force can be met with force. That's the law now. The Privy Council have said that's the law. B, in defending himself, he may do only what is reasonably necessary. This bill, as I'll show in a short while, actually puts additional obligations on you. C, what is reasonably necessary is dependent on the context of the attack. Completely correct. Nothing in this law changes that. So to come here and say about a little child in your house at 2 o'clock in the morning, that is playing on the emotions, that is playing on the heartstrings of the population, but sadly and dishonestly misleading them. D, the retaliation must not be disproportionate to the attack. In other words, you cannot use a hammer to kill a fly. E, if the perceived threat is imminent and grave, then it would be necessary to use such force as is reasonable. F, a person defending himself is not expected to weigh to a nicety of the exact amount of force which is necessary to repel the attack. G, in a moment of unexpected anguish, the response must be judged by what the person thought was sufficient and necessary. Duty to retreat. It seems to be that there's a collective societal misconception that a person under a threat, real or perceived, is under a duty to retreat. That is simply not so, Mr. Speaker. That is what you told the population, and it is correct, 100% correct. So don't come here and say that this bill now takes away an obligation on a duty to retreat, because that doesn't exist in law as it is now. You are entitled to defend your castle. You are entitled to defend your home as it currently stands. This bill does not take you out of a criminal trial and charges of murder or charges of negligence or charges of manslaughter. It simply doesn't. So population, do not be fooled. Mr. Speaker, we then get into the area and the realm which is of concern to us on this side. And in particular, those of us, all of us, who represent constituencies where we don't bury our head in the sand and pretend Trinidad is not a complex society. Trinidad is not a society that's made up of not only different races, different classes, different circumstances. And all of us face that. As a member for Port of Spain, North St. Anne's West, you have some of the wealthiest people in Trinidad and Tobago living in homes and houses in that constituency. And then you have some of the most vulnerable, literally over the ridge of a hill, living in difficult circumstances. And the studies show in other jurisdictions where stand your ground legislation has been introduced, some places for decades, they caution the difficulties that arise and the breaking apart, the further widening of some of these complexities of society that put us at even more risk with a false promise, as we're being told today, of some magical pill, some panacea in this legislation. The first one I'd like to refer to, Mr. Speaker, is from the National Library of Medicine. National Center for Biotechnology Information. An article titled, as a report rather, study, Effects of Laws Expanding Civilian Rights to Use Deadly Force in Self-Defense on Violence and Crime, a systematic review. And it is authored by 1, 2, 3, 4, 5, 6, 7 PhD doctors. Background: since 2025, most US states have expanded civilian rights to use deadly force in self-defense outside the home. In most cases, legislation has included removing the duty to retreat anywhere one may legally be, commonly known as stand your ground laws. The extent to which these laws affect public health and safety is widely debated in public and policy discourse. It goes on at the main results. Yes, please, Mr. Speaker. Mr. Speaker, the 15 minutes start now? Or? Okay, thank you. Main results. We identified 25 studies that estimated population-level impacts of laws expanding civil rights to use deadly force in self-defense, all of which focus on stand your ground and other expansions of self-defense laws in the United States. Importantly, authors' conclusions, Trinidad and Tobago, I beseech you, listen to the authors' conclusions of these experts who have studied stand your ground legislation. The existing evidence contradicts claims that expanding self-defense laws deters violent crime across the United States. Not if you listen to those on the other side, but this is the truth. Everywhere where they've studied stand your ground legislation, they have come to the conclusion that expanding self-defense laws does not deter violent crime. It in fact increases it. They go on to say, in at least some contexts, including Florida, stand your ground laws are associated with increases in violence and this is of particular concern to us on the other side, who are always against this. And there are racial inequities in the application of these laws. We on this side are not burying our heads in the sand. We have looked very closely at the behavior. And we understand what is taking place in society. And we are concerned about how this legislation may affect the racial inequalities in Trinidad and Tobago, as is so nicely put by these people. Public health implications. In some US states, most notably Florida, stand your ground laws may have harmed public health and safety and exacerbated social inequalities. The next article is the dangerous expansion of stand your ground laws and its racial implications by the Duke Center for Firearms Law, authored in January 2022 by Cami Chavis. Recently, there have been several high-profile trials that underscore the intersection of guns and race in America. In Georgia, Greg and Travis McMichael, father and son, and William Rudy Byron stood trial for fatally shooting Ahmaud Arbery, a black man whose race seemed to be the only provocation the three men needed to end his life. Many argue that Arbery had been white. Had he been white, he would never have aroused the suspicions of the McMichaels. Certainly, had the assailants been black, they would have been arrested immediately. The expansion of stand your ground statutes and entrenched gun culture in the United States complicates both of these propositions, and the racial impact of these laws deserves greater attention from policymakers. It goes on to talk about the common law self-defense in the United States, and it says, under the implications of stand your ground laws, evidence suggests that stand your ground laws increases firearm homicides. There are a number of arguments against expanding stand your ground laws. First, these laws encourage people to take the law into their own hands without calling on law enforcement officials who should be skilled at intervening in dangerous situations. The existence of these laws discourages de-escalation and may encourage people to shoot first and ask questions later. That is the reality of what we heard from Toko Sandigrandi a short while ago. Toko Sandigrandi stood here and told the population, shoot the man in the back. And it's not the first time he said it. He said it at public consultations as well. That is proof of what we're being warned about. And I am quickly going to go to the law, Mr. Speaker, to point out that this legislation does not provide you with a defense in such circumstances. The existence of these laws discourages de-escalation and it may encourage people to shoot first and ask questions later. Racial disparities. In addition to the potential increase in firearm homicides in general, there is also evidence that stand-your-ground laws exacerbate racial inequities for both victims of and defendants. In stand-your-ground states, homicides in which white shooters kill black victims are deemed justifiable 5 times more frequently than when the situation is reversed. In Florida, which is considering a repeal of the law was associated with a 45% increase in monthly firearm homicide rates and around a 23% increase among black residents. Caution. Now to get quickly to the legislation in my remaining time, Mr. Speaker. The population should not be fooled by those on the other side. Let me go immediately. The dishonesty, Mr. Speaker. Let's go to self-defense, clause 6. Because self-defense is what we're being told this bill is about. That if somebody comes in your home or you're defending property or that of somebody else, you have the ultimate self-defense. Worry not. The irresponsible utterances of the member of the Fatoko Sandigrandi, the Minister of Defense, shoot them in their back. Others saying, don't worry, we'll give you firearms, you could shoot and kill. Self-defense population. This is what a court will measure in determining whether defensive force used was reasonable in the circumstances. This is what the court has to take into account, Mr. Speaker. Clause 6(2). So immediately, that shows that what we are being told by the government is false. Because a court has to take A all the way to N into account. And let me tell you what the court will take into account, population. The test that the court will still apply in determining whether to uphold your defense plea in a trial. In a trial. So people have invaded your space, you've shot and killed them, or you use their own weapon against them and they're now deceased. You are going to trial, and this is what the court will measure to see if the self-defense under this bill can be used by you. A, the nature of the force or threat, common law. B, the extent to which the use of force was imminent, and, very importantly, whether there were other means available to respond to the potential use of force. Don't come here and mislead the population immediately. We're put on notice. If there were other means available to respond to the potential use of force, the court is going to look at that, and you will not get the benefit of self-defense. Codified here, black and white, but you want to mislead the population. Shoot a man in his back. C, the occupant's role in the incident. D, whether any party to the incident used or threatened to use a weapon, firearm, or explosive device. E, the size, age, gender, and apparent physical capabilities of the parties to the incident. So you can see, population, a test is put forward by the court for the court to apply. Importantly, F, whether any party to the incident is a person with a mental disorder within the meaning of Mental Health Act. So if a person with a mental health disorder comes into your house and you feel threatened, you can't just shoot and kill them. That's not what we're being told here. You go on. G, the nature, duration, and history of any relationship between the parties to the incident, including 1, any prior use or threat of force and the nature of that force or threat, or 2, whether either party ever applied for or obtained an order against the other in accordance with the Domestic Violence Act. So a dispute with your neighbor, all those things are going to be taken into play by the judge. any history, H, of interaction or communication between the parties to the incident. This one is the introduction of a test. I, the nature and proportionality of the occupant's response to the use or threat of force. Mr. Speaker will know, and everyone in this room can read, would understand that means you do not have a carte blanche permission to shoot anybody and kill anybody who comes into your house. Because the court is going to look at the nature and proportionality of the occupant's response to the use or threat of force after it looks at whether there were other means available to respond. J, whether the occupant acted under mistaken belief of imminent threat or use of force and the mistake was a reasonable one to have made. This one, the next one, concerns me in particular. And this is what the population needs to know through you, Mr. Speaker. K, whether there was any possibility that the occupant could have safely retreated. I will read that again because it is obvious that those on the other side are being misled by someone because they have stood here and said you have no duty to retreat. This now introduces on you a duty to retreat that the common law doesn't. Clause 6(2)(k), whether there was a possibility that the occupant could have safely retreated. What clearer language could be used, Mr. Speaker? You now have an obligation to retreat because the court is going to look at it and a judge is going to say, measuring, which hindsight is always difficult, as Mr. Speaker would know, when you're testing what goes on in reality. Because a judge and jury not there at the proverbial 2 a.m. in the morning. But now we're putting into law that a court will look at whether there was a possibility, a possibility that the occupant could have safely retreated. L, having regard to the circumstances, an occupant acting for legitimate purpose may not be able to weigh to a precise degree the exact measure of any necessary action. M, whether the occupant did what he honestly and instinctively thought was necessary for a legitimate purpose. And N, any other compelling factors based on the circumstances of the case, as wide as you can go, Mr. Speaker. So do not come here today, as you have done with your two previous speakers, and attempt to hoodwink the population, to have them believe that this bill now makes it easier for you in circumstances where, God forbid, you face the difficulties, the trauma, and the criminal activity of a home invasion. We cannot sit on this side and allow some irresponsible individuals on the other side, because there is no way all 26 on the other side would support misleading the population. You now have a responsibility to retreat. That is what that clause says. Mr. Speaker, it also goes on, and you know what the irony is? And I suspect when they were passing this, you look at the application of the Act at Section 4, it says, subject to the provisions of this Act, an occupant of a dwelling house has no duty to retreat from a home invader at the dwelling house, right? So that is what could fool people. But then when you get into the test that the court will apply if you have to use self-defense, it is clear there that that obligation is now put on you. Mr. Speaker, this law also now confuses for those persons who live, and many people in Trinidad and Tobago do, in situations where there are common areas, there are no easy demarkable boundaries, where persons live in a property, a dwelling house as it's defined, where there's no gate, there's no fence. For example, in Shafford Court in Port of Spain, North St. Anne's West, St. Francois Plannings in Belmont in my constituency, where it is corridors and staircases that we all have to traverse as common areas. And that applies even to the One Woodbrook places and the other upscale residents that exist throughout Trinidad and Tobago. This law now confuses it as to what the boundaries are when they talk about public places and curtilage. What this is doing is making the application of the law so much more difficult, but more offensively, Mr. Speaker. This is a clear attempt by those on the other side who are using the emotions that we all feel as law-abiding citizens under attacks from criminals. We all feel the threat of. So, Mr. Speaker, for those reasons, and many more that my colleagues who will speak later on after me will highlight and articulate, those are the reasons, Trinidad and Tobago, why we are compelled to say this is bad law and it cannot be supported by us on this side. And furthermore, we would be derelict in our duties if we allowed them to hoodwink the population, to fool the population as to what this legislation really does and really states. I thank you, Mr. Speaker.
All right. Seeing that you found it necessary to cite from an academic publication that I had written, I think it is necessary, without getting into debate, to clarify. You would have noticed, and you made reference to it, that I said in that article that what was needed was a clear policy demarcation, right?
Mr. Speaker, in an attempt to assist you, I would suggest you leave it right alone. Because you...
Right. No, I'm not getting myself in debate. I'm simply pointing. All right, I don't need your assistance, Myro. Neither does St. Augustine. All right, what I was pointing to is 6.2 can be referred to as a portmanteau section. There is no case. I just simply want to make the point, and Port of Spain South would know this. There is no case decided in any court, in any apex court, in any part of the world, that sets out the factors to be considered here. All right? So, insofar as that is concerned, that is the policy aspect that I referred to here. Insofar as the duty to retreat Port of Spain North, it's one factor, right? Let's get the law clear on it. Whether or not you could have retreated, let's get the law clear for the accuracy of the public record. Is but one factor to determine whether or not the force is actually necessary. That's decided in common law, and Port of Spain South knows that. The case is Beckford and the Queen, once you have an honest belief. Okay? Oropuch.
Thank you. Thank you very much. Thank you very much. Thank you. Thank you very much, Mr. Speaker. I need to flip through my notes. I believe you have taken away the first 2 points I was about to make. In response to the last speaker, Mr. Speaker, it is for me a great pleasure and a privilege to speak on this particular matter that is of grave import at a time like this, when this country, after 10 of the worst years in our existence, on April 28, that 10-year plague came to an end. When Trinidad and Tobago placed their faith once again in the caring hands of the Member of Parliament for Siparia and the United National Congress. Mr. Speaker, when the United National Congress took our case to the national community, the electorate, we made certain pledges, promises, which we intend to keep. A fundamental note was the issue of crime, of confronting the criminal elements, of returning the society to some modicum of stability, of progress, but of safety. There can be no progress if you're dead. There can be no prosperity if our human capital flees. There can be no growth if society is wiped out by these elements that have taken over this country. And some of the most heinous demonstrations of brutality that we have seen in recent memory. The Attorney General, in piloting this bill, spoke of the murder rate in 2022 or thereabout. The Attorney General, who by practice occupies a seat in this chamber as a fundamental pillar of a government. He's not to be treated as an invitee, as a guest, as someone who don't belong here. And Senator Jeremie, senior counsel, is himself a man of scholarship, an academic, a practitioner, and has returned to serve his country again as Attorney General. Which is more than we can say about a former Attorney General, Reginald Amo, I think, is a former Attorney General here, who was caught in some type of untruth in a Florida court. And Lord. Yeah. Thank you very much, Mr. Speaker. Well, let me get to Port of Spain North, since I think he's eager for me to focus on him. Mr. Speaker, both of us are attorneys at law. And although executive life did deny me the opportunity for a long-term practice, I think we both have the same track record. I think we share the same track record. And as regrettable as that sounds, Mr. Speaker, there are certain specific issues I would like to raise. But, Mr. Speaker, the gentleman from Port of Spain North St. Anne's West served as this country's Prime Minister. Whether it's for 1 hour or 1 day, whatever. He served this country at the highest executive office and has served, I believe, as Minister in the Office of the Attorney General as well, and other positions and so on. And today, the member for Port of Spain North St. Anne's West spoke about all the academics and the scholars and what they have written and all they have written on this matter and their conclusions and their data and the science and so on this matter of home invasion. But you know, Mr. Speaker, what I want to begin with? I will quote, Mr. Speaker, not from the scientists at this point, we'll get to them later. I'll quote from the ordinary newspaper articles that the people of Trinidad and Tobago suffer. The victims and the families of victims. And if we just go back, and I will begin 7th October 2020. That's 5 years ago. 7th of October 2020. CNC 3. Home invasions on the rise. Then Deputy Commissioner McDonald Jacob confirmed that there has been increased reports of robberies at homes in the last 3 months. Within 48 hours, at least 3 home invasions have been reported, etc., etc. I won't read it at length. Mr. Speaker, and then you go again. 9th January 2023. Home invasions on the rise again. Between 2015 and 2022, there were more than 14,663 burglaries and break-ins in Trinidad and Tobago, and a majority being at dwelling homes. Mr. Speaker, we go again. Preparedness is the key in dealing with home invasions. A story about home invasions becoming popular among criminals in Trinidad and Tobago over the Easter weekend, and we are dealing with 13th April 2023. 2023. We haven't reached 25 yet. Home invasions are popular among criminals. 4 home invasions in various parts of the country over the Easter weekend. Mr. Speaker, we move again. And this is a real story. It's not the scholarship and the academic and the scientists and the PhD. This is the story of Trinidad and Tobago, of victims, Mr. Speaker, and a lengthy story again. Criminals targeting the elderly, deadly home invasions, new TTPS unit making arrest. And this story, Mr. Speaker, is taken from the Trinidad Guardian in 2023. Mr. Speaker, 2023. We go again. Trinidad Guardian, August 2023. Again, a story. Husband fatally shot, protecting wife during home invasion. And I can read the story at length, but there's no need to read that horrible, horrific story that follows about the brutality and killing of a husband in front of his wife who sought to protect his wife during a home invasion. Mr. Speaker, it crawls your blood to even read this and put it on the record that way. Religious leaders call for citizens to, quote unquote, empty the clip on criminals. 2023, 17th August. April 2024, we're coming up. Trini-born Canada resident beaten during home invasion. And this is a dimension that we have not yet placed on the record. That when you have the criminal elements like this operating, home invasions, 4 on the weekend, which tourists visiting relatives who want to come here? Who would want to come here to spend their money to visit sites, to stay at the family home in some cases? When you report this, which is the truth, when it is reported, it has an implication even on the economic well-being of the society, of the country. So Canada resident beaten, Trini-born Canada resident, and that was April 5th, 2024. You come down the road again, Mr. Speaker. August 27th, 2024, woman, son terrorized by 7 bandits in Valsain home invasion. There's a deafening silence opposite. I think they are reflecting. Mr. Speaker, again, on the 7 bandits on the last Monday afternoon stormed the house of a medical professional, Mr. Speaker, terrorized the occupants, Mr. Speaker, and inflicted bodily wounds on a female elderly citizen, Mr. Speaker. Mr. Speaker, next story we have here, Wednesday, 16th October 2024. 2024, bandits dressed as police terrorize Moruga family. Terrorize Moruga family. Mr. Speaker, in home invasion. Mr. Speaker, we come up now to August 2025, and thereabout, Mr. Speaker. Princestown pensioner raped during home invasion. Mr. Speaker, this is the reality. What all the scholars have to say about this? What all the scientists have to say about this? What all the research data say about this? What we should sit down and do nothing. For 10 years, they did nothing. The murder rate hit 624. They did nothing. This was happening in the country. They did nothing. You know, today they have the solutions. Today they come and say, we have the solution. No, you don't need this. You don't need this. We could do something else. What did you do for 10 years? Nothing. Absolutely nothing. We come today with a piece of legislation, and I am shocked that they would not bring one amendment, one new clause. They would not bring any solution, any suggestion, any recommendation. They just say, look, we don't want this. No, this is no good. No, we can't do this, can't do this. Don't do it. Don't do anything so that this situation can continue unabated. That is their position. And Rio Claro man, 80, burnt during home invasion. Mr. Speaker. Mr. Speaker, it goes on and on and on. I have a book here in my hand with all these stories here. Mr. Speaker, I have it here. Mr. Speaker, with this as the background, the member for Siparia took the bold step in an election campaign to speak about stand your ground legislation. And to craft this new criminal offense that deals with this matter. And I'm hearing members on the other side we don't need law, we need to implement law, and so on. But you implemented law for 10 years, what happened? What is the former minister, Hines, I think was his name, was it? Yeah. What did he do? Huh? The sleepy one, yes. And has disappeared. Mr. Speaker, he has gone into some kind of karmic sleep. They won't know about that, but it's a long sleep. He has disappeared, Mr. Speaker, and he cannot be seen. Cannot be heard, Mr. Speaker, and presided with the member for Port of Spain South today, we forgot. He was the Minister of State in the Ministry of then National Security, telling us we have the solution. But they couldn't bring any solution when they were there. And you know, it's easy for the member for Port of Spain North, St. Anne's West to say, remove the emotion. You just heard the headlines I read there. How you read that without emotion? I don't know how you could read that without emotion, but you must be cold, heartless. I mean, you have to be of a different character to say that, you know, you can't feel for that type of story. And when they speak, Mr. Speaker, they tell us this is not, of course, the magic pill, but the Attorney General said that in his opening speech. He said this must go along with other pieces of legislation, other strategies, policies, and so on. But we have to give residents, owners, homeowners, and so on, a chance to defend their property and defend themselves and their family, not only with firearm, with other weapons that may be available. Mr. Speaker, the issue of the constitutionality, I just wanted to make a point that, yes, the Attorney General indicated and has instructed that there was consideration, deep consideration over the constitutionality issue, and it was removed. But you know, I remember in all this discussion, I read something about it as well. Again, no need to read at length. There was a gentleman sitting on this side here, the gentleman. And every time he opened his mouth, it's Suraj, Suraj. It's Surat, and then it changed to Suraj, and then it would have been changed to Hansraj. So he always have. But the point he was making, or trying to make, is that the Privy Council, our law, determined that in moving forward, we can infringe Section 4 rights with a simple majority if it is proportional, if it suits the public interest. And again, there's a long note on this, which maybe later, if I have time, I'll read into the record, that the Attorney General has considered that. So that is anything devilish and mischievous. It is done deliberately. We understand that. We understand that, Mr. Speaker. And the Law Reform Commission, to put on record again, Monday, 18th August 2025, Law Reform Commission endorses Stand Your Ground law. Praising the Law Reform Commission, but forget that they endorse Stand Your Ground law. They endorse that. The Law Reform Commission has argued that despite the Stand Your Ground laws being in contravention of certain parts of the Constitution, the recent rate of crime which seems to persist makes it necessary to establish a law that preserves the lives of law-abiding citizens. And the rush of home invasion across Trinidad and Tobago cannot be taken lightly. The traumatic accounts of being tied up, threatened, beaten by bandits, ransacking their homes for cash and other valuable items, and citizens have also lost their lives in home invasion. And they make the point, which was made before, there are no specific laws to home invasion, and is therefore necessary, as the member for Toko Sandy Grande, in a brilliant address to the House today, I want to compliment him, gave a precise, concise, practical, and comprehensive statement on this law. And he said clearly this is codifying and it seeks protection. There was another contradiction that came out from Port of Spain North, St. Anne's West. He was saying on the one hand, this law is not necessary. And it gives the impression that you could shoot to kill and shoot anybody, and anybody come by the door, shoot them down. And then on the other hand, he says there are parts here that actually places some type of balance on the alleged attacker, that you have to, the famous Section K, that there's a balance that you have to look, and it's not a responsibility per se, it's whether you could have retreated or not. I'm not sure it's a responsibility, but again, the lawyers will argue that, no problem with that. but bring solutions, bring policy change if you want, bring legislative intervention. But you cannot bury your heads in the proverbial sand and say, we will do nothing. We will do nothing. Let the worst continue. Look at another article put on the record, 26 November 2025. That's today, I believe. Is it? Yes. Yeah, 26 November 2025. Trinidad Express today. Victim of home invasion pleads for stand your ground laws. This is today. You telling me about the academic in America 5 years ago. What do you say about it? Look, the victim said, man, bring it. We can't wait. Mr. Speaker, we live in a society where if a mango fall on the galvanized roof outside, you jump. If somebody go in the washroom and slam the seat, you fly up. It is a frightening society. And with home invasion, sometimes you go to sleep, and I will tell you, because you're reading this a lot and you're seeing it and it's the truth, sometimes you dream of a home invasion. You're sleeping and you're thinking somebody outside by the door, and you actually might dream somebody in the yard or at the door, because you are so preoccupied with that and security. Some people have CCTV camera, you know, these screens with about 12, small screen on it. And if one not working, they're paranoid. 11 working, one not working. But they're paranoid about that one block, thinking that somebody could crawl in, stand up there, enter the home in the night, invade. When we were growing up, I remember, our parents would say, Mr. Speaker, come home before it get dark. Meaning 6 o'clock and thereabout and so on. Come home before it get dark. Everybody have been inside. They slam the door. Take the lock and lock the front gate, because we believe that, this home was sacred. But it was a place of safety, that the children and the parents, you were only safe if you were at home. You can't be safe outside. Today, what has happened to that? You're petrified if you're at home, and you are terrified if you're outside. And we must do something. And the government, led by the member for Siparia, has decided to do something in record time. Record time. To come to the parliament. Widespread national consultations took place across the country, Trinidad and Tobago. Policy drafted by the Legislative Review Commission. Bill drafted in record time. In the parliament in record time. Debating, possibly passage. And then we go to implement. But today, what is also amazing is my friends opposite, when they speak, apart from telling us what the scientists say, they come now and say, but what about the maid going by the wrong house? The children come with Halloween basket and they go on by the door. And you didn't expect Halloween night children to come with a basket. And then, what's the next one again? Somebody is mentally challenged and they come by the door. Now, all of those stories we read already in the United States. There are several articles about that. The same Google search you did, we do. So we know of all of that. The maid lady went by the wrong house. And in some of those cases, persons were convicted. They were convicted. In some cases, persons were acquitted. But in some cases, they were convicted. But the law that we are passing today speaks about grossly disproportionate. Grossly disproportionate. And as we said, you can't take the hammer to kill the fly. You can't take the small pin to do the job of a big drill. I think it's a fair analogy. So you have to be proportionate. That's the point I'm making without, getting too much in it. But I think that point is made. Yeah. So, Mr. Speaker, because it will be grossly disproportionate to use a small pen if you require the big bit. So, Mr. Speaker, that is the meaning it is in the legislation. So it still gives you, that emphasis that you have to, is a balancing act, as well as we seek to protect homeowners by changing the law and in some cases codifying the common law. And that is, Mr. Speaker, where we are today. That is where we are today. Mr. Speaker, a couple other points made by colleagues opposite. Slapdash legislation we come here with slapdash. What slapdash legislation? We came with a bill with 9 clauses, Mr. Speaker, well thought out. They have no amendments to offer at all. They're just against everything. They're against everything. Nobody has an amendment here. Mr. Speaker, the other point, I want to put on record now. It is despicable. It is disgraceful. It is unacceptable. It is untenable. All of that is for want of words. That members opposite will take this and somehow inject ethnic and racial connotations to making a law to protect all the citizens of Trinidad and Tobago. Mr. Speaker, it is unbelievable. We all know, we watch TV, the challenges that the American society face managing their diversity and managing serious issues of social class and crime and perceptions and property class against other social classes that is also linked to color. We only know of those challenges, we know. But Mr. Speaker, those cases, generally they're American cases and so on. In Trinidad and Tobago, all citizens are victims of crime, regardless of race, color, creed. They are victims of crime. And I will tell you as well, the perpetrators, they are of every race as well. The attackers will be of every race. There's no one race attacking. Go and see when they charge people, at least from the arrest point of view, member for Tanapuna. It is people of every race, different color. So there's no, I want to tell my friends opposite, particularly my friends to the right of me, many of them are rookie, you know. They now join the campus. And I want to tell them, the attorney, I will follow the footsteps of the Attorney General and I leave you alone. But what I tell you is, please, try not to take advice from those on your right. Try your best. It will lead you in good stead. It will lead you in good stead. It will lead you in good stead. Don't go down that road. You're too young. Don't go down that road. Leave that for young. Mr. Speaker, so we know of those things, you know, dispute with neighbor. The boyfriend came and he doesn't want to leave the house. And you tell him, get out, but you don't want to leave the house, so he's an invader. Okay, we know of all of that, the social realities and so on. How much, really, let me ask you something. Of all the headlines I read earlier, all those headlines I read, I can read more. Which one talk about the boyfriend didn't want to go home? Which one talk about the boy next door came and pick a mango, and we mistake him for something else? While those things happen, you know, in large-scale societies and so on, in Trinidad, what I gave you there was a reality. That was the reality we are confronted with. That is it, Mr. Speaker. So to come here and frighten people that, you know, this thing cannot work and it will not help, and in fact you will be more exposed and vulnerable than you were before, is really, Mr. Speaker, to instill fear in the population of Trinidad and Tobago. And I remember when we were debating, some of us have been on the compound for a long time, when we were debating kidnapping for ransom, which was a big issue in the first decade here, 2008-9, somewhere there. In fact, I think the distinguished Senator Attorney General may have been wrong as well. There were some who said that this will change nothing, and we should do nothing. The police should deal with kidnapping. And after a while, the data suggests that that legislation, which was agreed to between the then government and the then opposition, agreed to, a different type of opposition, a progressive opposition, agreed with the then government. In fact, the member for Siparia was on the opposition, and the senator was the Attorney General of the country. And the member for Siparia was part of a team that negotiated over several pieces of legislation. And we fixed it. It led to a sustained decline, almost eradication of kidnapping for ransom. They don't have that type of maturity, that spirit of patriotism. They don't have that commitment to the public interest. They are discussing, Mr. Speaker, who get robbed, where and how. That is their concern. Mr. Speaker, I just want to go back to the member for Port of Spain South because, Mr. Speaker, the member for Port of Spain South, I was more disappointed in him today than I was before. Every time he speaks, he disappoints me, but today it was worse. Mr. Speaker, a senior counsel like himself, you know, well, I think 3/4 of them is senior counsel. Mr. Speaker, they spoke and he came again to tell us, you know, property. When did we confuse property with life and so on? The member for Toko Sandy Grande pointed out, if you're robbing a bank, in the process of robbing a bank, you're looking for money, you're taking money, the security guard shoots you, you're dead. Property? You didn't go there willfully to kill the manager of the bank or the teller. You went for money. You're robbing. But he made this thing like if it's some new creature we are creating, some new legal character. We are changing, you know, the fundamental and we are revolutionizing our legal principles and so on. Mr. Speaker, people get shot when they're committing robbery. So if someone come in your home, what do? They're with a gun in front of you. Boss, tell me first. You come here for the money or you come here to attack my family? And when we get that clear, then I will know how I respond. That's what we're doing? Yeah. That's what you're doing? Why don't you, when the bandit come, you give them a little box to check out? I am attacking for money. I'm attacking for this. I'm attacking for that. Take off the box. That is where they are carrying this argument. When people come into your home, you have to assume that they come there to do the worst, not the best. And the member for Port of Spain South came with this business, you know, and said that the law was disproportionate, lazy, incompetent. That member was a member, Minister of National Security, talking about competence and incompetence of a government and laziness. He talking about, and they did nothing. When I tell you nothing, you heard of the CCTV cameras and think 40% of them were not working. Yeah, not working when they came in office. Now we are trying to fix it, they bother with that. Mr. Speaker, he went on to talk about the fabric of the society. Well, I don't know what he meant there. The government, and they cannot trust the government. We are 6 months into office, 7 months. He talk about you can't trust the government. 6 months. What is he talking about? What is that about? That is to instill fear in the community. But I want to remind members of the national community that the bill we are dealing with today has a fundamental role in protecting citizens and giving you the right to defend yourself and the protection of the law and the government in doing that. That is the objective of what we are doing today. And you know, I don't know why they are confusing themselves this way. I don't know why some of them getting jittery when we bring laws like this. I don't know why. I can't explain that one, Mr. Speaker. But what I want to tell my friends opposite is, see, in this matter, you either get on the bus or you go under the bus. Yes, thank you. Thank you, Mr. Speaker. Mr. Speaker, again, the member for Port of Spain South telling us that guests don't want to leave the house and so on. Anyway, I dealt with that already. Someone seeking shelter. He said that in the debate, you know. Somebody come into your house 2 o'clock in the morning until it's raining. They come to shelter. You know? Yeah, that is what they are about. And I was shocked. The member for Port of Spain South is at times slightly more prepared. But today, no. He must have been occupied over the last few days. Yes? Yes. Mr. Speaker, the other matter, I made the point already that you can change law and change behavior. We have done it in this society already. We have done it here already because we have passed what to us appeared to be, groundbreaking law. We have passed that. And we have seen changes in human behavior. It was there too with the seatbelt legislation. There was a time in this country when nobody could believe you could wear a seatbelt. And when it came out, everybody, they said, no, that's not for me. That will pin me up and it will be tight around my belly and the chest and so on. Today, there are some people who, if they don't put on a seatbelt, they feel terrified. If you're on the highway and you're not wearing a seatbelt, you can't function. But behavior can change when the law changes that way to instill, to compel a particular behavior. And the member for Toko Sandy Grande said it. He said, when you pass this law, protect the homeowner, the occupier, in this way, what happens, Mr. Speaker, is that they think twice. If I come into this home, what is likely to happen? Because apart from the homeowner possibly having a licensed firearm, they have certain rights now where they can lick me down, so to speak, in local parlance, and they are protected. So they have a certain leeway, a certain leverage, certain latitude, and that is what we want to give citizens, that right. Because let's face it, over the last 10 years or so, the TTPS has not been able to defend citizens in the manner that they ought to have been. That is why we have these headlines I read. If the TTPS could have done it over the last 10 years, they would have done it. But they were not able to. And you read about these things, Mr. Speaker, challenges that we face given what we inherited. Given what we inherited, we are trying to fix it. What we inherited, it will not fix overnight. It will not fix with the passage of one piece of legislation. But it can. Mr. Speaker, as we said, the bill provides that the defenses would not be valid in certain circumstances. Mr. Speaker, where the individual against whom force is used has a right to be in the dwelling, where the force is grossly disproportionate, where the persons themselves in the dwelling place is involved in criminal activities. They will not be able to hold on to that defense. So we provide for that. Mr. Speaker, the offense of home invasion, in brief, is called the unlawful entry into a dwelling house with intent to use or threaten force. It may involve weapons, firearm, and explosives. The offense covers such acts as injury, grievous bodily harm, grievous sexual assault, rape, death, theft, property damage. And of course, there are instances where those offenses can be aggravated, and escalated because of gang involvement. Members of a gang are involved. It is part of organized crime. There's an invasion in the presence of children, senior citizens, persons with disabilities, or vulnerable persons, and the law defines vulnerable persons as well. Just for the record, we should probably indicate what the Act says about vulnerable persons, Mr. Speaker. I think the definition is captured. Vulnerable person means a person who is, by reason of mental or physical infirmity, disability, or incapacity, incapable of protecting himself from abuse, neglect, and self-neglect. Mr. Speaker, this is a very important aspect because it suggests, Mr. Speaker, that we are now protecting. There's an extra level of protection to persons who cannot protect themselves. So while we are protecting able-bodied people, men and women, there's a special protection that you aggravate this offense if it is a senior citizen. And I read one of the headlines involving a senior citizen. Children, the differently abled, vulnerable citizens. Mr. Speaker, that is the nature of this bill. And of course, it adds to the defense of person, the defense of property. And property is sacred. The right to property, the member for Toko Sandy Grande told us, is a constitutional right as well. It is sacred, Mr. Speaker. So that, Mr. Speaker, while it builds on the Castle Doctrine, it goes slightly beyond and codifies existing law, and the constitutionality, as there is a non-issue. A non-issue that has been dealt with. The Attorney General, in his wisdom, referred to that, Mr. Speaker. And the opposition, in response, tries to be alarmist. They are alarmists. They would like the society to panic. They would like nothing to be done to begin with. Nothing should be done. You know, so far we have heard from, I think, 2 or 3 members opposite. I can't remember now. But we have heard from members opposite. So we have the tenor of the argument. And you know, no one referred to the victims. We're dealing with home invasion, all of this criminal activity. And there was not one reference. There was this cliched mantra-type statement, we don't like how crime going, the thing's not good, and we want to not have a society full of crime. But no reference to victims, no reference to the elderly, no reference to those who suffer. And today we bring the legislation to deal with it. No amendment, no solution, no recommendation, nothing. And then they say they care. They care. We're concerned, we must do something. But do what? But, Mr. Speaker, I want to make it very clear, which the political leader, Prime Minister, has said often enough, that doing nothing is not an option. Mr. Speaker, doing nothing is not an option. We must act, and we must act now. Destiny calls us to act. If we do nothing, we would be remembered for doing nothing. But if we act, we will be remembered that we came, we saw, and as Shakespeare said, we conquered. And conquering means getting the right laws and policies in place to deal with crime. Mr. Speaker, I would say I have spent as much as 15 years working through in government, the National Security Council, in opposition, the Joint Select Committee on National Security, and has served, of course, in opposition as Shadow Minister of National Security for some time, along with my brilliant colleague from Barataria, Symon. We spent a lot of time dealing with these security matters and so on. And this is not something for us that is, ad hoc. It is not ad hoc. In September 23rd, I believe, 2024, last year, at a press conference held by the United National Congress in Shoguanas, we spoke at length, and we said when we got into office, we will come with home invasion law to give citizens a fighting chance. We added, of course, other matters to it as well. And that is what we are doing. We are fulfilling a pledge that we have made. And that pledge is sacred. And members opposite, I ask you to support this bill, to stand with us, to defend citizens. Don't be remembered as the opposition that voted against the protection of homeowners, that voted against giving ordinary citizens a right to take action against bandits, criminal elements. Don't be remembered for that. It's so early that people will remember that you never supported legislation to deal with protecting citizens. This is just one. There are other major criminal enterprise that we have to deal with as we go along. This is one area, but it's a very significant area. Very, very significant. We have to do more, much more. But in this matter, I ask the opposition to join us, to support us, and to ensure that this bill is passed, it is implemented, and if need be, as we go along, if there are any other issues that will arise as you go along, that's how it is. The world is like that. You can come and make amendments later if we realize after 1 year, 2 years, whatever, that we need to tweak here and there. But we need to pass. We need to pass, and you cannot provide, let me say this as well in closing, Mr. Speaker, you cannot provide for every eventuality when you make law. You can't. You have to be generalized at some time. You can't just build a law and say, well, every single thing that could happen, we're dealing with it. It doesn't work like that. It can't. As you go along, things change. The criminal mind changes, their instruments change, everything. And you have to adjust. But in this matter, we are clear where we are standing. We are clear what we stand for. And Mr. Speaker, I therefore, with those few words, ask my colleagues and congratulate those on this side who have spoken already for the comprehensive, precise presentations. And I leave it at that, Mr. Speaker. I remove the bills. Thank you very much.
San Fernando East.
Mr. Speaker, thank you for the opportunity to contribute on this very important piece of legislation, Mr. Speaker. Mr. Speaker, I am truly today taken aback by the level of joviality and laissez-faire attitude by those on the other side concerning this piece of legislation, Mr. Speaker. Mr. Speaker, there are lives on the line here with this piece of legislation. Lives on the line, Mr. Speaker. Yet those on the other side seem to have a very flip attitude towards this document. I sat here, I listened to the member for Oropuch East. The member for Oropuch East spent his entire time not referring to the actual bill that we're discussing today. And only in the last 15 minutes of his contribution did he actually refer to the document. He went through all of these incidents of home invasion that have happened in the past few years, Mr. Speaker. But you know what he didn't do? He didn't say how this piece of document here was going to ever assist any of those persons who were victims of home invasions in the past few years. Yes, Mr. Speaker. Mr. Speaker, and I strongly suspect he didn't because he can't, because that is not what this bill does. They've been selling one dream, Mr. Speaker, while the bill says something quite different. We had our friend, Mr. Legal Luminary Toko Sangigrandi, who spoke in his chamber at length. I thought he would use his vast legal acumen to clear up some of the major issues that many legal minds in this country have with this piece of legislation. He did none of that. He skirted some of the major gray areas in this bill and its major issues, Mr. Speaker. Again, I'm sure he did that because he can't justify it. Mr. Speaker, there's a two-word term in this bill, honestly believed, Mr. Speaker. And we're going to hear that term over and over and over as I go forward. Mr. Speaker, we on this side maintain that what those on the other side are trying to do is to turn this country into the wild, wild west. That is what they're doing. It reminds me of a song from a Jamaican artist that I like, Mr. Speaker, where they're trying to turn this country into a cowboy town, Mr. Speaker. We have a prime minister threatening to cuff people down. We have a member from Toko Sangigrandi talking about shoot to kill. In many of the consultations that we had, shoot people in the back, shoot, 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 kill, kill, kill. All this they have done, and this bill has done, is to promote and elevate violence in this country, Mr. Speaker. That is all the bill does. And the most dangerous part about it is that the very same homeowners that they're talking about are the very same people who become victims of these crimes, Mr. Speaker. It will simply elevate the level of violence because they're giving the impression that homeowners in this country can engage in behavior. They're giving them false courage that they should engage criminals in situations where they would be better off not doing so, Mr. Speaker. They'd be better off not doing so. And there are some situations where...
Mr. Speaker, Standing Order 55-1B. We have heard these points traversed by all opposition members.
Yes, San Fernando East. Move on a little bit. It's really repetitious now. I mean, the point's been made over and over ad nauseum. So perhaps you could get to the substance of your contribution.
No, Mr. Speaker, let me say something they haven't heard. They want to talk about crime, and they only want to talk about the last 10 years, Mr. Speaker. Let me remind the people of this country of the genesis of the runaway crime in this country, Mr. Speaker. In the period 2010 to 2015, we had an incident of corruption in this country that still resonates in this country today. It's still today, and Mr. Speaker, this bill...
Are you going? No.
Mr. Speaker, they've been speaking about the past 10 years all afternoon.
San Fernando East, listen, we've been getting along very well. Let's stick to the provisions. Everyone has stuck to the provisions of the bill. That's entirely irrelevant. Come on. Let's move on.
Mr. Speaker, there was a period of time, and this bill is meant to deal with crime. That's what they say. Yeah. It's meant to deal with home invasions, Mr. Speaker.
It is meant to provide, as I told Port of Spain North, it could be looked at as a legislative portmanteau. You know what that is? It's a carry-all. It's a legislative carry-all. So come on, let's stick to it. We've been getting along very well.
Thank you, Mr. Speaker. Mr. Speaker, they're using this legislation to attempt to turn this country into the wild, wild west, Mr. Speaker. Good. So let me move to the core purpose of the bill, Mr. Speaker. They want to establish home invasion as a criminal offense. It grants occupants of a dwelling house the right to stand their ground with no duty to retreat, allows use of defensive force, including deadly force, in self-defense or defense of property, Mr. Speaker. Mr. Speaker, you heard deadly force, lives on the line, people on the other side making jokes, right? So, Mr. Speaker, the law already exists, Mr. Speaker, where the people of this country are allowed to defend themselves. The self-defense laws are already codified. in common law, and it deals with proportionality, Mr. Speaker. The bill reflects principles found in the Castle Doctrine, Mr. Speaker, and stand your ground laws, which originated in English common law. Mr. Speaker, I do not need any assistance from Legally Blonde from St. Augustine, Mr. Speaker. I do not need any assistance.
You are the first to habitually complain about name calling. And there you are, rushing past the post. And there you are, rushing past the post to refer to the member of St. Augustine. Yes, but that doesn't mean you have to have recourse to that kind of... I'll require to apologize to the member.
Mr. Speaker, I withdraw. Mr. Speaker, Mr. Speaker,
Standing Order 48-6, the member has to apologize to the member for St. Augustine.
I will require to apologize.
Mr. Speaker, I withdraw. I've already withdrawn my statement, Mr. Speaker. Mr. Speaker, so proportionality, as with the self-defense laws.
This is unacceptable. 48-6. The member is disparaging in his comment towards the member for St. Augustine, and we will take nothing less but an apology and a withdrawal.
San Fernando East. Come on,
Mr. Speaker, I have already withdrawn my statement.
And apologize?
I apologize. Mr. Speaker, we move on. Mr. Speaker, the self-defense laws of common law deal with proportionality, Mr. Speaker. And proportionality means actions, restrictions, or punishments must not exceed what is necessary to achieve a legitimate aim, Mr. Speaker. And in many cases, that legitimate aim is the preservation of life. What they are saying to the population, Mr. Speaker, is that they're giving them carte blanche and free rein to engage with the criminal element in this country, Mr. Speaker.
Mr.
And
Speaker,
in many cases, that is going to
Standing
end in
Order
death
55-1B.
Citizens of this country.
The member for Portispain North, St. Anne's West, raised these matters. We are engaging in tedious repetition from the member from San Fernando East.
San Fernando East, I thought you were moving on to a different point. You've made that point. I can pull it up on the Hansard, but I think you've made that point about 10 times in the short time you've been speaking. So let's just move on.
Mr. Speaker, let's deal with some of the weaknesses of this legislation, Mr. Speaker. And as we know, in criminal law in Trinidad and Tobago, there must be actus rea, mens rea. Actus rea means the physical action of the committal of the crime. Actus reus, thank you so much, Mr. Speaker. Mens rea is to the intent involved, Mr. Speaker, which speaks to the guilty mind, Mr. Speaker. Mr. Speaker, one of the major weaknesses of this legislation that is promoting chaos and mayhem.
In some peace, please.
That is promoting chaos and mayhem in this country, Mr. Speaker, is the risk of excessive force, Mr. Speaker. That is what the legislation promotes, Mr. Speaker, because it is simple cut and paste legislation from those on the other side, because that is what they have been doing. They've been cut and pasting legislation, and this piece of document, Mr. Speaker, is cowboy legislation. They want to promote more and more violence in this society, Mr. Speaker, because they don't want to admit that they have already failed in fighting crime in this country. Standing
Order 55-1B. You've repeatedly asked the member to move on, and the member continues to repeat the exact same points.
And I think it's too many times for me to recall now, but I think in the short time you started at 6:44.
Thank you. Mr. Speaker, let me move on.
In 9 minutes, you made that point at least.
Let's move on, Mr.
times.
Speaker, to discussing the ambiguity of honest belief, which is something I had hoped that my friend from Toko Sandy Grande would have addressed. Mr. Speaker, reliance on what an occupant honestly believes may create subjective standards that are hard for courts to assess consistently, Mr. Speaker. We're asking the courts of this country to read minds. Many legal minds that have read this, that have made comments in the public space, spoke about these two words, honest belief. I thought Toko would have said something about it. He said nothing, Mr. Speaker. Honest belief. And it's very dangerous. I was hoping that those on the other side would have presented at least a single shred of data or evidence that this piece of legislation would have reduced crime in a single jurisdiction in which it was implemented. Not a single one did, Mr. Speaker. Guess why?
Mr. Speaker,
because it doesn't.
Standing
Mr. Speaker.
Order 55-1B. I would also like, Mr. Speaker, to refer your attention to Standing Order 53-2.
San Fernando East, I think you made the point. It has reached a stage of an ad nauseum classification now. I'm not going to invoke 53-2, but I'm going to ask you, you've made the point. Let's just move on. Examine the provisions of the bill. You've made that point ad nauseum now.
Thank you, Mr. Speaker. Let me present some interesting data to the people of this country, Mr. Speaker.
Do this. I habitually grant the 15 minutes, but I'm putting you on notice. I'm not inclined to grant 15 minutes because you've repeated the same point over and over. I'm putting you on notice now.
Thank you,
so
Mr.
let's
Speaker.
move on.
Thank you, Mr. Speaker, for your usual even-handed management of these affairs. I greatly appreciate it. Mr. Speaker, the key data points in jurisdictions where stand your ground legislation has been implemented, Mr. Speaker, and this is coming from an independent source. These are not made-up numbers, much like Point Fortin's Petrotrin numbers. These are actual numbers coming from a reliable source, Mr. Speaker. The research by the RAND Foundation, Mr. Speaker, and the RAND Foundation, or RAND Corporation, is a non-profit, non-partisan research organization that produces evidence-based analysis on global policy issues, Mr. Speaker. And this is what they found. Research by RAND found that states in the United States adopting stand your ground laws experienced a 7 to 10% increase in homicides, with no evidence of crime deterrence, Mr. Speaker. No evidence, no data from the other side, because they cannot find any data to support the implementation of this cowboy legislation, Mr. Speaker. 2, no reduction in burglary or assaults. Studies show these laws did not reduce burglary, robbery, or aggravated assault rates, undermining the argument that they prevent home invasions, Mr. Speaker. Oropuch East stood up here without a laundry list of home invasions. Not one time did he say how this piece of legislation would have protected any of those people or saved their lives, because it won't, Mr. Speaker. They're trying to fool the people of this country. We will not be fooled. Mr. Speaker, disproportionate impact. Analysis highlights racial disparities. Defendants are more likely to be acquitted when the victim is black than when the victim is white under stand your ground defenses. This raises concerns about fairness and bias in application, Mr. Speaker. Again, the law in every jurisdiction that it has been implemented has shown that it is skewed against the more vulnerable segment of society, Mr. Speaker. Escalation of violence, Mr. Speaker, as we've been saying from the very beginning. Many of the speakers on this side have said it, and any right-thinking person will see it. This bill gives false courage. It is promoting homeowners to engage with a criminal element, and they're not certain who it is they're engaging with, Mr. Speaker. If it's late at night and you hear someone at your door, you don't know if it's one of them or 10 of them. You don't know if they have guns, knives, cutlass, or whatever. In some cases, Mr. Speaker, it would be in your best interest to preserve your life and your family's lives, to maybe secure yourself in a secure place, or to escape through a back door, Mr. Speaker. What they are promoting here is that homeowners engage with criminal element where they may lose their lives, Mr. Speaker. Very, very serious. That is what they're promoting, escalation of violence. Evidence suggests that instead of encouraging de-escalation, these laws increase the likelihood of lethal outcomes. People are more likely to die after this law has been implemented, Mr. Speaker. Not less, more. In lethal outcomes and confrontations, even in situations where retreat was possible. Because as I said, this bill gives false courage. Listening to Toko Sangre Grandi, you would swear that everybody will all of a sudden turn into John Wayne or Josie Wales. That is not the case. Because you own a gun, it doesn't always mean that you're protected from criminals. In fact, in many cases, when you receive a firearm, Mr. Speaker, one of the first things they tell you is not to tell anyone. Why do you think that is? Because it makes you a target for criminals, Mr. Speaker. Those on the other side have already indicated that they are willing to free sheet give out FULs to people in this country. And very likely it's going to be family, friends, and financiers, Mr. Speaker. They're not going to be poor people. They're not going to be average citizens in this country. They're going to be family, friends, and financiers
Mr. Speaker,
receiving firearm licenses. Yeah, you're going to jump
I
up
wish
boldly.
to turn your attention to 55(1)(b). The member is introducing data and making the exact same points as Portisby North, St. Anne's West, and even the member for Portisby South. No new points have been introduced into the debate by the member.
I am more concerned with the imputation of improper motive for the bringing of legislation. That's what I'm more concerned about. You did make that imputation. I'm going to ask you to withdraw it and move on. With the amendment of the firearm user's license, you did say that it's for friends, financiers, and family. That plainly is an imputation of...
Thank you, Mr. Speaker. I withdraw.
So withdraw that and also pay heed to 55(1) again.
Thank you. Mr. Speaker, let me show you what the data shows in the United States, where this ridiculous cowboy legislation, cut and paste by the lazy people on the other side, want to introduce in this country. In Florida, adopted in 2005, homicide rates, Mr. Speaker, homicide rates rose by 24% in the decade after adoption of this dangerous piece of legislation, compared to a national average increase of 7%. So after they implemented their Stand Your Ground legislation, there was a 24% increase in murder, Mr. Speaker. Not less, more. In Texas, 2007 adoption saw a 16% increase in firearm-related homicides in the 5 years following adoption. Not less, Mr. Speaker, more murder and mayhem after this legislation was implemented. That is completely against what those on the other side would like to lead us to believe. I want you to believe that you're free from prosecution if you kill someone in your
Mr.
home.
Speaker, Standing Order 55(1)(b). The member is using data to make the exact same points. It is not any new point. Please, I'm begging, Mr. Speaker, we are at the stage where we have raised 55(1)(b) from the time the honourable member started to where we are now with no new point being introduced.
I think you've reached, literally arrived at your Icarus moment, insofar as tedious repetition is concerned.
Thank you, Mr. Speaker. Greatly appreciate it.
No. It says, I have warned you to move on. I put you on notice that I'm not going to give you the extra 15 minutes. You keep harping on the same point over and over. I'm going to give you one last chance to move on and not tediously repeat the same point you've been making ad nauseum for the last 18 minutes. So please, this is your last chance. I'm warning you. Move on.
Thank you, Mr. Speaker, for your warning. Mr. Speaker, let us deal with the clauses of the legislation, Mr. Speaker. And I move on to Clause 6. As I said earlier, Mr. Speaker, we spoke about those important two words, honestly believe, Mr. Speaker. And I'm going to show how this piece of legislation entrenches and in some places protects racial bias and other kinds of biases in this country, Mr. Speaker. It codifies
Mr. Speaker, 55(1)(b), the member for Portisby South and the member for Portisby North, St. Anne's West, went down the same road. You just warned the honourable member. If the honourable member has nothing new to contribute, he should sit down.
All right, San Fernando East, 55(1)(b), in the face of tedious repetition, gives me two options. Having warned you, I can ask you to take your seat, please. Thank you. And that's my first thing. Take your seat. Resume your seat.
Thank you, Mr. Speaker, for your usual even-handed management.
Tobago.
Thank you, Mr. Speaker. And I want to firstly say how gracious I am to be allowed to enter this debate on this critical piece of legislation. Mr. Speaker, prior to entering this House, I was of the opinion that contributions made by parliamentarians took into consideration the pros, the cons, all the variables, the advantages and the disadvantages. And I must say that I have formed a different opinion based on the contributions of the other side. Fundamentally, Mr. Speaker, the question that needs to be asked is whether or not there is a problem in this country with home invasions. And if the answer to that is yes, then we should be concentrating on solutions. Mr. Speaker, we spent quite a number of hours debating this bill. And I am yet to hear those on the other side fundamentally offering their blueprint or their plan. But that will not come, Mr. Speaker, because we have spent 10 years and home invasions continue to plague this country and nothing was done. Mr. Speaker, the home invasion or the person who invades homes should be seen as a devil because his intention is to steal, kill, rape, and destroy. And therefore, Mr. Speaker, the action that is perpetrated against such a person should be opposite and equal. Mr. Speaker, as a Tobagonian, I am aware that crime migrates. Just last evening, we had in Tobago, in the village of Mason Hall, Sandy River in Mason Hall, a drive-by shooting, something that is unheard of in the Tobago space. And therefore, it would be irresponsible of me to stand in this House or sit in this House and not support this piece of legislation. Mr. Speaker, I'm always averse to any approach by individuals to condemn an attempt to make things better, an attempt to eradicate crime. And that same individual is not as willing to offer a solution. That, in my opinion, Mr. Speaker, is nothing else but being very irresponsible and is a clear-cut case of showing the entire population that you have no interest in solving the problems of the nation, but rather you are placing yourself in a position to condemn any attempt that is made to make this country better. Mr. Speaker, I have sat here and I'm wondering, the victims of these crimes, don't they have constitutional rights? Don't they have families who are suffering? Are they not persons of value and substance that can make valuable contributions to this country to make it better? In the Tobago space, we are bent on doing everything possible
to ensure that Tobago becomes the greatest little island on the planet. And that, Mr. Speaker, is why we are sensible enough to join with the government and make sure that legislation that comes to this House that is in the best interest of the wider community of Trinidad and Tobago, we will always support. Mr. Speaker, there is an adage that says, evil will continue if good men fail to act. So I fully understand why home invasions continue to grow in this country, because there were no good men to act. The opposition, in my opinion, Mr. Speaker, came to this House to play on the emotions of the wider society of Trinidad and Tobago. And therefore, it's easy to understand why they do not have a plan, a blueprint, or anything that would have stemmed the flow of home invasions. And they have found themselves in a position where they cannot reasonably explain to the population why nothing was done. So they are now purporting that this legislation will injure Trinidad and Tobago rather than make it a better nation. And that is all right, because we have a team, a government, who understands that the people of this country needs a leadership that will demonstrate in a profound manner that they care about people. And I will always stand up against anything that suggests that we do not care for the people of this country. Where is the sympathy for the victims? Where are the rights of the victims? Where is the consideration for the victims? Where is the plan for the last 9 years? Madam Deputy Speaker, it is said you can fool some of the people some of the times, but you cannot fool all the people all the time. Mr. Speaker, Madam Deputy Speaker, I have lived for many a year and I have looked at how the society has unfolded. And I believe that based on your works, you are rewarded. I think the opposition need to do some retrospection. Mr. Speaker, Madam Deputy Speaker, my apologies. I am not here to be the greatest speaker, but I'm here to ensure that the wider population of Trinidad and Tobago take time off to examine the people that represent you. Consider whether in truth and in fact they have your best interests at heart.
Madam Deputy Speaker, point of order 48-1.
Overruled.
Madam Deputy Speaker,
I almost was disappointed that I didn't have an intrusion. However, I welcome it because facts always affect people. And I have no way of hiding my head in the sand. In Trinidad and Tobago.
Madam Deputy Speaker, 48-1.
Member is attempting to make a point, so let's wait for him.
In my short time at this microphone, Madam Speaker, I am quite sure I listen almost every news report, and I'm quite sure there is a problem in this country with home invasions. And I am sure that if we do not make an attempt, a profound attempt, to curb that runaway horse, this country is likely to pay dearly. And if we are all responsible persons in this house, both the government and those on the other side, we will support this legislation because we want to continue to build a Trinidad and Tobago that is attractive to all. We want to build a Trinidad and Tobago that will encourage foreign investment. We want to build a Trinidad and Tobago that will cater for our children and our children's children. And if the opposition don't know, that is what identifies a responsible father. Madam Deputy Speaker, as I close, I just want to say a word is to the wise is sufficient. And if we are interested in building out a product that will cause Trinidad and Tobago to prosper and flourish, we've got to think again and make sure that our contributions suggest that and only that. I thank you, Mr. Deputy Speaker.
Member for Diego Martin Central.
Thank you very much, Madam Deputy Speaker, for acknowledging me and allowing me to enter this debate for what I expect will be a brief contribution. I do not want to bother the member for Cuba South too much. Madam Speaker, let me start off by saying that every debate that takes place in this House is of national importance. But there are some matters that come before us, some debates that take place here that have the ability to fundamentally change who we are as a nation. And in that sense, there are some debates, I think, that are more important than others. Because those matters that come here may impact our society for the better. In some cases, it may impact our society for the worse. But either way, it is important that in those moments that we as legislators, as representatives of the people elected to serve here in this Parliament on their behalf, and as leaders in our society, to put a marker down, to not only say whether we support a bill or not, but to also say to this House and to the nation why we have taken the position that we have taken.
Madam Speaker, today is one of those days. Madam Speaker, the bill before us is the Home Invasion, Self-Defense and Defense of Property Bill 2025. And a lot has been said today simply because the bill has come to this House in a way that not many bills come to this House. It has been the subject of widespread discussion in the public space and online platforms because it formed part of the UNC's campaign leading up to the general election. And, quite frankly, the campaign that they have waged since then. And a lot of that discussion, and if we are to be honest, not much of it is really to do with what actually exists in the legislation today, but mostly on the way in which the population has been made to expect that this bill is going to impact their lives. Madam Deputy Speaker, everyone in this chamber, members of the public who have joined us in the gallery, the persons who are watching this on television, online, not only now, but who will do so for weeks and months and years to come. They also, in the lead up to the campaign, in the lead up to the election, the viral clips of the then opposition leader talking about knock it and crack it and light them up and reload. And the joy very often that was expressed, and I get that it was in the campaign and those things, but the joy that was expressed in sharing those sentiments.
Madam Deputy Speaker, 48-1.
Overruled. Member, continue.
Thank you very much, Madam Deputy Speaker. I am trying hard to walk a line here, and maybe the member will get a chance at some other point. Right? However, Madam Speaker, it is in that sentiment that the public had an expectation. And of course, along with that, there was a understandably less energetic display by the member for Toko Sani Grandi in his own follow-up as well. But we have discussed that at length here, and I will not get further into the expectations that the member during the campaign and even today also has foisted upon the population. Madam Speaker, so against that backdrop, we have come here today. And there are many in this society who have subscribed to what was sold, quote unquote, sold to them. And they truly believe that this bill is the silver bullet that will offer them the protection that they crave and the freedom from fear that they are living with up to today. So, Madam Deputy Speaker, we have speak more today than you have spoken in months in this House. But keep going. Madam Deputy Speaker, let me start at the beginning. Either. Anyway, Madam Speaker, let me start at the beginning, right? And the Attorney General, in his piloting of this bill, spoke about crime and said that crime, there was no quick fix for it. I'm paraphrasing, but that's basically what he said. And that there was no single magic bill to cure this problem. And he spoke about it requiring a strategic approach that empowers the protective services, supports the judicial system, and empowers citizens to protect themselves to feel safer in their homes. Madam Deputy Speaker, I want to respectfully suggest that I think that the Attorney General didn't get it all the way right. Because, Mr. Deputy Speaker, everything that the Attorney General spoke about was about fixing crime at the point of it being committed. You cannot fix crime if all you are doing is operating at the point where the person has already committed themselves to that path. All you're doing at that point, Madam Deputy Speaker, is moving them around between the courthouse, the prison, and the morgue. So, to fix the ills that have contributed to the state of crime that the Attorney General raised in his piloting of this bill, so to fix those ills, crime, criminality, and the violence that necessarily follows those, the focus must start long before the crime is committed. It requires a whole-of-government approach through policy, through programs, through government assistance, mentorship, and things of that ilk focused on providing young people in particular, but citizens in general, with an avenue or avenues which take them away from crime and criminality. So, Madam Deputy Speaker, it has been said, both by the member for Oropouche East and most recently by the member for Tobago East, that those on this side have offered no solutions. But that is also not true, Madam Deputy Speaker. The way that we combat the journey that takes the individual to the point of invading someone's house is by ensuring that there are programs like the Empower TT program, programs like MILAT and CCC. Programs, and it is interesting, the member for St. Augustine has talked to us about us shutting down. But I saw today, after the member from Lahokta Talparo made his comments in the House, in December 2024, a graduation ceremony for CCC. So I don't understand what shutdown we shut down. And in fact, member, it was the member for Aruka Lope, if I remember correctly, who gave the commencement speech at that graduation. So they were never shut down by us. You have entered debate. Madam Deputy Speaker.
Madam Deputy Speaker, 53, Standing Order 53. We are trying to listen to the member for Diego Martin Central, and there is constant chatter, utterances, and disturbances from this side. Standing Order 53.
Member, I think that occurs on both sides.
It is happening now, is Standing Order 53.
That'll make it right.
Proceed.
Thank you, Madam Deputy Speaker. So it is programs like that, programs like the Cultural Transformation Policy that was enacted by the member for St. Anne's East. Those programs are geared at transforming the culture of
48-1,
that had
48-1, 48-1, 48-1. Please
I agree,
be seated.
member.
48-1.
Let's move on.
Sure, Madam Deputy Speaker. All right? It is important, however, Madam Deputy Speaker, that we do speak about what contributes to that path and how that path can be positively impacted by a government who is actually interested in solving the problem and not leveraging fear. Right? So, Madam Deputy Speaker, it is always important that we address things that are said here. And the member for Oropuch East said many things, but in his contribution, one of the things that bothered me is that we on this side have said nothing about the victims. That was also mirrored by Tobago East in his contribution. So, Madam Deputy Speaker, let me state categorically that neither the member for Diego Martin Central nor any member on this side is in favor of exposing a man or a woman in their house to violence, to harm, to any sort of intervention that way from someone who has invaded their home. And our position has never been, the position from this side has not been about that. The position that we have taken is that the legislation has serious flaws in it. Flaws that are to do with the expectation of the public, flaws that are to do with the expectation of the person who in that split second, that moment in time, has to make a decision as to whether or not they are protected, that they are protected by this legislation, and what that means for them. Madam Speaker, we on this side are opposed to the way in which it has been sold to the population, but I and we here fully support the right for any person to protect their family, their children. The issue, however, Madam Speaker, is that already exists in the common law. That right already exists. And that has been explained at length from this side. You see, Madam Deputy Speaker, words matter. And the effect of words matter. Right? And there has been, obviously, the issue of that phrase that is not explained in clause 3 of this bill of honestly believed, and I will not continue along it because members on this side have spoken to it at length as well and exposed it as a genuine deficiency in this law. But there's also another change that exists in the legislation, and that is the fundamental shift from proportionate to now not grossly disproportionate. And, Madam Speaker, for the non-lawyers who are either viewing now or will at some point in time, what that effectively means is that the bar by which the person who has exercised the right that they believe that they have under this bill to shoot and to kill, that bar is now dramatically lowered. So that protection is there, Madam Deputy Speaker. And in the case of the parent who is at home protecting their family, from intruders, I have no issue with that. Except that the protection already exists. So, Madam Deputy Speaker, that protection also extends beyond the person's home because of another devil in the details. And that is the inclusion of yet another term that has not been explained in Clause 3 of this bill. And that term is an associated place. The idea of an associated place has to be defined because it does not, sorry, Madam Speaker, it is defined in Clause 3. My apologies. It is defined in Clause 3. But it is not what the average person would legitimately believe it to be under the protection of a homeowner or the occupant of a home, because it extends to any place where a dwelling house is part of a collective in one building or in a group of buildings that all the occupants use in common with each other. What does that mean, Madam Speaker? It means that apartment complexes, townhouse developments, and other gated communities will all fall under this rubric. It means that we now have to worry as a society what happens to us in those shared spaces, in the car park, in the stairwell, in the elevator, in the gym, in the electrical room, in the corridors. Madam Speaker, our issue with this has nothing to do with the fact that we don't support the right of the person in their home to protect their home and their family, you know. It has nothing to do with the fact that we don't stand with the victim. It has to do with the fact that we are saying that this law also creates a new group of victims and potential victims. And that is something that we have to be cognizant of in this House. We must understand that process, it was somebody, it may very well have been Tokosani Grandi, no, it wasn't, who talked about a member giving a contribution, and everything that the member spoke about was what ifs. Well, Madam Speaker, that process of what ifs should have taken place when they were crafting the legislation so that they would understand how this legislation was going to impact the society beyond who their target market was and how it would affect change in the very fabric of this society. And so it is the opposition's responsibility to point out those flaws, those deficiencies, because that is our role in this parliament, whether or not there are members on the lower bench on that side who don't like that. But we are here and we have a role and function. And that role and function in a piece of legislation as critical as this cannot be shirked by us. It must be taken with both hands. And Madam Speaker, we on this side would have spoken with our constituents, would have heard their concerns. And we are not coming here to pull from our pockets to say something, you know. I have been tasked with speaking here today, not only by the party which I represent, but the people who I represent. So, Madam Speaker, under this law, the person who has the honest belief, as we have discussed, driven by any number of prejudices and biases, protected by the metric of not grossly disproportionate, can use deadly force in a situation that did not totally warrant it, and the story cannot be refuted because dead men tell no tales. Who, in that situation, who am I to stand for? Who am I to be concerned with? The person who has utilized the law, wittingly or unwittingly, to protect themselves, or the person who is lying on the ground? For me, Madam Speaker, the person on the ground is a person that I will speak for every day. And Madam Speaker, even where that person may be found guilty, as we have discussed, the shooter is going to end up in court, the shooter is going to end up before a judge, the shooter may or may not be found guilty. So even if they are found guilty or not by the courts, there is another person who might be killed or wounded and emotionally scarred for life. And while we have talked about deaths, Madam Speaker, there is a group of people that we have not spoken about, and those are the people who sit in that sort of near miss, who would have had those interactions and will never forget for the rest of their life, the day a gun was in their face. And for all his bleating, Madam Deputy Speaker, that person is going to remember that it was the Minister of Defense, the member for Toko Sanigrandi, who said, shoot first, kill first. And they are standing there on the other side of that argument, not warranting it, praying for their life and seeing it flashing before their eyes. So, Madam Speaker, we do know that there are going to be people who are going to be impacted by this legislation. Not speaking about the homeowner who is defending himself, who is already protected under the common law, and who I fully endorse should have all the protection that he or she can be afforded. We are not talking about the person who has chosen a life of crime, who was kicked in a door, he and associates, to wound, to rob, to rape, to kill. We are not speaking about them, Madam Speaker. We are speaking about the people that this legislation is silent about, because that silence is deadly. And I take that very seriously. And I'll tell you why I take it very seriously, Madam Speaker. Because this piece of legislation is not an island. In this debate, it has been discussed by the Attorney General in the moving, and at some other point by some other member who, if I'm to be honest, I cannot remember right now, that we do have the reality of widening access to firearms and a policy to empower a proliferation of gated communities in this country. And I draw you, Madam Speaker, I draw your attention to an article in Trinidad Express on August 29, 2025, reporting done by Anna Ramdas, the title being Gated Community Policy on the Way. And in that report, which is a reporting of a post-cabinet press briefing, the Minister of Rural Development and Local Government, speaking at the post-cab news conference, said that this move to have this proliferation of gated communities aligns with the government's position on stand your ground legislation, and went on to say that stand your ground doesn't only mean owning a gun and being able to defend your home with force, but it also means standing your ground and protecting your communities. And in this sense, Madam Speaker, that community is everybody who lives behind that wall and that gate, and who is protected under this legislation because they live in a dwelling house that is part of a community with more than one house, and there are associated places within that community. Madam Deputy Speaker, we have to acknowledge that the fact that people are fearful of crime in their daily lives. And as we have seen today, and I understand as the day goes on, patience is reduced and tempers may free. But in this political guile that is the Parliament, Madam Speaker, we understand that the government, as they have, will undoubtedly assign their blame to the opposition. And we on this side will have the ability to speak about what we see as them undermining us for 9.5 years while they weaponize their minority on this side. But the truth is that that does not change what is happening today. After spending the majority of 2025 in a state of emergency, that feeling of fear has not changed, and in many ways, it has worsened. And it is that state of affairs that the government comes to us to leverage, to dangle gates and walls, to dangle more guns in your hand, and the perceived protection.
Member, would you like your additional 15 minutes?
Yes, Madam Deputy Speaker. And the perceived protection that you could shoot whoever scares you. And the truth is, Madam Deputy Speaker, that will appeal to some in this society. But Madam Deputy Speaker, when I was doing my own research for today, one of the groups of people that I wanted to speak to were gun owners. And Madam Deputy Speaker, I was fully expecting that my conversation with them would result in me being told that they fully support the bill. Because the truth is that the perception is that it leans heavily in support of the gun owner. Not the perception, Madam, the reality. However, Madam Deputy Speaker, you will be amazed to know what the feedback was. The position that the gun owners told me was that the current law is not against the gun owner in his home, and that the thought process as to when they use their weapons in any situation is a function of training and not law.
Leader of Government Business.
Thank you most kindly, Madam Deputy Speaker and members of the House, to allow me to invoke the procedural motion under Standing Order 15.5. Madam Deputy Speaker, in accordance with Standing Order 15.5, I beg to move that the House continue to sit until the completion of the business before it.
Honorable members, the question is that the House continue to sit until the completion of its business. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Member for Diego Martin Central.
Thank you, Madam Deputy Speaker. And the last point that was made to me, Madam Deputy Speaker, by the gun owners was that they saw the shift of proportionate to grossly disproportionate as giving the gun owner more latitude to make a mistake and be protected. And they were not in favor of that. Madam Speaker, if I have to spend any time to explain to Tunapuna what is being said on this side, I will run out of time. So if you don't mind, I will continue. Madam Deputy Speaker, I want to just, in my closing moments, speak about an issue that I don't think has been raised, but I do think needs to be. And that is that the the two policies that I have discussed, the widening access to guns and the gated community, in combination with the legislation, does worry me deeply when it comes to the implications for this country. And my concern and the concerns of those who I have spoken to in my constituency and across the country, even as we went around speaking to our members across the country and others, was that it is going to bolster the creation of communities that are walled off, that are armed, that are policed from within and protected under law. And the issue, Madam Deputy Speaker, with that is that in many constituencies, if not all our constituencies, we have situations where you have those communities who fall under that grouping of protected under law, walled off, armed, and policed from within. And less than the width of a storm drain away is a community that is offered none of those protections and does not have the wherewithal to achieve any of those protections. And my issue is that we are going to have communities that see each other as different and apart, deepening divisions that do exist in this country as it would exist in any multi-ethnic, multiracial, diverse country. The truth is, Madam Speaker, that there are people who do subscribe to that separation. And those people are becoming more emboldened every day. My position here today is that it should not be the government that utilizes their majority in this House to hasten us down that slippery slope. So, Madam Deputy Speaker, I actually do share the sentiments that the member for Tobago East expressed as a father. And it is on behalf of my children, on behalf of all our children, on behalf of the children of this country and our children's children, that I respectfully ask the government to reconsider this legislation in its current form. Thank you, Madam Speaker.
Member for Labrie.
Thank you, Madam Deputy Speaker, for the opportunity to enter this debate. Madam Deputy Speaker, before I get into my contribution in this debate this evening, I wish to acknowledge the life of Councillor Ramona Victor, who tragically lost her life a few days ago, and who we will say goodbye to come tomorrow, and who served this country as a councillor and fought tirelessly for the betterment of the people of the Superior Borough Corporation. Madam Deputy Speaker, I heard earlier on a member on the other side made reference to what I suppose he was tempted to make a biblical quote and said, "Yea, do I walk through the valley of the shadow of death, I will fear no evil." But I want to say that I too know some Bible quotes. And Luke 6:46 says, "Why do you call me Lord, Lord, but you do not do what I say?" I also want to add to that James 1:22 that says, be doers of word and not hearers only, otherwise you are deceiving yourself. But more importantly, I want to add to that, Isaiah 29:3. Therefore the Lord said, these people draw near to me with their mouths and honor me with their lips, but their hearts are far from me. So not because you quote Bible, it means that you are any closer to God. And it's the same people, Madam Deputy Speaker, that has treated us in a manner that demonstrated that their heart is far from God. And I also heard the member for Potter's Bay, North St. Anne's West, indicate that we spoke on this side only about emotion and not about the bill. But, Madam Deputy Speaker, if you cannot connect the act of home invasion to an emotion that is moving and stirring, then your heart is of pure stone. In my contribution, Madam Deputy Speaker, I want to draw reference to two personal examples. The first example I want to bring to your attention, Madam Deputy Speaker, is a situation that I had personally when I was living at my prior residence to the one I'm living at now. And for successive days, while I was not at home, 4 young boys broke into my home and stole a number of different things from my house. Eventually they were caught, but because of their age, I showed sympathy on them and I asked the court to go easy on them and give them a bond, rather than to have the full measure of the law enforced upon them. But another more telling experience for me, Madam Deputy Speaker, was around 2015, 2016, I think it was 2016. My father, as he was then, was home with my my older sister, and just around midday, 2 young boys entered my father's house, demanding money, because they said to him that they knew he got pension, and they wanted to know where the money was. And he said to them, I have no money. They say, you're lying. You have the money. Give me the money. And in their quest to commit and complete the act, they became violent, and they used a cutlass, and they attempted to strike a blow at my father's neck. And he defended himself by raising his hand. And as he raised his hand, Madam Deputy Speaker, one of the bones in his arms was completely chopped, and the other one was fractured severely. Of course, he had to seek medical attention. The police hold those 2 gentlemen, and the charge that those 2 gentlemen faced certainly was not a home invasion charge. The charge that they faced was inflicting grievous bodily harm. That was the charge that they faced. And of course, when they went to court, because of the court system then, which we are fixing now, those 2 young men got off. How are we fixing that? I want to make reference to section 5, subsection 3 of the bill that is before us, Madam Deputy Speaker, which says, a person who commits an offense under subsection 1, A, acting as a gang member, B, acting as a participant in an organized criminal activity, or C, in the presence of a child, senior citizen, person with a disability, or otherwise vulnerable person, is liable on conviction on indictment to a fine of $750,000 and to imprisonment for 25 years. What my family and I would have given to have this piece of legislation at the point in time when my family faced this. And as I hear members on the other side, in their usual manner of being dismissive to persons' plight and empathy, he quips, but grievance William is 25 years. Mr.
331L. The Speaker has been speaking since he started with his hands in his pocket. He's offending the rule. Could you look at it, please? 531L.
Member 531L states, shall otherwise conduct himself in a fit and proper manner.
Speech, madam.
Overruled. Member, please continue.
Had he been paid proper attention, I thought he was going to say, I'm speaking with a pen in my hand. That's what I thought he was going to say, because a pen is in my hand. But I am more skilled than he is. So I am not going to get into that banter with him. Mind you, Madam Deputy Speaker, this is the same gentleman that told us to use a coal pot to cook when they were in power. Yes? This is the same member who asked that we ride a bike.
We can't afford gas now. Collateral, we can't afford gas.
Madam Speaker, I think you need to rein in the member for Port of Spain South. This level of hooliganism once more will not be tolerated in this parliament. Putting on your mic and shouting across the floor while a member is on his legs.
Member for Labre, please continue your contribution.
Thank you, Madam Deputy Speaker. Thank you, Madam Deputy Speaker. So, as I was saying, before I so rudely interrupted Madam Deputy Speaker, you can imagine what not just my family, but many other families would have given to have legislation like this implemented at the point in time when we faced what we faced. And you see, Madam Deputy Speaker, sometimes the loss of tangible things, a value could be put to it and it can be replaced. Sometimes even an injury, a physical one, can heal with time. But the mental trauma, the psychological trauma, the emotional distress that accompanies anybody who experiences a home invasion that could never be measured, never be compensated, and never be replaced by anything else. So while they pussyfoot on that side with people's lives and people's safety and people's security.
48. No. 48-4. You are serious, Tanapuna? 48 something? How much is that in years? You are serious? You are serious? Madam Speaker, he's imputing improper motives of us pussyfooting with people's lives.
It is a mere analogy. I will let the member continue.
Thank you, Madam Deputy Speaker. Madam Deputy Speaker.
Go ahead, comrade.
Madam Deputy Speaker, you see, sometimes the truth also offends.
Yes.
So for 10 years, they did nothing, and that is pussyfooting. For 10 years, they pussyfooted. And now we have a government that is acting, and they can't believe what it is they see in Parliament here today. Very soon, Madam Deputy Speaker, we may have to even expand our own manifesto, because at the rate we go in, by next year we don't lick up the whole manifesto promises already. That's what they can't take. So again, as I was saying, Madam Deputy Speaker, that mental anguish that a family faces after you experience a home invasion, that is something that could never, ever, ever be replaced. You dream it. You're always looking over your shoulder. You're always insecure. When that feeling of insecurity is taken from you, Madam Deputy Speaker, no matter what anybody says, it could never, ever compensate or make up or replace. Never. I lived it. I know it. I could speak it. So this legislation has been brought for us here today. For some of us who experience it already, it may be a little bit too late. But it has not ceased to exist in the society. And as a responsible government, it is up to us to protect our people in the best interests for our people. And that's what we're doing here tonight, Madam Deputy Speaker. But I want to add one more element to what I told you earlier on about the experience of my father. We would have called the police. And because of the incompetence of the other side to properly address resources and provide resources to the national security apparatus, the Erin police station.
Madam Speaker, 48-1. How was any of this addressed by the legislation?
Overruled, member. Continue.
Thank you, Madam Deputy Speaker. Because they failed to adequately resource rural areas, as they did with the Erin police station, where there were not even vehicles to respond to our call. We had to take our father personally to the station and to get medical treatment. Of course, we took him to get medical treatment first. So even, and Fernando West want to know how this is relevant. Even in cases of home invasion, they did not even protect the people against that. But more than that, they did nothing or very little to ensure that even when you experience a home invasion, that you were given the resources to get some kind of response by the protective service. So because we live in a rural community, as Labre is, and for 40 years they were in charge of Labre, and if you see Labre now, God help it, I am here now, God help it. So we have, Madam Speaker, we have ensured that with this legislation, that we put systems and things in place to give people that comfort and that peace of mind to some extent. Because as I said before, even if someone breaks into your house, that sense of security that they steal is something that is very hard and difficult to replace. I heard, remember, for Port of Spain, North, Sentence West, in what I suppose he felt was an acute attack on the AG. Read out the story where the AG was a victim of home invasion. With glee. As if to suggest, look, he ever gonna still get robbed, look at him, ha ha ha. As if to suggest that. You understand? But Madam Deputy Speaker, I want to tell the public that this legislation is not about, it is not about putting guns in people's hands. It is not about that. This is not a gun law. Contrary to what San Fernando East will want people to believe, this is not a Wild Wild West legislation. It is not that. And, Madam Deputy Speaker, I would have engaged in consultation on this legislation within my constituency of Labrie. And I want to say tonight for everybody to hear that all who attended that consultation unanimously supported this legislation that we have in Parliament here tonight. I make that point as well to address something that Port of Spain, North, St. Anne's West said, that what we sent out in consultation is not what came before the Parliament. Well, that might be so. And you know why, Madam Deputy Speaker, that is so? Because when we consult, we listen. We do not talk down to people. We do not shove things down people's throat. We listen. And it's because we listened, what was presented as a draft bill for consultation is not the same thing that will come before this Parliament. That is what a responsible government does. They would know about that. Yeah, you will. Now, Madam Deputy Speaker, this legislation, as they want to have us believe, on the other side, that things already exist in law for this and exist in law for that, you don't need this, you don't need that. But if we didn't need this, then all of the articles that my colleague from Orpuch East spoke about would have been irrelevant. As a matter of fact, Madam Deputy Speaker, let me add one more to that. Another one. I'm reading, Madam Deputy Speaker, from an article in the Daily Express dated February 25th, 2022. It says, woman killed in Westmoreland's home invasion, two suspects die. Nicole Moses, and again, even though it's something from 2022, I still extend deepest condolences and sympathy to the family of Miss Moses. Nicole Moses, the woman killed when bandits entered a property in Westmoreland this morning, is being mourned and celebrated as a hero who died in defense of her family and property. Moses was mortally wounded in the neck and chest after she rushed her 2 nephews to safety and tried to escape into her home, police sources say. Her brother, who was in the house, a licensed firearm user, confronted the men and shot them dead, police say. Now, what they will want us to believe is that you only need a gun to defend yourself. And that's what happened on. But it didn't matter if there was a gun, if it was a piece of iron, if it was a stick, if it was a stone, whatever it is that is used to defend yourself, this legislation says you can stand your ground. Stand your ground. So we are here bringing legislation to let citizens know, to let this country know that notwithstanding the morass that that side has left us in, that we will do things that is going to protect you and your family and in your best interests. That's what we're here for. And as they spoke about the legislation, it was only as a matter of, I want to use an appropriate word here, of being embarrassed into action, that Diego Martin Central decide, okay, well, I will talk about the victims.
Yes. Yes.
So I sat here as a victim of home invasion. The AG sat there as a victim of home invasion. And here we are feeling as if we were the perpetrators of a home invasion. Where is the sympathy and the empathy from the other side?
Forget it.
But you see,
Forget it.
while we plead with the other side to support this legislation, we certainly will not be surprised if they don't.
No, of course not.
If the first bill that we brought to this house was to protect children with the Children Life Fund, and they didn't support that. Well, then what is this one?
Yes. Yes. Yes.
And they were very livid when we brought bill concerning Prime Minister's pension.
Yes. Yes. They like their own self.
I will still appeal to them nonetheless, Madam Deputy Speaker, because it's my job to do so. I want to appeal to them that they look at this legislation and see it for what it is, and not try to fearmonger the population as they always do, into believing that this legislation is a license to kill. It is not a license to kill. And I want to make that point, Madam Deputy Speaker, that they will have you believe that this legislation is one where the vulnerable could be killed easily. We need to protect the vulnerable. Or they'll have you believe that this legislation is one that encourages Wild West behavior and vigilante kinds of actions. That's what they will have you believe. But there are enough clauses in this legislation to protect you as a homeowner and anybody else who may be a victim of person's wickedness. That's what you're trying to do as well. So we know that not all men are good. We know that. People will try all kind of different things and use the law as their shield. We know that too. And that is why we have placed within the legislation, Madam Deputy Speaker, enough clauses that says the conditions under which you can depend on this legislation or rely on this legislation to protect you. Should you, God forbid, stand your ground and bring injury, harm, or even death to a perpetrator. So this is not a free license to kill. This is not that. So you can't, as they want you to believe, do someone harm, and as Potter Spain South said, when your dead dies it, to have no coming back. Well, of course we know that. But this is not a license for you to harm somebody and then use this law as your shield. This is not that.
Member, would you like your additional 15 minutes?
Yes, please, Madam Deputy Speaker. This is not that, Madam Deputy Speaker. But what this is a legislation that says, if you come into my home with ill intentions to hurt my family and I, then I have the right to stand my ground, to defend myself, and whatever I get inside there, you go take. That's what this is. And anytime a legislator could stand up in defense of the criminal, then that alone should tell the population that on April 28th, they made the right choice. Because that's what they have been doing all night. Standing in defense of those who want to commit acts against law-abiding citizens. And no law-abiding citizen.
Madam Deputy Speaker, 48-6, please.
I don't understand how that is imputing improper motive, so I will let the member continue. Overruled.
The Speaker.
Thank you, Madam Speaker.
48-6. The gentleman is saying that we are promoting criminals in Trinidad and Tobago. Let me know when you finish. Let me know when you finish. Madam Deputy Speaker, the member is saying that we on this side are promoting criminals in Trinidad and Tobago. That certainly isn't true.
The member did not exactly say that, so I will let him continue. Overruled.
I said that, Madam Deputy Speaker. I don't mind you quoting me, no. When you quote me properly. Don't misquote me. Don't misquote me at all. You understand?
Love, love, love.
Do not misquote me at all. I did not say that.
Love, 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 love.
So,
love, 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 love.
Madam Deputy Speaker, law-abiding citizens in this country need not be fearful of this legislation. So all the fear-mongering and the what-ifs. So what if a child go to pick mango? Well, Madam Deputy Speaker, let me tell you something. Well, let me tell them something, sorry. How I grew up, and maybe I'm using my own experience and thinking everybody should have the same kind of brought up sea, to use a colloquial term. But even in the country, with all of the fruit trees growing by the roadside, with no fence around it, once it was in front of somebody's house, you couldn't just go and pick it just so. Miss Lucy, Miss Ova, I could get a pomerac, please. I could get a pumpsite, please. They will not tell you no, you know. But what they want is for you to first ask before you enter and go and pick it. So when children are taught the right thing from early, then they don't need to go astray and go foul of the law. I am not saying that all children are taught the right way, Madam Deputy. I'm not saying that at all. But they played on the emotion of citizens by saying, what if a child is, and what if that, and what if that, and what if, and what if, and what if. But, Madam Deputy Speaker, what if the last 10 years didn't happen?
Oh, God. Oh, Lord.
What if? We could get ridiculous like that, or even more ridiculous than that. But the persons who made those what if statements, the disappointment for me is that that person claims to be a reputable attorney. And therefore, if you claim to be a reputable attorney, you must know that no law, nowhere in any piece of legislation could you legislate for everything under the sun. You can't. So all of this what if and what if and what if and what if. What if? What if, despite all of the attacks on the union, that the union get what it deserves as the 10%, which they did? What if?
Madam Deputy Speaker, I rise on 48-1. I don't think the union and the 10% is a part of this dispute.
It was just a comparison.
What if what we are actually saying in here, they understood and made sense to them? What if? So, Madam Deputy Speaker, this legislation that we have brought here, it is designed to ensure that that sense of security that people so want to feel and have, and want to have some kind of legislation they could stand on, and something that actually says what you're doing there is against a particular law, is brought to ensure that our citizens know that this government cares for them and for their best interests. That's what we're doing here. So this legislation is just that, to bring good law. I don't care what they say, this is good law. To bring good law to this parliament that not only protects, but advances the interests and the security of our citizens of this country. I want to say one more thing before I close, Madam Deputy Speaker. Notwithstanding all of the advocacy for everybody but the victim, notwithstanding their clear and deliberate attempt to not support anything good that this government brings, notwithstanding their dubious attempts to hoodwink the population because all they want to do is oppose, I believe firmly that our people in Trinidad and Tobago, they are brilliant, they are smart, they are thinkers, and they can see that the only choice for this country was the one that they made on April 28, and for the next 15 years, it will be the only choice they have yet to come. So I thank you, Madam Deputy Speaker, for allowing me this opportunity to contribute in this debate. And as I close, I want to close as I started. And I want to once again urge us to just contemplate on the life of Councillor Ramona Victor, and for those of us who knew her well, to attend her funeral tomorrow as we pay our last respect to Councillor Ramona Victor at Irving Park, Superior for 1 p.m. Thank you, Madam Deputy Speaker.
Member for Laventille East Morva.
Thank you, Madam Deputy Speaker, for allowing me the opportunity to contribute in this very controversial debate. Madam Speaker, I would like to start and clearly outline to the country once again, as I did my initial contribution, my maiden speech, to clearly outline what my position is every time I enter into these chambers. I seek not to quarrel, but to clarify, not to condemn, but to contribute. I seek no political points, but I seek to strengthen our national understanding of what we do in these precious chambers and what it means for real people in real communities. This, I believe, Madam Speaker, should always be the standard brought forward in these chambers. Madam Deputy Speaker, today we debate a very controversial piece of legislation, the Home Invasion Bill, more popularly known as the Stand Your Ground Bill. And we can all agree that home invasion, it is a real and a terrifying experience. And Madam Speaker, I say this not because of what others have experienced, but because I myself have first-hand experience with home invasion. So if you may permit me to paint a picture for you. It occurred many years ago, and I would have went to bed one night with my cell phone next to my head, and I would have woken up with my SIM card next to my head. Some items missing, and in addition to that, some jewelry missing. But what I will say, Madam Deputy Speaker, is that no amount of access to guns, weapons, or anything of that nature would have provided any comfort in that situation. Madam Speaker, this bill, the Home Invasion Bill, just to give a bit of context for those who may be now tuning in or listening to the debate, it gives long jail terms for people who break into houses to hurt or to rob people. It also says that you do not have to retreat if someone comes into your home to attack you. you are permitted to stand your ground and fight back. Madam Speaker, it even allows for deadly force to protect your home and your things. I want to stress on that, your things. And that means that you may be allowed to kill to protect your property. Not to save a life, but protect your property. And Madam Speaker, I heard a lot of Bible quotes being mentioned in the chambers today. I want to make mention to one according to the Quran in respect to the sanctity of life. Whoever kills a person, it is as if he has slain all humanity. And whoever saves a life, it is as if he has saved all humanity. So, Madam Speaker, when I hear comments like load up the matic, cuff them down, bust their head, kill them violently, shoot them in the back while they're running, Madam Speaker, I ask myself, who really has the heart of pure stone, as the member from Larry would have mentioned? Madam Speaker, I would have said it before. I would have heard the opposition leader make mention to it, and everybody else on this bench make mention to it already. We are prepared to support any piece of legislation that serves the best interest for the people of Trinidad and Tobago. Any piece of legislation that would support the protection of families, we are prepared to support that. But what we will reject with impunity is any piece of legislation that encourages more killing, more guns, and more injustice, especially in working communities like Lavantillis Mover. We will reject that with impunity, Madam Speaker. So I would just like to lay some context based on my understanding of the bill and what my review would have brought me to. Madam Speaker, what I will say though, before I get into that, is I was taught by some elders, the ones that raised me, that you must accept some good with the bad. And how playfully she would have taught that to me is with one phrase: sugar and salt. You use sugar and salt to bake one cake. So let that sink in. Madam Speaker, there will always be some sort of merit to anything. And we can probably review some of those as we go along. Because what this bill does, it clearly names home invasion, as we can probably agree that there might have been a legislative gap there, as the existing laws would have covered burglary and robbery, but not the particularly violent element that is home invasion or violent entry into your space. What it also does, Madam Speaker, is it adds serious penalties for a very serious offense. And some of those penalties is 20 years and $500,000 fines, and 25 years and $750,000 fine if you are a gang-related member. And, Madam Deputy Speaker, what it does, it serves as some form or sort of protection for those who genuinely act in self-defense. And having been a victim of home invasion, I can agree that somebody defending themselves in their own home, they should not have to argue technicalities about retreat with respect to what follows after you survive a life-threatening incident. But, Madam Speaker, we clearly agree that home invasions they are a national trauma, and they must be punished. I cannot stress on that enough. We agree that genuine self-defense in your home, it must be something that is protected and encouraged. But we disagree, Madam Speaker, with law that imports the most dangerous parts of foreign stand-your-ground experiments, because it is an experiment, into high-tension communities like Lavantelis Mover without any safeguards, any monitoring, or any support at all. Madam Speaker, when I reviewed this bill, what stood out to me was the sheer advocacy that went into forming this piece of legislation that is brought before us today, and the government is asking for support. I asked myself, what level of research went in to the formulation of this bill? Because, Madam Speaker, I believe that any piece of legislation that comes into this House, it should be data-driven. You should have some sort of review, and it should be backed by studies, it should be backed by data. Madam Speaker, I looked at some of these reviews, and according to the American Journal of Public Health 2021, they examined laws which expanded rights to use deadly force in self-defense, including the stand-your-ground laws. And their conclusion, Madam Speaker, was that these laws, they do not reduce violent crimes, and in some states, they were associated with the increase in homicides. Madam Speaker, I even looked at many large cohort studies. According to JAMA Network Open 2022, they analyzed US states before and after stand-your-ground laws were implemented, and they found that statistically there were significant increases in monthly homicides and firearm homicides. That is after the adoption of these laws. And Madam Speaker, we must not ignore, as much as the government would have you believe that it is just a myth, we must not ignore the fact that there's the factor of race and justifiable homicides. Utilizing FBI data, Madam Speaker, Roman 2013 and their later works showed that they found white on black killings were far more likely to be ruled as justified as compared to black on white killings under the very same stand-your-ground regimes. I can go on, Madam Speaker. A smart review was done on systemic reviews on firearm policies and race, and it showed that firearm laws can have different impacts by race and ethnicity, sometimes widening disparities in who lives and who dies. I can go on again, Madam Speaker. The data is there for all to reference. Comparative legal scholarship and castle doctrine, according to Carpenter, Market Law Review in 2003. So there's a broad gap there. And even back then, it warned that broad castle doctrine rules can undermine proportionality and it can blur the lines between defense and revenge. In addition to that, Madam Speaker, it increases the risk of domestic conflicts. So what can we take away from this data, Madam Speaker? You can honestly say that the international evidence, it does not support the promise that these laws will indeed reduce violent crimes. It does not promise that, Madam Speaker, as the government would have the population believe. It also shows that there is moderate to strong evidence that they increase homicides, especially firearm homicides. What else can we take away from this, Madam Speaker? There is clear evidence of racial bias in how justifiable killings are judged in stand-your-ground states, and this should ring a very loud alarm in everyone's head in this chambers here tonight. Because, Madam Speaker, we already live in a society and we struggle with inequality and mistrust. And, Madam Speaker, while we are on the topic of trust, there was another study, another survey, I should say, that was conducted called the World Value Survey. And they asked a very simple question. But that question, Madam Speaker, was a very loaded question. As simple as it was very loaded. They asked, how easy was it for you to trust someone? Seems simple enough, right? How easy was it for you to trust someone? And they would collect their data, prepare the report, and share this information. Some of the findings go, Madam Speaker. China reported 63%. Canada reported 43%. The USA reported 37%. And I would like to ask anyone in this chamber to offer a guess as to what Trinidad and Tobago reported with respect to trust. Trinidad and Tobago reported a whopping 3%. Madam Speaker, this was troubling data to read, particularly because we have a clause, clause 7, that states, deadly force where the occupant honestly believes that it is necessary to protect property or remove an intruder is allowed, it's permitted, and that's not to save a life. That is not to save a life, Madam Speaker. And this data, sorry, not data, but this fact, that clause, it sits uneasily with right to life norms in human rights laws, Madam Speaker, because these laws generally hold that lethal force should be used where strictly unavoidable to protect life. Madam Speaker, we cannot just sit idly by and pretend that this tablet that I'm holding in my hand, the chairs, the mic that's in front of you, is on the same legal scale as compared to a human life. We cannot pretend like it's the same thing, Madam Speaker. That is an important thing to not overlook. Madam Speaker, it's almost as if we are lowering the bar. We are lowering the bar with respect to the value of a human life. Madam Speaker, I believe that we increase the risk We increase risk when we compound the two phrases, honestly belief, with no duty to retreat. And that test is partly subjective as we leave life and death, Madam Speaker, in the hands of the occupants and his version of honestly belief. And that, in conjunction with our 3%, Madam Speaker, is a troubling tale to tell. It's a troubling thought. With no duty to retreat, people may feel legally authorized to shoot first in situations, Madam Speaker, of confusion, noise, intoxication, and mental distress or illness. Shoot first. Madam Speaker, I don't know about anybody else, but I have never opened my door in the morning and seen a tumbleweed blowing. I've never seen it. I could go even further, Madam Speaker, because international evidence shows that when you combine no duty to retreat with subjective fear, the result is more killing, which includes more killing of unarmed people. Madam Speaker, allow me to address the elephant in the room yet again. Madam Speaker, there exists a serious risk of class and racial bias in this practice and incorporating this piece of legislation into Trinidad and Tobago. Madam Speaker, empirical studies in the US shows that stand your ground laws, they produce racially uneven patterns in which killings are ruled justified. And that, Madam Speaker, they want to bring into Trinidad and Tobago, where policing, housing, and social inequalities already map onto class and race. This is a serious risk, Madam Speaker, because if we truly look at it, murders in upscale communities are more readily accepted as self-defense as compared to killings in places like Lavantelis-Mova and how they are treated. They are either under-investigated or they may be selectively prosecuted. Madam Speaker, to go a little deeper on class, inequality, inequity of justice and parity, we have numerous examples right before us in Trinidad and Tobago, countless examples that it exists. We can easily look at the mere fact that we had a former COP who referred to people as cockroaches. That is a troubling thought. And we see the impact of how they treated people throughout the SOE and COVID-19. And I say this because there was a disparity that existed between people that might have been taking a sea bath and those in the private pool parties. We saw how they were treated. We saw it. And, Mr. Speaker, we can even return to the SOE imposed by the then government in August 2011. And the data showed that there was inequality and inequity exercised there as well. I know people that sued the state because of how they were treated and won. Madam Speaker, this is a serious issue. This is a very serious issue. These are the issues that we face, Madam Speaker. This is something, Madam Speaker, that I think this faulty legislation can only unintentionally exacerbate And if the only virtue of race talking and political rhetoric in anything is to gauge, Madam Speaker, is the worrying thought that with more guns, it moves from online to offline and to in-person engagement. Madam Speaker, I asked myself, had they even thought about the type of pressure that this piece of legislation is going to put on the Trinidad and Tobago Police Service and the DPP. This bill now gives the court a long list of factors to weigh, when deciding if force was reasonable, but they gave no procedural guidance towards it. And I say this because there is no special review, no data collection, no reporting clauses, nothing. Just a piece of legislation brought to the House. Please accept this. Please sign on. Please say yes to this opposition. Can't do that. Madam Speaker, experience from Florida, yet again, it shows that stand your ground rules can complicate investigations and it shifts the burden onto the state. What does that result in? More pressure on who? Madam Speaker, this is no laughing matter. This is no laughing matter. I ask yet again, did the government think about the risks to the police and the first responders and what they will be experiencing with implementing this piece of legislation? Now, this bill has exceptions for law enforcement, but, Madam Speaker, it depends on whether the occupant knew or reasonably should have known that the person was indeed law enforcement. Madam Deputy Speaker, and I say this because we must think about it practically. In a real life situation, raids, issuance of warrants are usually carried out in what type of environment? Low light, noisy, chaotic situations. And this by itself presents a real risk that in exercising his duty, there can be a result of traumatic crossfire between law enforcement and a frightened resident. It is a real fact and a real possibility that has unfortunately been overlooked by the government. Like I said, Madam Deputy Speaker, the advocacy that accompanies this legislation is unheard of, and there exist immense gaps and unintended consequences to this piece of legislation. There exists no requirement to collect data and to publish data. And as I said earlier, legislation must be data-driven. If you really want to see change, it must be data-driven. There exists no clause that requires the state to track anything at all. For example, how many people are killed under these provisions? The race, the sex of these people, the age, the area, the social background, whether the victims were armed, unarmed, nothing. And without this, Madam Deputy Speaker, this Parliament, there is no way for us to know whether this law is actually reducing crime or fueling vigilante killings. There is no measure. There is no built-in review clause, Madam Speaker, Madam Deputy Speaker. No built-in review clause. And given the serious risks shown in the peer reviews, that evidence, I believe that there is a required need for an independent body, an independent review body.
Would you like your additional time, Member?
Yes, please. Madam Deputy Speaker, These gaps are alarming. Another one, Madam Deputy Speaker, overlooked. What about the domestic violence dynamics? Where both parties may have a right to be here. I have a right to be here. This was clearly not addressed. And to elaborate a bit, we can all admit that we have a very long-standing cultural motif, if I may, of land disputes within our East Indian communities. We have all seen it. We all know it is usually settled wielding cutlasses and brandishing cutlasses. Yes. Not no. We could say that. We can say that. And what is that to say now, Madam Deputy Speaker? Would this now escalate the situation from cutlass brandishing to yielding pistols in a more violent manner? Because both of us can now stand our ground. And if we are speaking about the family, Madam Deputy Speaker, what about the children? What about the children? If we increasingly expose these weapons and this thought, Madam Deputy Speaker, of exposing these kids to weapons and the thought of violence, raising them in that environment, it can easily result in weapons, more firearms, finding their way into the school bags and into the compound. And that by itself can now escalate a regular schoolyard fight, fist fight, I should say, into what? Into what? You may not see the connection, sir, because you don't think far. But it will escalate fist fights into mass shootings. And I'm not speaking just because I want to say it. I am speaking because I have first-hand experience dealing with the nation's children. I've worked years in the schools, and I can tell you, not ever once was a violent situation or a violent child calmed down with more violence. You see, what the government overlooked, Madam Deputy Speaker, is the mere fact that we live in a very unique culture. We have a very unique community context. And what I'm about to say next, I would hope that the government goes back to the Hansard and they read it 5 times, 10 times, 11 times, 20 times, as many times as they would like to clearly understand that Trinidad and Tobago is not Florida. It is not Florida. We already have very high homicide rates, an average of 37.2 per 100, and that is data between 2018 and 2022. And we already have a limited capacity for scientific policing, crime scene management, and unbiased investigations. So, Madam Deputy Speaker, importing this risky model into this type of environment without heavy safeguards is dangerous. There are no safeguards. But I understand why this government would bring such risky law into the country. I would understand why. Because to know where you're heading, you have to know where you've been. And my friends on the other side would have people think that history, Madam Speaker, in my 15 minutes, I would like protection from Toko Sandigrandi, please. Madam Speaker, I would like protection from Toko Sandigrandi, please. I was quiet while he was saying whatever he was saying.
Yes, member, please continue.
Thank you very much. So my friends on the other side would have you believe that history only goes 10 years back. Every 3 seconds, every 2 seconds, 10 years, 10 years, 10 years.
Madam Deputy Speaker, a point of order, 53(1)(e). The member is entitled to speak in silence.
Let's let the member complete his contribution in relative silence.
Madam Speaker, as I was saying, they would have everybody in the country believe that history only goes back 10 years, as all their comments, everything that they brought forth, goes back 10 years, 10 years, 10 years, 10 years. Madam Speaker, I believe that the people listening need to understand clearly what brought us to where we are today. And to be quite clear, Madam Speaker, and specific, between 2010 and 2015, under this very government, led by Ms. Kamala Persad-Bissessar, the UNC single-handedly dismantled our security architecture that was built to protect this
Madam
nation.
Deputy Speaker, 48-1, please.
I agree, member. Let's make good use of your remaining time.
Madam Speaker, I knew it would have aggravated my good colleague from Cooper South. I knew that, because the truth often offends. What I would urge, you know, I find it ironic. I find it ironic. Madam Speaker, my simple 15 minutes, I would like to reclaim my time because it cannot stop. So I would seek your protection again, Madam Speaker.
Again, let us let the member complete his contribution in relative silence, and no additional time will be given.
Thank you. Madam Speaker, the good member from Orpoch East, he made mention to amendments. Well, ask and you shall receive, because clearly you all needed the assistance. So I hope you have your pen, hope you have your paper. One, I would hope that you amend clause 7.4 so that deadly force is permitted only where there is a reasonable belief of imminent threat to life or grievous bodily harm, and not to property. You must, and I insist, consider to add strong proportionality test into the defense of property. Why not just mirror the factor of clause 6.2 and explicitly require that the risk to life posed by the Defensive Act be weighed against the value and nature of the property? What we also require, member, is mandatory data collection and reporting as a clause. That is what we require. We must be a data-driven country if it is we need to get into first world status. I know data is a strange concept and a strange word, but this is what we need. And you must involve the TTPS and the DPP. All incidences where self-defense and defense of property under this act must be recorded, along with the demographics of these victims, the accused, the outcomes of the charges, which would be whether they are charged, not charged, convicted, acquitted, whatever. And you must have a clause for independent review. You asked for recommendations. You said that we brought none. So here we are. Here we are. What about implementing mandatory training and public education? And I say this strictly based on the fact of how this bill was sold to the public in the first place. Your leader was on a pulpit saying, load up the matic. How is that something to utter to a nation as an self-proclaimed loving mother? This is what you stand behind. And I can tell you for a fact that I will not feel well knowing that you put legislation before me where somebody is allowed to brutally kill somebody for an object. I will not feel good knowing that my daughter or my son is brutally gunned down because he walked too close to somebody's home or their car. Or, like my good colleague from Library would have mentioned, climb a tree and pick a fruit and then get shoot like a bird out a tree. Madam Deputy Speaker, I know my colleague from Toko Sandigrande is eager to add some more of the nothing that he was saying, but I would ask him to sit there and be quiet while I finish. Madam Speaker, you see, this law and how it was sold, it requires education to the public. And the first thing that must be said to the public is that this does not generate and grant a license to kill. You must explain to the public that it does not create a constitutional right to bear arms, because this is the perception that is given to the general public based on the negligence that you exercised when communicating to them. I know you wanted to win an election, but we are all adults here and we are leaders, and your words are heavy. It does not protect criminals or people using grossly disproportional force. This also must be communicated. And you must implement stronger safeguards for law enforcement. You must also explicitly, even though it is mentioned in Clause 9, you must do so explicitly with respect to domestic violence and its misuse. You see, Madam Deputy Speaker, this bill, this piece of legislation that they want to bring to Trinidad and Tobago, it does way more harm than good. And they can say what they want, but the law reform has already shown and proved that they got this directly from Florida and the United States of America. The data is there. I do not know what makes them say or think that there's going to be a different result when we bring it to Trinidad and Tobago. I am saying this on behalf of the people of Lavantelis Mover. Madam Deputy Speaker, there's a lot more that I can say. But what I will close with today, Madam Deputy Speaker, as we sit on these benches, I will reinforce the fact that we are happy to support good legislation, and we actually want laws that protect people from bandits, but we do not want And we will not accept any law that makes it easier for people to die. Thank you, Madam Speaker.
Member for Couva South.
Thank you, Madam Speaker. Madam Speaker, the member for Laventille West, who just spoke, East Mover, my apologies, member for Laventille East Mover, who spoke just before I rose to contribute. I always saw that he was one of the more astute members on the opposition. And I'm quite disappointed that he proved me wrong. Madam Deputy Speaker, there were two main things that came out of the contribution from the honourable member. And there's a thread, a common thread, across several opposition members who have spoken thus far on the two main points that the member for Laventille East Mover spoke on. One had to do with fear-mongering, speaking to the issue that this bill creates an opportunity for more killing. And the second one, which was more disturbing, because I'm trying to figure out where my colleagues opposite are going with this argument. And that has to do with the issue of race baiting. Race baiting in this society. It did not work in the general election for you, and it certainly will not work this time around, Madam Deputy Speaker. Madam Deputy Speaker, the honourable member made very few points, but the member spoke about data and data collection. Maybe the newness of the member to the Honourable House does not put him in a position to understand that there are areas in the TTPS that provides for the collection of this type of data, and an annual report from the TTPS is laid in this very House, Madam Deputy Speaker. So it puts to rest any concern with respect to data collection in terms of the uses of this legislation when the legislation is passed today. But I want to give my friend from Laventille East Mover the benefit of the doubt that he did not know that. But, Madam Deputy Speaker, when members opposite speak about slothfulness and laziness, that is a representation of slothfulness and laziness. Madam Deputy Speaker, it appears as though that the opposition don't caucus with their members. Because the member for Laventille East Mover attempted something of the sort of providing amendments on the floor of the House. Everyone knows there's a process, there's a procedure, and not one member, particularly those who have served in government, who spoke on this bill today from the opposition, advance any amendment? None. But, Madam Speaker, we are not surprised. Again, if you want a representation, to use the words of the opposition, of slothfulness and laziness, that is what we saw from members opposite. And therefore, they were in a state of confusion when the member for Laventille East Mover spoke. There was a total state of confusion. Opposite the government bench, members of the opposition started to look at each other. What was happening here? It's a clear case of the left hand doesn't know what the right hand is doing. And therefore today, when they come speaking on both sides of their mouths, cannot put together a coherent argument as to why they don't support the legislation. They go to their fallback position of what? Fear-mongering and race-baiting. That is what they go back on to. Madam Deputy Speaker, I had no intention of joining the debate today. But I simply could not
sit and listen to the hogwash from members opposite. I heard my colleague from Labre speak very passionately from a personal perspective, having been a victim of home invasion. Madam Deputy Speaker, I want to join in my own personal reflection by saying, I too know what that feels like. And it is only, in local parlance, we say, it's only when you're in it, then you know it. Not one member today advanced any new policy, any new idea. And they're most upset when we say 10 years have passed and you have said and done nothing. But that is the reality. That is the reality, Madam Deputy Speaker. Madam Deputy Speaker, I say that in the context that very few administrations post-colonialism in Trinidad and Tobago has ever received a constitutional majority. The member for Laventille East Mova attempted to speak disparagingly about the Honorable Prime Minister. I want to tell them, you can try as hard as you can never step in the shoes of the Honorable Member for Parliament. Never. None of you opposite have demonstrated the fortitude, the strength, and the determination to do what the member of Separia is doing today with the United National Congress administration. Mr. Speaker, I made the point, very few administrations have received a constitutional majority from the electorate in Trinidad and Tobago. And it takes me directly to the bill, because it tells us where do we get the platform, the legal standing, the strength, the determination to pass this piece of legislation. We didn't fill a small maxi taxi. We have 28 seats sitting on the side of government. The member for Laventille East Mova spoke ad nauseum about the general election campaign. Yes, this was one of the main pillars that the United National Congress campaigned on for the general election. Mr. Speaker, with 28 seats in the House of Representatives, we feel emboldened that within our first year that we have kept the promise of bringing this legislation as a way of protecting citizens against home invasion. Mr. Speaker, right off the bat, in my contribution, I want to say to you, I want to speak to two particular clauses. I know colleagues on this side of the House have spoken to several other clauses, but I will confine my contribution to Clause 5 and Clause 6 and share with you why I felt compelled, particularly as the Minister of Public Utilities, to stand up in the Parliament and speak today. Mr. Speaker, from time to time, while serving in opposition, we attempted to advance ideas that would assist in the administration of Trinidad and Tobago, particularly dealing with the issue of crime. And we were often told, but those things are on the statute books already, what nonsense you're talking. Today, we have taken the position that stand-alone legislation is needed. No, stand-alone legislation is needed. Yes, stand your ground too. But there are areas in the law where there are loopholes. And therefore, this administration is taking the bold and courageous step to bring stand-alone legislation on particular serious matters, and stand your ground, and home invasion is one of them. The political will demonstrated by members opposite, Mr. Deputy Speaker, was woefully low and short like some of their members. Mr. Speaker, I mentioned earlier that I was particularly concerned because when I saw in Clause 5, it treats with an issue that we have heard about time and time again. And as the Minister of Public Utilities, with responsibility for WASA, TNTEC, TT Post, whose workers from time to time visit homes of citizens, when I read Clause 5, Mr. Speaker, and I looked at item C, which speaks to fraudulently representing oneself to be a member for a law enforcement authority or a representative of any other public or private entity for the purpose of gaining entry into an occupied dwelling house, it jogged my memory of how many instances we have had in this country where persons fraudulently represented themselves as WASA workers, as TNTEC workers, as TT Post workers, and as police officers to invade the homes of citizens and brutally rob, rape, and in some instances, murder citizens. And this is a very progressive and forward-thinking piece of legislation, Mr. Speaker. I want to take the opportunity to congratulate the Honorable Attorney General, the Minister of National Security, the Minister of Defense, but more so the Honorable Prime Minister. We said to the nation that we would have brought this legislation in September, laid the legislation in September. The Honorable Prime Minister mandated every member of the government serving as a representative of the people to go out there and engage their constituents. That was a mandate from the Honorable Member for Siparia. And today, Mr. Speaker, we feel emboldened that we can bring this legislation, having promised it in September, knowing fully well that we took a few weeks more to bring it, but we took the steps that were necessary to engage the people of Trinidad and Tobago once more. You see, they gave us that constitutional majority with 28 seats, 26 with the United National Congress, and we are very happy to have the 2 members from Tobago joining the government on this side. Those are responsible members who are interested in the welfare and safety of their constituents. So that was the first test, Mr. Speaker, where we received the constitutional majority. We received the mandate of the people, and that is why we are here to bring this legislation, because the people of Trinidad and Tobago supported it. They bought into it, they understood, they went in with their eyes wide open in that general election. So when the member for Laventille East Mover wants to tell us that people are concerned about the killings and so on, we explained to them exactly how this legislation will work. But the only fallback position they have, as I've said before and I'll repeat it, is fear-mongering and race-baiting. Mr. Speaker, the second bite of the cherry came when the member for Siparia allowed us as elected members to hold those consultations. People attended in their hundreds, these consultations. There is a yearning in our society, Mr. Speaker, for something to be done. Trinbagonians have become numb in many instances to the lack of support and the advancement of any workable ideas from the opposition when they were in government. And therefore today, having received that support in the general election, going back to the people through these consultations, we have brought this legislation knowing fully well that the population now understands that drastic time calls for drastic measures. But, Mr. Speaker, I want to address another issue that the member for Laventille East Mover spoke about. And the honourable member spoke about the license to kill. and that the Florida model will open up a floodgate for murders and killings through home invasion. Mr. Speaker, I refer to an article written in the Trinidad Newsday with the headline, "No License to Kill, Burden of Stand Your Ground." The Honorable Attorney General, to give credit to where credit is due, he is not here today, but a member for Barataria San Juan, the Minister of Homeland Security, and others, inclusive of the Honorable Prime Minister, has spoken ad nauseum about the protection and safeguards, and the member spoke indicating that there were no protections and there were no safeguards in the current legislation. Had the member done a bit more research, spoken to colleagues, attempted to review the bill in its entirety, the member would have seen the safeguards in the legislation, Mr. Speaker. Mr. Speaker, if you allow me to quote from Trinidad Newsday, Tuesday, 19th August, quoting the Honorable Attorney General, it says, "Stand your ground legislation designed to protect people from the threat of home invasion does not give them free license to kill anyone who enters their property. The limitations which prevent this are outlined in the Home Invasion, Self-Defense and Defense of Property Bill 2025, which is posted in the Ministry of the Attorney General and Legal Affairs website. They include homeowners being under the influence of drugs when they threaten or use force against an intruder, and homeowners threatening or using force against law enforcement officers executing their duties." And the member for Laventille East Mover spoke about these law enforcement officers. What about the flip side to that? The impersonation of law enforcement officers. I mentioned earlier that DILT's bill provides for the protection of citizens against those who fraudulently misrepresent law enforcement officers. Mr. Speaker, I don't have to go through all these screaming headlines, all the bloody murders that have occurred through home invasions by persons fraudulently representing law enforcement officers. This has become a serious issue. Under colleagues opposite, Mr. Speaker, home invasions occurred in this country by persons misrepresenting law enforcement officers with authentic police uniform. That happened under them, Mr. Speaker. Wearing authentic police uniform, using guns, ammunition, belonging to the Trinidad and Tobago Police Service. Not by bona fide Trinidad and Tobago Police Service officers, but by those misrepresenting those officers. When my colleague, the member for Tunapuna, tells the population that the safeguards are that we have to ensure that persons who are misrepresenting law enforcement are treated within this bill, that is only the opening salvo. The other salvo is the operational element of ensuring that uniforms, guns, and ammunition do not fall into the hands of these people who are fraudulently representing law enforcement officers. But also, I can tell you, Mr. Speaker, this government does not operate in silos. We saw that happen with our colleagues opposite, where the left hand never spoke to the right hand. And therefore, all manner of things were happening under state enterprises and ministries. What we have been attempting to do is working with Homeland Security, Defense, and others through the Ministry of Public Utilities, that when workers that fall under Clause 5C, when they have to go and visit bona fide workers I'm speaking of, there must be a mechanism There must be communication with the Trinidad and Tobago Police Service. That wasn't happening under them. And therefore, it happened time and time again, Mr. Speaker, where persons did not only misrepresent themselves as law enforcement, they misrepresented themselves to gain entry, to rob, rape, murder, and plunder innocent citizens under the guise that they were going to do work in the water sector, in the electricity sector. Mr. Speaker, this requires an all-of-government approach, and I can tell you with certainty, we are not operating in silos, and therefore when the Honorable Attorney General addresses these matters in the bill, I did not hear one member, not one member, speak to the provisions in the bill that gives clarity, purpose, and precision in terms of the protection of citizens as it relates to some of the issues that I have identified, Mr. Speaker. Not one of them. I could stand up in this Parliament at 9:35 this evening and raise an entirely new issue. Mr. Speaker, we have heard from many members across the floor, but if you want a representation of laziness and slothfulness, they repeated the same points over and over and over again with the hope that the population will buy into this fear-mongering. Mr. Speaker, citizens, frankly, I can tell you in Couva South, they are fed up of the talk. They want action now. And therefore, the legislative support today that we are giving to citizens will not create a floodgate or a crisis, Mr. Speaker. Mr. Speaker, there's a process, and the member for Laventille, East Mover, and others spoke about the issuance of these firearms users' license. How will one protect themselves in the home? And there have been several instances in the bill under, I believe it is clause 5, again, that treats with the weapons or the tools that citizens can use to protect themselves. But the members opposite want Trinidad and Tobago to believe that we want a Wild Wild West society. Nothing is further from the truth. The provisions in law still provide for the Commissioner of Police to be the person to issue firearms users' license in this country. We have said, again on the campaign, that once you fit the criteria, whether it is on the operational side, the psychometric side, there's a process and a procedure for the issuance of firearm license in this country. That has not changed. What has changed is the political will to ensure that citizens who meet the requirement are allowed to protect themselves. And you ask yourselves, why are you so opposed to that, members of the opposition? They were found it very disparaging that I saw the member for Ruka Lopino took to social media about an hour or two ago that the Honorable Attorney General spoke about those who have firearms and those who don't. And I issued a warning earlier in today's sitting, Mr. Speaker. Be careful of what you ask for, because you may get the answer you don't want. Because you still have the Honorable Attorney General to wrap up the bill, you know. So if you want name, you could very well get name. You want to know who had 3 and 4? We could very well tell you that. But while you were protecting yourselves and your own families with blue lights and security and special branch sitting down at your door and sitting down in classrooms with your children, what happened to the lady down in Labrie? What happened to the man in Laventille? So ask yourselves, members of the opposition who raises this issue, who are you really serving, yourself or the people who elected you? Because to every right-thinking citizen who listened to the contribution from members opposite, all you heard was race-baiting, fear-mongering, and I'll add one more, a self-serving opposition who were concerned about what the AG had to say to them, but as I told them, be careful of what you wish for and what you ask for. Mr. Speaker, in this same article, and we speak about the protections in the legislation, it says other limitations include the nature of the force or threat being used against the occupant, the extent to which the force was imminent, whether a weapon, firearm, or explosive device was used in the home invasion, the size, age, gender, and physical capabilities of the parties. The member for Laventille East Mover spoke about people passing on the side of the road and knock you down and hit you. Mr. Speaker, the legislation is very specific. The legislation deals with home invasion. It gives you a description of the persons under which this law will seek to empower and protect, Mr. Speaker. Mr. Speaker, it goes on to say, stand your wrong legislation and easier access to legally issued firearms were the UNC's main campaign promises with respect to tackling crime ahead of the general election. Mr. Speaker, what we are doing today is the will of the people of Trinidad and Tobago. And their lack of support means they are subverting the will of the people of Trinidad and Tobago. It's a subversion. Your lack of support is a clear subversion. Mr. Speaker, in that context, the bill provides that a person has no duty to retreat when operating in self-defense or defense of his property, to provide that a person may use defensive force, including deadly force, to protect himself or his property. Mr. Speaker, let us go to property. Let us also look at Clause 6 in the bill. And Clause 6 gives a clear indication of what we mean by dwelling house, what we mean by property. Another point that no one has sought to raise in today's debate has to do with the commercial side of this. The commercial side where in many homes in Trinidad and Tobago, people operate business from downstairs of their house. You see the member for Urupuch East shaking his head. I remember in Urupuch East, there was a situation, there was a company called Big Boys Toys. It was about trucks and so on, Mr. Speaker. It was about trucks, it was about vans, it was about vehicles, etc. And the company was run under the house of the owners. The maid and the children of the home, they were roughly about 7 or 9 years old. The home was invaded through the business. They then went up. The children and the maid was locked in a room, calling the police. And in true typical fashion, the police under the TPS, having been starved for resources, could not reach in time. And the children were calling their parents, who were in another country at that time, begging, pleading for help. What do you say to those children today, member for Roodal? What do you say to those children today, member for Laventille East Mova? If that was your children, would you still take the position that you're adopting today? I'm almost certain you would not. You have asked us to take the emotion out of it. I started off by telling you is when you're in it, then you know it. Yes,
Thank
Mr.
you.
Speaker. Mr. Speaker, I essentially stood to speak for just 10 minutes. Did not envision it would have gone so quickly. But Mr. Speaker, it has to do with a commercial mixed dwelling. And we have had a serious problem. I've heard the member again, I'll reference the member for Lebre, speak about rural communities. On this side of the house, we represent most of the rural communities in Trinidad and Tobago. Most of the rural communities is represented in the government. No one spoke to the issue of predial larceny. No one spoke to the plight of farmers who have endured losses in the hundreds of thousands, if not millions of dollars, that have also encountered beatings, the rapes of family members, the trauma. Mr. Speaker, I will tell you about the trauma. For 6 months, I did not live in my own house. Why? When that home invasion occurred, you always keep at the back of your mind. They know where you're living. They know who's living inside of the house. They have been there before, so they know the layout of the home. Mr. Speaker, when we tell you that we can take emotion out of it by looking at the clauses of the bill that objectively treats and deals with the specific circumstances, the dwellings, the tools used in self-defense, the items that fall under Clause 5A to I under Clause 5. We have taken the emotion out of it, and we have done the work. And therefore, we lend our support to the Honorable Attorney General, not out of emotion, but understanding that today what we are doing is a step in the right direction. We are creating history today. Mr. Speaker, I'll tell you this. I spent 10 years in opposition. Sometimes it feels a little, you feel helpless when your constituents come. And you yourself have endured some of the experiences that they have now endured through these home invasions. But it gives us the opportunity today to do something about it. And we are demonstrating our political will. Mr. Speaker, I will go as far as to say, as a member for Couva South, if this legislation operationally fails, I would have still been satisfied that I tried, that our government tried, that we gave citizens the best opportunity to protect themselves. It cannot be that we continue to speak ad nauseum, find faults with the bill, sit down and in government having done nothing for 10 years to protect our nation's citizens, and then say, well, let's go back to the drawing board. You all could come up with something better. There must be other alternatives. The member for Laventille East Mova spoke about the Florida model. I want to tell you, it is on the public record that the Honorable Prime Minister said we were looking at the Florida model. We never hit that. We understand.
Laventille East Mova. This is very uncharacteristic of you. All right. I'm not seeing Chaguanas East, but I'm seeing you. San Fernando East. I don't think you really want me to answer you. All right, so Laventille Mova, this is very uncharacteristic of you. Member, continue.
Thank you, Mr. Speaker. Mr. Speaker, I was making the point that even if operationally the legislation does not pan out the way that we hope it would, we have demonstrated the political will today that we are willing to do something about the issue that is affecting Trinidad and Tobago. Mr. Speaker, I referred to an article earlier, and I want to deal with the issue of Clause 7 of the bill, which says that the occupant must also believe that his actions were necessary and reasonable to defend or protect himself or another person from the use of threat or force, and that the defensive force used was proportionate to threat he honestly believed to exist. The member for Urupuch East dealt extensively with that. But it also goes on to say, for the purpose of self-defense during a home invasion, the bill states, the use of deadly force may be justified where an occupant reasonably believes such force is necessary to prevent what? To prevent what, Mr. Speaker? Imminent death, imminent grievous bodily harm, grievous sexual assault or rape. Clause 8 of the bill makes allowances for a person's right to defend his or her property. Mr. Speaker, for all of us who have children under the age of 18, whether you want to categorize them as property or not, in reality, that is what they are to us. And in the circumstances of imminent death, imminent grievous bodily harm as contained in the legislation, there's no right-thinking citizen in Trinidad and Tobago that will tell you that if your child, your loved ones, are at the mercy of criminals, that you will not take any reasonable step to protect them. Mr. Speaker, as I started earlier, I said I really wanted to deal with Clause 5 and 6 by introducing those new issues that were not traversed before. But putting this bill into context today, having been a victim of home invasion, I told you I did not live in my home for 6 months. And that is something that stays with you every single day of your life. You turn around, you see sometimes shadows where no shadows exist. Every phone call from your child's school, you are apprehensive because you don't know what they're calling you to tell you about the safety and well-being of those that you care most about. And as I've said before, we have taken the emotion out of it, but we are driven by the mandate that we have received from the population to effectively deal with an issue that has reached the doorstep of not only myself as a member for Cuba South, not only the member for La Brea, but many ordinary citizens who cannot speak for themselves inside of this parliament. And today we are speaking on their behalf and we are doing something about it. Mr. Speaker, make no mistake. This is not old talk. This is not rhetoric. This is legislation that comes less than 1 year under a United National Congress led by the member for Siparia. There was a time, Mr. Speaker, that they used to tell us, keep Siparia right there. We have kept Siparia right here. We have kept her here. And she has provided us with the leadership, the vision, the determination, but most importantly, Mr. Speaker, the courage and the conviction to address frontally one of the most burning issues that is impacting the ordinary man, woman, and child in this country, and that is the issue of home invasion. Prime Minister, in your absence, Mr. Speaker, she may not be in the chamber, she's at a meeting right now, but she is in the House of Representatives. Prime Minister, I say through you, Mr. Speaker, the country has said to you, do the right thing because it is the right thing to do. Mr. Speaker, the country has said to the Honorable Prime Minister that through the mandate they have given to her, take the necessary steps to protect property, life, and limb. And that is what the member for Siparia and our government is doing here today. Mr. Speaker, I will tell you what we are not doing here today. We are not directing anyone to go and jump on a plane to kidnap citizens in Barbados. We are not pulling merit lists from President's house in the selection of a commissioner of police. We are working within the ambit of the law and passing new revolutionary law to ensure that citizens can feel a sense of safety and security, which is the first responsibility of any government. I say hats off to the Honourable Prime Minister, the Attorney General, and the ministers who form the cluster of national security, Homeland Security and others, and to all colleagues for standing up bravely, boldly, and hold your heads high, because what we are doing here today will be remembered for many lifetimes to come when we continue to push and provide progress in the advancement and protection of our nation's children and our nation's citizens. Hold your heads high. If there's anyone to hold their heads in shame, it is the members opposite, Mr. Speaker. Mr. Speaker, with those words, I thank you.
Diego Martin, Northeast.
Mr. Speaker, listening to the contribution from the member for Couva South and the contribution from the member for Labrie, the declaration by the member for Couva South that the contributions of the government on this piece of legislation have not been emotional is a figment of their imagination. In fact, the member for Couva South spent the last 45 minutes screaming at us. Now, the government has expressed a point of view with respect to this legislation. Members of the government have insisted that this legislation is necessary. And the argument presented is that it is necessary for people to defend themselves, their families, their friends, and their property. And that it is necessary to give people the right to use deadly force to protect themselves, their family, and their property, and their friends, and so on. The member for Labrie in particular did not refer to a single clause in the bill. Not one. The member for Labrie did not justify his presentation by any reference to a clause in the bill. And in fact made a most astonishing statement that...
Mr. Speaker, just give me a minute, I'll find it. Mr. Speaker, I stand on...
Yes, a quota standing order?
Yes. I stand on...
Number which?
Mr. Speaker.
Member, can I hear you? Can I hear your interjection?
Mr. Speaker, I stand on 48. Let me just find it. 48.6. Yes? Mr.
Thank you, Mr. Speaker. Wow. Before I was interrupted, Mr. Speaker, I was about to make the point. All right, Mr. Speaker, I may have to start to ask for your protection from day one from both sides of the House.
It would appear you need protection more from your own side. That's what it would appear to me.
The member, thank you, Mr. Speaker. The member for Labrie carried on at a rate about the allegation, because it is not a fact, that the government held consultations and they listened to the people. And because of that, this bill is different to what was there before. Because they listen to the people. Because that is what they do. They listen. Mr. Speaker, that is the most astonishing, ridiculous, absurd, and just plainly wrong assertion that I have heard in this parliament for a very long time. I am satisfied now that the member for Labrie has not read this bill. I am satisfied that the member for Labrie, Mr. Speaker, I have to ask for protection from both sides of the House. I have to ask you.
I think you need to get your chief whip to crack the whip on your own side.
This, in my opinion, with great respect, is not a laughing matter. The member for look at this going on right now. Yeah,
come on.
So it's not just my side. So I'm also satisfied that the member for Labrie did not read the original copy of this bill, the one that was sent out in July of 2025. Because if that honourable member had read the bill circulated for public comment, which was the subject of consultation, the only difference between that bill and this one was clause 2 of that original bill, which reads as follows: this act shall have effect even though inconsistent with sections 4 and 5 of the Constitution. That's the only difference. So, Mr. Speaker, am I to believe that in these consultations where hundreds of people attended, these hundreds of people demanded that the constitutional protection that was in the first bill should be removed? It just proves that they haven't read this. They haven't read this bill or the one before. And come to this parliament to mislead and misinform the public about how they listen to the people. There is no way a right-thinking member of the public would demand removal of constitutional protection from the bill. The bill dealt with the whole question of section 4 and 5. And that brings me to the point, Mr. Speaker. There is a question that needs to be answered. And you have to wonder why the bill had a special majority provision in it first and no longer has that. And I really think a proper examination has to be done of section 4 of the Constitution, in particularly the right to protection of life without being deprived of it without due process of law. And I have a feeling, this is just my opinion, that clause 7, which I wish the member for Labrie had read, that clause 7(4) may offend section 4 of the Constitution, because section 4 says as follows: for the purposes of this section, the use of deadly force may be justified when occupant honestly believes that using or threatening to use such force is reasonably necessary to prevent or remove a home invader from his dwelling house or to protect his property or that of another person. Don't you need a constitutional majority for that? That you could kill somebody because you want to protect your property? I think the constitutional lawyers need to think about that. And what I find odd, the right to life. I don't see how you could give somebody the right to kill someone to protect your property, and worse yet, the property of somebody else. Now, if you look at clause 7, there are some issues here, because clause 7(1) says that you can use defensive force. And when one looks at the definition of defensive force is the justifiable and reasonable use of force by a person acting in self-defense, in defense of property, or in defense of another person. Now that kind of makes sense. But why in 7(4), the same clause, you now could use deadly force? So in 7(1), you are being permitted to use defensive force, but in 7(4), you're allowed to use deadly force to do the same thing. So I think the constitutional lawyers need to take a look at that. The other issue that seems to be coming across is what is the reason for this legislation? We've heard the members opposite say that it is to allow people to defend themselves, to defend their lives against invaders and so on. And Mr. Speaker, no one on this side is trying to trivialize home invasion. There are members on this side who have also been victims of home invasion in urban areas. So it is not restricted to rural areas. It's all over the country. And there are members on this side who have been the victims of home invasion. So nobody is trying to trivialize a very, very serious matter. But when I listen to what the Attorney General said, and I have the Hansard, and I read from the Hansard, the government intends to protect these citizens, the citizens that would be affected by this legislation, in a number of ways. One of which is the tabling, laying and tabling, well, he says it twice, of the legislation that is before us. Another of which is to ensure that those citizens who qualify are able to get licensed firearms commensurate with the threat to their persons, their families, and their friends. And then the Attorney General goes on to say, practically all of the members on the front bench opposite, practically all, have not one, not two, not three, sometimes 4 and 5 firearms. Yet they tell ordinary citizens, none for you. That is a blatant untruth. A blatant untruth. And, Mr. Speaker, the Attorney General cannot rely on the style of the Minister of Homeland Security and say that practically all means half the most. It does not. The legal definition, the English definition of practically all means almost everything, the vast majority. And I can say without fear of contradiction that the vast majority of members on this side do not have 2, 3, 4 guns. Several of us have none. And I would like to know, how did the Attorney General get this information? How did he get this information? I thought that was personal and private information that is under the control of the Commissioner of Police. But let me go back to what he was saying. Another of which is to ensure that those citizens who qualify are able to get licensed firearms, commensurate with the threat to their persons, their families, and their friends. And I heard a contradictory statement from the member for Couva South. And the member for Couva South referred to the fact that the granting of firearm licenses is a matter for the Commissioner of Police. I will now read the Firearms Act, Section 17. Subject to this section and to Section 16, the grant of any license, certificate, or permit shall be in the discretion of the Commissioner of Police. The sole discretion. It is the Commissioner of Police, and this is my knowledge, having been a member of this House for over 33 years, that the discretion to grant a firearms user's license rests entirely in the Commissioner of Police. No government could compel any Commissioner of Police to give anybody a firearm. So why is the Attorney General and the member for Couva South saying that they want to ensure that those citizens who qualify are able to get licensed firearms commensurate with the threat to their persons, their families? Who is going to determine that? Is the government now going to determine the threat to persons, their families, and their friends? And is the government now going to decide who gets a firearm license or not, as the case may be? Is the government now going to tell the Commissioner of Police who should get a firearm or not? And you see, this brings me to a particular point. Because when you do the research on this legislation, a number of things pop up. My colleagues have referred to a lot of the learning on this matter. But I would like to refer to a particular thing. In the United States, the member for Couva South has confirmed that this legislation is borrowed or flows from the Florida Stand Your Ground law. So I would like to quote from an article by an entity called Every Town, and the article is entitled, "The Dangers of Shooting First. Stand Your Ground Laws Are a License to Kill." That's the title. 25th of January 2021, last updated 21st of July 2025. And I quote, "For centuries, self-defense laws have given the people the right to protect themselves. Shoot first laws," and you see there are different points of view. I heard the member for Labre in his impassioned speech say that this is not legislation to give people a license to kill. That's a point of view. But there are other points of view. And there's a very strong point of view in the United States, in Florida, from whence this legislation has been borrowed, as follows. Shoot first laws, also known as stand your ground laws, go beyond these long-standing principles, aggressively altering criminal law to shield a person who claims self-defense from being arrested, prosecuted, or convicted for using deadly force. In 2005, Florida enacted the first modern shoot first law, an effort backed by the National Rifle Association, during a time when they were making concerted efforts to reverse declining gun sales. Working with the gun lobby, the American Legislative Exchange Council pushed to turn Florida's law into a template for a national campaign. Now, in 29 states, these laws change the nature of self-defense, turning everyday disputes into deadly confrontations. Far from empowering victims, shoot first laws lower the threshold for justifiable homicide, encouraging the escalation of petty arguments and armed vigilantism. Although the gun lobby created these laws under the pretense of empowering and protecting victims of crime, the data overwhelmingly shows that the statutes have failed. Research on shoot first laws indicates that they increase gun deaths, leading to hundreds of deaths every year that would not have occurred otherwise. And there's a familiar point made by my colleagues. I'll just read what is here rather than going into all the research my colleagues did. These laws also consistently fail to protect vulnerable communities. In addition to the increased risk of victimization in shoot-first states, convictions are unfairly skewed against people of color and women. So that's a point of view. Members opposite have another point of view, that this is not shoot first, this is not a license to kill, and that this is necessary. And that there were consultations, the UNC had consultations, and everybody supported the bill. Well, the PNM also had consultations. We had a number of regional consultations, as compared to the UNC consultations, which were in UNC constituencies. And when they were asked, why aren't you coming into PNM constituencies? They said, it's for the PNM. But, Mr. Speaker, while members opposite report that in their consultations, the majority supported the legislation. In our consultations, the vast majority, practically all, to use the correct terminology, were not in support of the legislation. And I'll tell you why they're not in support. Because it's easy to get carried away with emotionalism. But what is wrong with this bill is the way they define dwelling house. And it's going to lead to problems. Let us look at the definitions. You have to read the definitions in their totality and then apply them to the operational aspects of the legislation and see what's going to happen. So I will paint a canvas, Mr. Speaker. In clause 3, 1, it states, in this act, Associated place means any place that is used exclusively in connection with or for purposes ancillary to the occupation of a dwelling house. Or B, that was A, any place where a dwelling house is one of two or more dwelling houses in one building or group of buildings that occupants of the dwelling house use in common with each other. That is the first mischief in this legislation. What do the words use in common with each other mean? And I will go on to give an example about how dangerous the ambiguity in this clause is. The next definition is curtilage in relation to a dwelling house means an area immediately surrounding or adjacent to the dwelling house which is used for purposes connected with human habitation in conjunction with the dwelling house, regardless of whether the area is surrounded by a fence, a natural boundary, or a combination of both, or is enclosed in a manner that indicates the occupant's intention to keep persons off his property, but does not include any part of the area that is a public place. That is the second mischief in the bill. And I will give a live example to explain what the problem is there. In Trinidad and Tobago, we have a number of gated communities that have evolved over time. The evolution of gated communities really began, I would say, around 2002, 2003, and so on. It's been going on for about 20 years. Prior to that, there weren't many gated communities in Trinidad and Tobago. And I happen to know, because as Minister of Works, I had to deal with applications for gating of communities by various people. I can use one pertinent example for my own constituency, which is Fairways in Maraval. Fairways is controlled by two gates. There is a booth, there's a gate on both sides, and you cannot enter unless you are given permission by the guard to enter, or you get in some other way, and you can't exit either. The problem with something like that, and I'm certain this applies to communities in South Trinidad, in Central Trinidad, in East Trinidad, and in Tobago. The conversion of a public road into a private road in Trinidad and Tobago is a complex legal and administrative process. The Highways Act, a key principle of the Highways Act, is that once a road is a public road, the public right-of-way cannot be extinguished by private action. And legislation is required for closure of a public road. And it's in the Highways Act, and it involves cabinet decision and the gazetting of the change. Now, let's take a gated community where persons have applied to whoever, or they simply put up a gate, because that has happened too in Trinidad and Tobago. People just put up a gate. They decide to make their own gated community. They don't follow any law. They don't go to the police. They don't go to the fire service. They don't go to the health authority, because these are all the persons that have to get involved in creating a gated community. You have to determine whether an ambulance can get in there quickly, whether the police can get in there quickly, whether if there's a fire, the fire service can get in there quickly. You have to get consensus from the persons who are living there and the surrounding communities. It's complex. But there are several gated communities in Trinidad and Tobago that have not followed this legal process. How do we classify the roads and parks and other common areas inside those gated communities with respect to this definition? That occupants of the dwelling house use in common with each other. Is it a private place or is it a public place? So that these words here, that curtilage essentially does not include a public place. What is a public place in the context of a gated community? Let's move on. The definition of a dwelling house includes any adjacent land, building, or other structure within the same curtilage as the dwelling house. I just spoke to the curtilage. That curtilage means all the land around it, because it says immediately surrounding or adjacent to. any adjacent land, building, or other structure within the same curtilage as a dwelling house and occupied for the same purpose. So dwelling house, member for Labrie, through you, Mr. Speaker, is not your home. I don't know where the member for Labrie has gone. The member for Labrie made repeated mention to, we are passing legislation to defend somebody who is attacked in the home. But is the yard in a gated community 100 meters away from your dwelling, is that your home? Is it that when the person passes through the security booth and is quarter mile away from your house, because you use that road to go in and that booth to go in, is that part of the common area where you could kill somebody because you see somebody inside the so-called gated community that you feel is a threat to you, and you feel frightened, and you have a gun, and you shoot them? The definition of what is a dwelling house, Mr. Speaker, is extremely dangerous. Now, the members opposite, they spoke about constitutional majority. I heard the member for Couva South, and I don't like to use these words, but I think this word is appropriate. The member for Couva South boasted that they have a constitutional majority. But the PNM has had constitutional majorities on a number of occasions. I will just name three: 1976, 1981, 2007. The PNM had, because of the mandate of the electorate, got a constitutional majority. But the PNM has never used its constitutional majority to trample on the rights of citizens in Trinidad and Tobago. That's the difference between us and them, Mr. Speaker. We don't boast about having a constitutional majority and what we will do with our constitutional majority. We don't do that. Yeah, it's fine. You could say all that. So, Mr. Speaker, I go back to what the Attorney General said. I go back to what the article from Everytown Research and Policy said. And the people who wrote that article are convinced, and many people in the United States are convinced, that Florida's Stand Your Ground law, which then expanded to 29 states in the United States, was driven by the gun lobby, by the National Rifle Association in Trinidad and Tobago. And people listening to this debate, listening to the Attorney General saying that they're going to ensure that people who want guns get them, that's essentially what I am hearing here. That's what the Attorney General said, that people get guns commensurate. Let me read the exact words so that I would not be misquoted. We wish to ensure that those citizens who qualify are able to get licensed firearms commensurate with the threat to their persons, their family, and their friends. Mr. Speaker, why is the Attorney General speaking like that? I would ask your protection, Mr. Speaker. I think, Mr. Speaker is speaking again. I didn't say a word when he was talking.
Could you carry on? You have 2 minutes more of regular time.
There he goes again. Mr. Speaker, when I read the words of the Attorney General, that the government is going to ensure that person. Mr. Speaker, why is the Attorney General shouting at me across the floor? Mr. Speaker, I read it again. Another of which is to ensure that those citizens who qualify are able to get licensed firearms commensurate with the threat to their persons, their families, and their friends. That can't be the government's responsibility. That is the Commissioner of Police responsibility. So is it that the gun lobby in Trinidad and Tobago is driving this legislation? Because the gun lobby is accused of driving the Shoot First law, the Stand Your Ground law in the United States. And, members talk a lot of emotional things, spoke a lot of emotional things. But understand something. The person who gets the gun, because the government is going to ensure that they get it, Yes, I would
The
like
time
my
is
time,
up,
please.
but-
My additional time, please.
Thank you.
Thank you very much. The person who gets the gun, because of the government's promise to ensure that those who feel threatened could get it, they're not only going to use a gun at home. This stand your ground law to give people guns is not just for your house, you know. When they drive out, they have their gun with them, you know. So all you are doing is changing the culture in Trinidad and Tobago. This is not the United States. This is not a country where we have in the Constitution the right to bear arms. In the United States, fellas have 100 guns. You read about it on the internet, a man will have a whole wall full of guns, because that is the way their Constitution is written, and that is their history, and that is their culture, and that is their practice. But we in Trinidad and Tobago, there is no free for all with respect to the distribution of weapons and guns to persons. And what is wrong with this legislation, Mr. Speaker, apart from the deficiencies in the clauses that I have referred to? And members opposite made fun of the member for Lavender Lees Mova, but he made a brilliant point. And I support him, and I say he made a brilliant contribution too. And it shows how good things can come from any part of the country in Trinidad and Tobago. And the point he made is the problem with clause 7.4, that why should you be allowed to use deadly force to protect the property of another person? That's excessive. And I don't think that will pass the Section 13 test either, even though they don't have the constitutional majority anymore. Even if they had it in, I don't think that would pass the Section 13 test. So what the government needs to understand, the people are suspicious of the government. They don't trust the government. If you did a poll now, what would be the government's rating? It would be below 50%. They have lost whatever support they had on April 28th. And they need to understand. Remember, Mr. Speaker, I did not say a word when the member of Hoover South was talking. There's a practice of members on the other side. When they don't like what I'm saying, I'm exercising my right of freedom of speech as a member of this parliament. That's a sacred right. When they don't like what I'm saying, they shout across the floor. I did not say a word when the Attorney General was speaking. I did not say a word when the member for Hoover South was speaking. I did not say a word when the member for Labray was speaking. And you can testify to that. I did not say a word. I complied with the standing orders. So, Mr. Speaker, the problem about this legislation is suspicion. Apart from introducing a culture of violence, because all the statistical data tells us, all the research on the stand your ground laws in the United States tells us that what has happened since the stand your ground laws have come into being is a history of violence. And I will simply refer to an article in the Tampa Bay Times, 2013, and the title of the article is "Many Killers Go Free with Florida Stand Your Ground Law." And many killers who go free have a history of violence. Mr. Speaker, what this article tells you is that, and I'm going to read, nearly 60% of those who claimed self-defense under stand your ground laws had been arrested at least once before the day they killed someone. More than 30 of those defendants, about 1 in 3, had been accused of violent crimes, including assault, battery, or robbery. Dozens had drug offenses on their records. Killers have invoked stand your ground even after repeated run-ins with the law. 40% of persons who invoked stand your ground laws had previously been in trouble for threatening someone with a gun or illegally carrying a weapon. In dozens of cases, both the defendant and the victim had criminal records. In dozens of cases, Mr. Speaker, of the victims that could be identified in state records, 64% had at least one arrest. Several had 20 or more arrests. That is the history of stand your ground laws in Florida as we speak, Mr. Speaker. And I will end with an example of what can happen in one of these gated communities where the definition of common property is nebulous, may not be legal, may be misunderstood by the occupants of that gated community. And I'll give you an example and I'll show how it's pertinent. In October 2022, I'm reading from Everytown Research and Policy. William Hale and Frank Allison drove alongside each other on US Highway 1 in Hialeah, Florida. A traffic dispute grew more dangerous as both men began driving erratically. When Hale threw a water bottle at the other car, Allison retaliated with a gun, firing a shot that hit Hale's 5-year-old daughter. In response, Hale fired all of the bullets in his handgun, striking Allison's 14-year-old daughter. Though both men were initially charged with attempted murder, prosecutions dropped the charges against the man who fired first. Under the Florida's so-called stand your ground legal defense law, the thrown water bottle justified responding with deadly force, leading to a child being shot. In the end, with 2 girls wounded in a road rage tragedy, the man who started the shootout was protected by a distortion of self-defense that allows people to shoot first and ask questions later. Let's take that now to a community where you have a barrier at the entry, a barrier at the exit, you have roads inside, you have common areas, parks, and that sort of thing. And 2 persons are inside there driving. One is a person who lives there, the other one is a person who lives there. And they get into an accident, one bounced the other car. And they start to argue. And they both pull out their licensed firearms. And they start to shoot. And one kills the other. That is a true life scenario that will happen because of the bad definition, the incomplete definition, the ambiguous definition of what a dwelling house is. Because under this law, a dwelling house has now been extended to common areas and adjacent land used by the occupants of that area. So I urge the government to understand what you are dealing with. Understand what you're dealing with. We on this side are not objecting to the concept of somebody protecting themselves. We believe that persons should be allowed to do that and use force if necessary. But your law is badly drafted and you're going to kill people. People will be killed because of this. Innocent people will be killed. And it will boil down to who shot first and who shot second and who was right and who was wrong. Mr. Speaker, I urge the government, forget the rhetoric. Deal with the issues that we have raised on this side and correct this bad law. Thank you.
Member for Tobago West.
Thank you, Mr. Speaker. You know, I sat here all afternoon listening, and it reminds me of a quote that says, some people bring nothing to the table except an appetite. And it's like, it's very hard to listen those on the other side, but I will not be distracted by them. Mr. Speaker, permit me to express thanks to all the people of Tobago West, whom I now probably serve as their representative. The people of Tobago can finally exhale. It is with great humility I accepted the challenge to be the voice of Tobago West in this parliament. This, while driven by a political party which genuinely echoes the sentiments of the people of Tobago. Mr. Speaker, the Tobago People's Party is not a political party based in Trinidad which is stained red with a compromised legacy of corruption, mismanagement, divisiveness, and downright disregard for the views of the people of Tobago. The TPP is new, Tobago-based, brimming with vision and innovative ideas for Tobago to become the greatest little island on the planet. Mr. Speaker, for this past election on April 28, the citizens were decisive, and hopefully continuing onwards, it is my hope that the people on the ground will continue to say no to the PNM, Mr. Speaker. That the people will demand that their voice be heard, unfiltered by the spin of PNM propaganda. The people are flexing their political power too, Mr. Speaker, to play their part in governance. They wanted to influence the corridors of power usually reserved for the elite who fund political campaigns. They wanted the TPP.
Mr. Speaker, 48 word. Can we get to the bill, please?
Mr. Speaker,
yes, I suppose the member is laying his foundation and he will get there.
Thank you very much. You can't build a house without a foundation. And you know one thing, Mr. Speaker, I realize the goodly member from San Fernando East likes to disturb everyone. You know, in colloquial days, they would say the apple will fall right by the tree, but unfortunately, this apple fell down San Fernando Hill, so he took nothing from his father. They wanted the TPP, they wanted the UNC, they wanted a safe future for us all. To this end, all the people of Trinidad and Tobago must feel justifiably proud that a new beat is played on these drums of democracy. They are proud that this is not a solo beat, it's the drum corps. It's the beat that recognizes the partnership with communities and the delegation of power to exercise powerful, productive, and protective citizen control over public policy and decision-making. Mr. Speaker, the contributions of my predecessor and the former representative for Tobago East were all driven by empty rhetoric, grandstanding boastfulness, and no reference to the plight and needs of the people of Tobago. None of their so-called sophisticated speeches, Mr. Speaker, deeply expressed the invisibility of Tobago.
Point of order, 48-1.
Tobago West, I think I've given you enough leeway. Get the run-up.
All right, Mr. Speaker.
Let's not show you back there. So come, let's get to the point.
Mr. Speaker, this legislation is one which is cause for much reflection. But the biggest question to answer is why are we here at this legislative juncture, Mr. Speaker? We are here, Mr. Speaker, because crime and criminality has long bolted from the proverbial stables under the tenure of the outgoing PNM government. Mr. Speaker, this is why we are here. We are here because of decades of failed national security and crime-fighting policies of the PNM, to the point that the legislation reflects the Tobago saying, who can't hear will have to feel. Mr. Speaker, I also point out the rampant disregard for law and order displayed by the former government and their inability to set an adequate policy environment for the institutions charged with the enforcement of the law to function in...
48-1.
No, the member clearly is articulating the policy foundation behind the legislation. Overruled.
Yet despite this actual truth, the country must work together to bring positive change in keeping with our constitutional rights to safety and security. Mr. Speaker, as the Member of Parliament for Tobago West, let me make it pellucidly clear that national security is a sixth schedule matter for which the Tobago House of Assembly does not have policy responsibility for, neither for crime fighting on the island. Mr. Speaker, although the THA does not have the direct duty, the role of the citizens is very pertinent in policy making. Hence, people all over this country must have representation in this decision-making house. We act as their voice on these important matters. Hence, the reason for staying connected to them, to see and experience what they are going through in their daily lives and be their voice in this honorable house. Mr. Speaker, Tobago just came off a record high of 26 homicides last year. The relative peace and safety, well known in our island, bruised, butchered, and battered by the bullet. Mr. Speaker, we in Tobago long for the return of years when we recorded no homicides at all. Last year, our homicide rate was 39 per 100,000, and this was not very far from the 45 per 100,000 population in Trinidad. Taking our small size into consideration, the Tobago murder rate with 26 murders is equivalent to 541 murders in Trinidad. If, God forbid, we had 4 more murders in Tobago last year, we've had the same murder rate as Trinidad of 45 murders for 100,000 persons. Mr. Speaker, the small numbers translated to high rates when our population is small. I urge all citizens to appreciate what Martin Luther King Jr. once said. We are all connected by the fabric of destiny. What affects one affects all. Mr. Speaker, the TPP-led Tobago House of Assembly has a clear preference for the public health approach to crime reduction because, among others, the THA's remit lies in the social protection ecosystem that looks at prevention through social programs, poverty eradication, and poverty alleviation, employment support, rehabilitation, and social protection floors to ensure access to the suite of social services to provide a minimum set of services for social resilience against vulnerability to social deviance. Mr. Speaker, this motion, which seeks to authorize the potential use of deadly force by citizens in the sanctity of their dwelling place to protect life and property against an intruder. Mr. Speaker, it gives residents of Tobago a fighting chance to defend their family, an opportunity to protect their valuables which they would have gained via hard work, not to be taken away by the uninvited guests who come with the intent to remove what does not belong to them, and in some instances, end the life of the homeowner or its members when confronted, which we have seen played out many a times. I stand in support of this legislation, which will give law-abiding citizens who demonstrate the right ambit to carry a firearm so they can defend themselves if faced with such brazen and blatant disregard for their life and well-being by the person or persons who intrude their home. I agree on these grounds that this piece of legislation is what we need right now to equip the citizens of Trinidad and Tobago with an opportunity to protect themselves. Not tomorrow, not the day after, not next month. Mr. Speaker, now. Mr. Speaker, this authorization by the state granting our citizens permission to use deadly force to defend themselves against a home intruder has come at a time when lawlessness has taken over our beautiful Twin Island. We cannot stand by idly and continue to do nothing about these home invasions with no say and without due consequence for the actions of those that commit these offenses. Mr. Speaker, it will be a different story or a different outcome if these brazen criminals entering the homes of innocent citizens know that there is a possibility that they can be met with deadly force. Mr. Speaker, in carrying out a crime or violent nature, such as these home invasions, no outcome is guaranteed. The intent of this piece of legislation is to empower our citizens, especially us in Tobago, to make a critical decision of use of force when faced with a situation such as a home invasion. Mr. Speaker, this gives them an opportunity to protect their rights until the police service arrives, because we all know many a times, too late shall be the cry. Mr. Speaker, now an opportunity is presented so we can sing a different song. No longer will there be slow singing, because those culpable of these crimes will now have second thoughts. Mr. Speaker, those opposite will try to let the government look like it's allowing citizens of Trinidad and Tobago to become gun-swinging, trigger-happy citizens. This is far from the truth. This legislation does not mean that anyone will apply and say, I have a home, I want a gun to protect myself, or I want the authority to protect myself with deadly force against intruders. What it means, Mr. Speaker, is that for those who will seek to access firearms will only be available through the requisite procedure in order to ensure their background and lifestyle will render them or deem them operationally stable enough to be issued that permission. What it will do after such a process is to give our citizens a chance to defend themselves from such intruders and prevent the what if. In some cases, assisting our security services and easing financial burden to the state. Mr. Speaker, to be against this type of legislation is to be against doing anything to address the current runaway situation caused by those on the other side. What citizens of our country continue to face daily is unbearable. So this move by the government shows its dedication to stand with its citizens against the current surge of crime, where home invasions are a serious cause for concern. Mr. Speaker, this move should not come as a surprise to anyone, nor should it be a legislative mystery to anyone. We reside here. We see and hear what goes on in our beloved country. Just as every home intruder has the option of being productive and can work to gain what they are trying to take from homeowners with deadly force, this legislation seeks to give our citizenry the right to protect what they have worked for using the same force. Mr. Speaker, the lives of the people in this country are plagued by the countless situations and encounters of having to endure pain and abuse at the hands of intruders. Mr. Speaker, just recently in Tobago, a family was hogtied and robbed of their valuables from home intruders who had no regard for them upon entering their home. Had this legislation been in place, it could have been a different kettle of fish. Mr. Speaker, our citizens have exposure to many other options than a life of crime, with all the self-enhancing programs, income streams, and business opportunities available to them. So it is clear, Mr. Speaker, that those persons who choose to invade a homeowner's personal space to relieve them of their personal effects don't want those listed avenues to enhance themselves. Mr. Speaker, I thank you for this opportunity, and I close with an appeal to all those who have the tools and the thoughts of mayhem to rethink. Do not be triggered. Do not be puppeteered for a few pieces of silver. That, as Aristotle said, what is in your power to do is in your power not to do. That with free will and knowledge, we can discipline ourselves to do good, not for ill will and destruction. It is on those grounds, Mr. Speaker, myself, my colleague, and the people of Tobago support this piece of legislation that will empower citizens to defend themselves and their property using deadly force when confronted by an intruder. Once this legislation is passed, I will join my colleagues in saying to homeowners, you have the resources, you have the means. Defend yourselves using such force as necessary. Because if you do not and allow the intruders to plan and make a move before you do, then you shall be another statistic and another what if. Mr. Speaker, I thank you.
Member for Laventille West.
Mr. Speaker, I thank you very kindly for the opportunity to contribute to this very important bill that is before this Honourable House. And of course, Mr. Speaker, it engages the entire national population to see what is the government's response to the crime situation, how we are going to approach this issue of home invasions, Mr. Speaker. And Mr. Speaker, when we come to this Honourable House and we bring legislation and we debate legislation, we have to often ask ourselves, what is the intent of a bill? What is the mischief it is trying to cure? Mr. Speaker, we first must examine briefly what is the current status of the law. Is there adequate provisions, whether by common law or by statute, in order to criminalize acts of home invasions, which may include trespass onto your property, burglary, assault, murder, and these wide range of both common law and statutory provisions, Mr. Speaker. Mr. Speaker, we know, and I wouldn't go in depth in terms of the common law position, as a lot of members on both sides would have gone into it. But the salient point, Mr. Speaker, is that as we speak, if tonight some member of the public with ill intent decides to enter onto the property of any citizen of this country's property or home, and they are found, Mr. Speaker, from the moment that they step foot into the person's home, whether it is to steal some chairs in their yard, or to steal something that is in their yard, there are provisions in both the statutory law as well as the common law. Mr. Speaker, Section 3 of the Trespass Act of Trinidad and Tobago, Chapter 1101, and as amended by Act 5 of 2019, provides that any person found in an enclosed yard, garden, or ground, or in any cultivated lands, or in or about the works of any plantation, oil field, refinery, or oil tank farm, and fails to make it appear to the satisfaction of a magistrate or justice of the peace that he had some reasonable cause or excuse for being in the place where he was found, is liable to a fine of $50,000 and imprisonment for up to 10 years, Mr. Speaker. So situation one, you enter someone's property tonight unlawfully. You can be held, you can be arrested by the police, you can be charged by the police, and you can be brought promptly before the court, whether it's through by way of summary offense through the magistrate's court, or the justice of the peace having concurrent jurisdiction to treat with the issue of station bail. And you can go to court, brought before the court, you can be tried, and you can be convicted. There's a provision for that, Mr. Speaker. Mr. Speaker, if you enter that property and that person actually steals something, the Larceny Act provides for it. The Larceny Act of Trinidad and Tobago, Chapter 1112, Mr. Speaker, Section 14 states, any person who steals in any dwelling house any chattel, money, or valuable security, A, if the value of the property stolen amounts to $25, or B, if he, by any menace or threats put any persons being in such dwelling house in bodily fear, is liable to imprisonment for 10 years. Mr. Speaker, let's go further. If the person moves some, not only in your yard, but they break into your home, situation number 3, Mr. Speaker, and they break into your home, Section 27 of the Larceny Act provides for that too. Section 27 states, Mr. Speaker, any person who in the night, A, breaks and enters the dwelling house of another with intent to commit any arrestable offense therein, or B, breaks out the dwelling house of another having 1, entered the said dwelling house with intent to commit any arrestable offense therein, or 2, committed any arrestable offense in the said dwelling house, is guilty of burglary and liable to imprisonment for 15 years, Mr. Speaker. Mr. Speaker, situation number 4, which Section 30 of the said Larceny Act provides for, where if you are armed with any dangerous or offensive weapon with the intent to break or enter any building or any house, that you can be found liable to imprisonment for 10 years, Mr. Speaker. And Mr. Speaker, I move to the Offences Against the Person Act, because not only may persons enter onto your property unlawfully, they may enter your yard and then they may enter your home, and we give the provisions. That person may not know that you're there. They may enter the property and you may not be there, and they may go and they may steal something. But there are situations in this country, Mr. Speaker, which our citizens are faced with, when at times the intruders come into your home with firearms, with whether it's knife or any sort of weapon, and they may go further, Mr. Speaker, to assault you, to rob you, and the Offences Against the Person Act and the Larceny Act also provides for same. Mr. Speaker, they may commit heinous offenses against your children, against your wife, against your mother, against your grandmother. And Mr. Speaker, there are provisions in terms of the Sexual Offences Act. Mr. Speaker, the Offences Against the Person Act. And then worst of all, Mr. Speaker, you would have, Mr. Speaker, in terms of the provisions, of course, against Section 4 of the Offences Against the Person Act. If that person is killed in the home, if a victim is killed in the home, Mr. Speaker, of course, Section 4 of the Offences Against the Person Act provides that any person who commits murder shall be sentenced to death. So, Mr. Speaker, I'm bringing it to the point of what is the mischief this bill is intended to cure. If there is adequate lawful provisions in order for Mr. Speaker, the police to arrest these perpetrators and bring them before the court, then, Mr. Speaker, our issue may not be legislation, it may be implementation, Mr. Speaker. And Mr. Speaker, that is one aspect of the bill. So the first aspect of the bill treats with creating the offense of home invasion. But the second aspect of it provides or sorts to qualify, in a sense, the self-defense aspect of a owner or occupant of a home protecting themselves against an intruder. And Mr. Speaker, what mischief in Trinidad and Tobago lies there? Mr. Speaker, there is no outbreak of persons being homeowners who have their FULs and have their firearms, and persons break into their homes in Trinidad and Tobago and they shoot them or they kill them, Mr. Speaker. Where is the evidence that there is any malicious prosecution and or wrongful arrest in Trinidad and Tobago? Where is the allegation that the office of the DPP or the police service is maliciously prosecuting homeowners who find themselves in these positions defending themselves, Mr. Speaker? There is no such outbreak, Mr. Speaker. And I want to just briefly, Mr. Speaker, look at a few reports. So the first, Mr. Speaker, is a Gregory McBurney Newsday report dated the 15th of August 2025. And it said, which is that on the said August 15th, 2025, a 66-year-old Santa Cruz man and a holder of an FUL shot and killed two persons who broke into his home and attempted to rob him. Mr. Speaker, the said FUL holder defended his life thankfully. Mr. Speaker, in the circumstances, the degree of force was both reasonable and proportionate. And therefore, Mr. Speaker, in applying the existing common law defense of self-defense, no charges were recommended by the DPP. That person in question was not arrested by the police. So therefore, why do you believe on selling this bill to the public as if somehow persons would now be afforded these lawful protections, Mr. Speaker? Mr. Speaker, according to a Jensen Levin Guardian story report from 2023, the report states, a man who is yet to be identified was killed on Saturday morning after he and two others broke into a house in St. Augustine. Police reported that the intruders went to Freeman Road, St. Augustine, and was greeted by a firearm user's license holder who shot two, killing one, and the other escaped. Mr. Speaker, yet again, this person, this citizen, was not arrested, was not wrongfully or maliciously prosecuted, and therefore we ask again, what is the mischief? What is the crime, Mr. Speaker? Mr. Speaker, let's go back, Mr. Speaker, to another situation in Claxton Bay, where in March 22nd, 2025, an FUL holder killed a bandit with a toy gun in a botched Claxton Bay robbery. He had his licensed firearm. He used both reasonable and proportionate force in these circumstances. He too was not wrongfully arrested or maliciously prosecuted. And Mr. Speaker, so I draw this to the attention of the public that there is in fact no allegation in this country, where we observe the rule of law, where it is the office of the DPP and the Director of Public Prosecution, Mr. Speaker, who exercise his discretion in a way that is lawful and that is reasonable. And therefore, if citizens are not being persecuted for defending themselves, it begs the question, why is this bill being held up as if it is for the first time? It is for the first time, Mr. Speaker, inventing this self-defense aspect for when persons defend themselves in their home, in their dwelling home, Mr. Speaker. But, Mr. Speaker, this bill was being purported as if it is linked, one, or somehow promotes or encourages or facilitates the grant of firearms or FULs. And that is not so. Mr. Speaker, of course, the Attorney General indicated earlier that it's not a standalone law, and it will come with other aspects in terms of perhaps FUL, the granting of FULs and so on. But, Mr. Speaker, this bill, as we speak, according to the then Minister of National Security at the time, the Honourable Fitzgerald Hines, Mr. Speaker, there were 25,000 active FUL holders in Trinidad and Tobago. 25,000, Mr. Speaker. Mr. Speaker, so you're holding up this and you're telling the country, this is the solution to our problem, when only 25,000 citizens can benefit from same in terms of defending themselves with firearms, which is less than 1.8% of our population. So we come here and we say that we represent all of Trinidad and Tobago, but yet still this legislation only benefits the 1.8% people in this country who are fortunate enough to have an FUL and to be able to afford firearms, Mr. Speaker. Mr. Speaker, we require more progressive thinking and more progressive solutions to our crime problem than to hold out hope to only 1.8% of the population and selling it as if it's the best thing on the market since sliced bread, Mr. Speaker. Mr. Speaker, I have sat here for the entire day, and speaker after speaker on the government side gets up and say that there's a rise, there's a big increase in home invasions. Mr. Speaker, I went to the TTPS website, and a little button to the top, there's a little button called stats, right? I know they don't like stats. But, Mr. Speaker, one of the categories that you can look for, and it's categorized, is burglaries and break-ins. And I said, Mr. Speaker, I must carefully go through each and every report that is available online on the TTPS website as the only authoritative source to indicate what in fact is the rate, the crime rate specific to burglaries and break-in. Mr. Speaker, in 2013, there were 2,968 reported burglaries and break-in. 2014, 2,592. 2015, 2,011. 2016, 2,187. 2017, 2,176. 2018, 2017. 2019, 2029. 2020, 1,511. 2021, 1,331. 2022, 1,731. Mr. Speaker, 2023, 1,677. And Mr. Speaker, as of December 31st, 2024, we recorded one of the lowest rates of burglaries and break-ins in Trinidad and Tobago at 1,613. Mr. Speaker, that is 1,613, too much. But the fact remains, Mr. Speaker, that from 2013 having annual annual amount of reports for burglaries and break-ins from 2,968 to come in 2024 and have it at 1,613, Mr. Speaker, indicates a 47% decrease in burglaries and break-ins. Mr. Speaker, that is too much. But I'm saying that if the mischief that is being purported here, Mr. Speaker, speaker after speaker, on that side, Mr. Speaker, is that there is in fact a rise, that there is in fact a rise in break-ins and burglaries, it means therefore that is furthest from the truth, and we must put it on record with the facts, not opinions. Mr. Speaker, so we have noticed that there is sufficient both common law and statutory provisions to protect citizens, to have, Mr. Speaker, the perpetrators found, to have the perpetrators, Mr. Speaker, convicted, and it is, of course, Mr. Speaker, our duty to not only criticize, but to also look at some areas for consideration, Mr. Speaker. Mr. Speaker, I recall during the consultations, and I paid attention, attended every single consultation that the PNM had. I also read the news in terms of some of the consultations that the UNC members were having. And I remember one particular consultation stood out to me, and the response of the Minister of Land and Legal Affairs, the Honourable Member for Barataria Sanwan. And I want to read from a Daily Express. Story, please, Mr. Speaker, by Vivian Bowen. The heading is Saddam, Grey Areas in Law. Mr. Speaker, and I quote, will the Stand Your Ground law act as a legal defense if an unauthorized user kills an intruder with a legal firearm in the house during an invasion? The question was posed to the Legal Affairs Minister on Tuesday night by the Public Relations Officer of the Prison Officers Association, Mr. Sean Ramnarine, at the first public consultation held at Barataria Community Center. Ramnarine described a scenario in which an armed intruder breaks into his home while he's in the kitchen, and he's the first to be held by the intruders. He pointed out that if his wife, upstairs with their children at the time, sprung into action and decided to retrieve the legal firearm which belonged to him and confronted the criminals to protect the family, but was not legally authorized to use the weapon, would the new law be on her side? And Mr. Speaker, the Honourable Minister indicated that this is a grey area in the law and assured it was a matter that he would raise with the Honourable Attorney General in order to fix it. Mr. Speaker, the amended version came to this House. And as far as I have seen, Mr. Speaker, Section 9.1 of this bill, Mr. Speaker, states that Sections 7 and 6, which provides the protection for or the self-defense for persons defending their property and themselves, that those sections, Mr. Speaker, do not apply where, and I'm going to see, where the occupant or a person assisting an occupant who uses or threatens to use force is engaged in a criminal activity. Mr. Speaker, as far as I know, according to the Firearms Act, if you are not a holder of a FUL and you find yourself in possession, no matter what the circumstances are, because there are no possible defenses in the Firearms Act for persons in your home who are not authorized to use your firearm being allowed to use it. And Mr. Speaker, this is why, rather than rushing to the Parliament without any meaningful consultation and without making such amendments that their very same these very same persons at their consultations raised, and they acknowledged that there were grey areas. We come to the Parliament to debate this bill, and no such provision is made, Mr. Speaker. It is not considered, Mr. Speaker. And if that is the case, Mr. Speaker, we must call it for what it is. This is an unpopular administration rushing to make populist decisions in hopes that people would ignore the abject failure in 7 months, Mr. Speaker. Mr. Speaker, members on the side have compared the different jurisdictions in terms of Florida, in terms of Ireland, the UK, and so on. And many states in America, of course, where the stand your ground legislation is in fact there. And we don't have to throw our memory far back to the public cases such as whether it is the Trayvon Martin incident in America, or whether it is the 17-year-old Trayvon Martin, or whether it is in fact I think it's Yal Williams, if I'm not mistaken, Ralph Yal, who was a 16-year-old, Mr. Speaker, a 16-year-old high school junior, who was picking up his younger twin brother from a friend's house on the day in question, Mr. Speaker, when he approached an incorrect address. A white homeowner, 84-year-old Andrew Lester, came to the door and shot Yal in his head before shooting him a second time, according to the authorities. Mr. Speaker, we must look at the very fabric of our society. We must determine, Mr. Speaker, in a realistic way, even when it is unpopular to do, even when it is a conversation that nobody don't want to touch, Mr. Speaker, we must acknowledge that while we thrive for it every day, Mr. Speaker, for in this country, for every creed and race to find an equal place, Mr. Speaker, we know sometimes the ugly head that rears, Mr. Speaker. We know sometimes, Mr. Speaker, that the biases, the racial discrimination, the classism, the society placing one in terms of looking down on certain communities, on certain demographics, Mr. Speaker. That is a reality. Whether we want to accept it, whether we want to call it race baiting, whether we want to call it all kind of things, that is the reality, and we cannot run from it. We cannot hide from it. We must strive to do better. We must strive to do better. And it must start with us. But, Mr. Speaker, that is the reality. So we cannot put this bill and have it as an island on its own and don't understand the current climate in this country and, of course, our social fabric, Mr. Speaker. Mr. Speaker, I hail from a beautiful and resilient community called Beetham Gardens. I represent the most resilient constituency in this country called Laventille West. A people that comes from nothing, a people that has to lie on their dress in order to find jobs, whether it's in the private sector or the government sector at times, Mr. Speaker. People who walk into a room where interviewers, and they see your address, they're not asking you about your qualifications, they're asking you about all kind of unorthodox and racist and discriminatory questions, Mr. Speaker. So when I stand here and say, Mr. Speaker, that we must tie this bill into our social fabric, Mr. Speaker, I make no joke or no mince about it, Mr. Speaker. So I'm saying this to say, Mr. Speaker, why is in the case of Trayvon Martin, why is in the case of Yaraf and all these different circumstances, this bill can very well be the start of the changing or the eroding of our social fabric as a nation, Mr. Speaker. Mr. Speaker, I plead with the Honourable Attorney General, the Honourable Prime Minister, and members opposite to not make a populist decision right now. Refer this matter, Mr. Speaker, refer this bill, Mr. Speaker, for proper consultation. Mr. Speaker, this may very well require whether it's by way of constitutional reform to have a referendum to determine whether this society, Mr. Speaker, truly wants to erode, Mr. Speaker, the very fabric of our society. Mr. Speaker, what are we going to say to the young man who attends Trinity College in Mocha, but from Beetham Gardens and walking through and decide whether for some reason or not, Labrador spoke about that children, that you grow them up in a certain way and they're supposed to knock and they're supposed to ask if they're going to pick a mango. And he's saying that if you don't do that, whether they're child or not, collateral damage. Wow. He didn't say collateral damage, Mr. Speaker. I'm inferring by his words that it was collateral damage. And I'm saying, Mr. Speaker, even with the issues like that, Mr. Speaker, we have to be very, very careful. Because before you know it, because this government, it comes on the backdrop, Mr. Speaker. This bill comes on the backdrop of what were the public statement made by members opposite during their so-called consultations, as well as in their election campaign, Mr. Speaker. Mr. Speaker, there are many members of the public who are never going to take the time to go through this bill. The vast majority of the public is not going to read this bill. The vast majority of this public, Mr. Speaker, reads newspapers. They have social media, and they sometimes believe the lies that is being postulated by those who are seeking to win an election and those who are trying to hoodwink a nation, Mr. Speaker. And therefore, members of the public would believe that they are to load up the matic, knock it on them, reload it, knock it on them again and again and again and again, Mr. Speaker. The public, Mr. Speaker, would believe that this bill is shoot first and ask questions after. The public may believe, Mr. Speaker, that they should kill them all violently, Mr. Speaker. Mr. Speaker, the public may believe, Mr. Speaker, that of course it's better to be judged than 12, no matter the circumstances, than to be carried by 6, Mr. Speaker. And if a home invader come and you kill him, that, Mr. Speaker, you would not even be arrested or investigated. Those are public statements, Mr. Speaker. You want to know who said the last one? The member for Barataria San Juan, in a public consultation telling someone that this bill provides. I wasn't going to do it, but I asked for it. Not the whole 15 minutes, Mr. Speaker, but I'll be sure. So, Mr. Speaker, I am saying this to say that this requires proper consultation, proper consensus, proper education, and a key focus on understanding our very social fabric, Mr. Speaker. I stand in defense of the persons, Mr. Speaker, I stand in defense, Mr. Speaker, of the mother who knows that her son is a law-abiding citizen, who knows that he's attending university, who knows, Mr. Speaker, that he have hair that look like mine, or look like the member for Tunapuna, or look like the member for Port of Spain South, Mr. Speaker. Mr. Speaker, and I stand, and Mr. Speaker, I am giving the example. That's not we would get there. It's one example I'm giving, Mr. Speaker. And that example I'm giving, Mr. Speaker, is that the prejudice, the discrimination, the perceived bias that has found its way, for example, in Florida, in the United States, Mr. Speaker, with the Trayvon Martins, with the Yalras, Mr. Speaker. All of these are realities that can face this sweet, beautiful country soon. Mr. Speaker, I stand in defense, Mr. Speaker, of the father who raised his son, Mr. Speaker, as a law-abiding citizen, sending him to lessons, and who looks like the member for Caroni Central, that looks like the member for Couva South, Mr. Speaker. And if it comes to a place where that person enters, and if that young man enters a certain place mistakenly, and that person steps forward, Mr. Speaker, and shoots because it's on the wrong door, Mr. Speaker, I stand in defense of every citizen of this Trinidad and Tobago, Mr. Speaker. And Mr. Speaker, they can try to trivialize it how they want. They can call us anything that they want, Mr. Speaker. But I know, Mr. Speaker, that the citizens listening to us would know that this objection and these concerns come from a genuine place, Mr. Speaker. Mr. Speaker, there is adequate common law and statutory provisions in order to protect against. Mr. Speaker, I want to recommend a few solutions before I go. I want to make a few solutions, Mr. Speaker, because you see, it doesn't have to only be an issue of legislation. Mr. Speaker, I remember in 2023, Mr. Speaker, when the then Minister of Finance, Mr. Speaker, the Honourable Member for Diego Martin North East, would have removed taxes from all CCTV-related items into this country, encouraging more citizens, of course, to be provided with security cameras and so on, Mr. Speaker. Mr. Speaker, I want to recommend, Mr. Speaker, that there are, in fact, other than arming our population, there are, in fact, other security measures that we can put in place in order to decrease home invasions, burglaries, and or break-ins, Mr. Speaker. Mr. Speaker, I want to suggest that the government, that there be a removal on all taxes, removal of all taxes on security, electronic fence, wall spikes, etc. I want to recommend, Mr. Speaker, to the honourable government that they allow tax returns for citizens with home security services, remove taxes on alarm system and other home security related taxes, use AI and digital tools, Mr. Speaker, to develop, whether it is a nationwide app to report suspected break-ins, Mr. Speaker, and with real-time information being communicated to the nearest police station, and of course putting equipment in place. So, Mr. Speaker, to conclude, I have identified, Mr. Speaker, that there is in fact no mischief in Trinidad and Tobago or no lack of laws, whether in relation to criminalizing and penalizing persons who commit home invasions. Two, Mr. Speaker, there is no mischief in relation to any allegation of wrongful arrest or malicious prosecution in Trinidad and Tobago for homeowners that defend themselves using reasonable and proportionate force. And third, Mr. Speaker, I am asking and urging the government, Mr. Speaker, in their deliberation, to consider that because this affects the very fabric of our society, that they do the honorable thing and go to the population and have this, whether by way of constitutional reform, to get a referendum on it and let the population be truly a part of this process. Mr. Speaker, with those few words, I thank you very kindly for this opportunity.
Honourable Attorney General.
Mr. Speaker, when I started this debate just about 10 hours ago, I think I said a number of things which either were forgotten by those who came afterwards, including those who came immediately after, or just ignored, either forgotten or ignored by those who came right after or some time after. I could excuse those who started to speak perhaps at 11 o'clock or so. I mean, it's been a long day. But there were others who spoke immediately after me. And if I could just go through quickly what I said by way of a rebuttal to some of the points which were made. The point has been made over and over again that this is not the answer to crime. Well, I think I started off by quoting police statistics. I said, this is what CAPA says. We have a problem with gang-related homicides. I don't know how many different ways to say that. We have a problem with gang-related homicides. And then I said we have a problem with home invasions. I said that what we did with respect to gang-related homicides was to cripple the leadership of the gangs, put them away somewhere that you did not dare to touch them. You did not dare to move them to. Cut off their command structures. They were unable to speak to their soldiers. And as a result, the gang-related homicides fell precipitously. That is a fact. And it is, you cannot see, by way of a rebuttal to that, well, there has been a state of emergency for 9 years, for 9 months. That is glib. There was a state of emergency for 3 months when the member for Port of Spain North jumped out on a television and said his leader was somewhere playing golf in Tobago, and he said, well, listen, state of emergency. State of emergency. And you know what? A director of public prosecutions was slaughtered during that state of emergency. What has happened during ours? Nothing similar. It has been efficient. It has dealt with the threat that we faced, and we have had a reduction, a dramatic reduction in the rate of gang-related homicides. But that is not the end of it. We said that we were looking at judicial reform. We have started that hard work. And we also said that we were doing work in relation to the matter that brings us, that has brought us here this afternoon. And it's part of an entire package to make our citizens feel more secure. And at the heart of that is a conception that they ridicule. And that conception is this, that ownership of firearms is not the province of the chattering classes. It is not for those of us who have too many guns and we wish to donate guns because they're too powerful to the police service. That is not what we're about. We say that we should democratize the ownership of firearms. And that is separate and apart from what is before us this afternoon. That is where we are going. If it is good for your financiers, you know where they are, and you know who they are, and you know what they have in their houses. If it is good for them, it is good for our supporters, our law-abiding supporters as well. But the legislation that is before us is this afternoon is comprised of 11 clauses. And I just want to remind colleagues, because I heard the member for Port of Spain North and someone else mention that the Law Reform Commission is staffed by good public servants. That is true. It is a body set up by statute. It is supposed to be a body which is in charge of looking at the law. That's their job. They look at the law, they look at deficiencies in the law, they study various models all over the world, and then they say, if you have a problem, this may be your fix. You did nothing about it. We came, my Prime Minister directed me to ask them to solve this problem. And what those public servants that you say are decent, good, hard-working public servants, you say they are. They've come up with this model. And we've brought this model to this Parliament today. Now, what does the law before us do? It does two things. It creates the offense of home invasion, which I mean, it's kind of difficult to, I don't know if the PNM has caucus again. They used to have a caucus back in the day. So it's difficult for me to understand when some persons say, well, okay, home invasion is criminalizing home invasion is a good thing, and then others suggest that I want to be very careful. I'm terrified of the Privileges Committee. Terrified. So, sometimes some folks say that it is a good thing, the home invasion, punishing home invasion is a good thing. Others say no. The fact is that the law does two things. It punishes home invasion. That was not done before. And then it enhances the self-defense and defense of property. Those two defenses. 11 clauses. Now, that's it. That's all those 11 clauses do, my friends. Now, inside of there, I heard a couple times from Port of Spain South, who is an experienced lawyer. I heard that there were some constitutional concerns. But the concerns that I think I heard, I might have been wrong, dealt with, the right of the individual to retaliate using deadly force. Now, and I'm not saying that the Law Association is right, but we embarked on a series of consultations. And one of those consultations was with the Law Association. The Law Association had a couple problems with the law. They said, first of all, that there was nothing unconstitutional about the self-defense, right? Defense of self, use deadly force. If you wish, I could read it out to you, but it's late, it's 11:30, and I'm sure that you wish to bed it by. I'm pretty certain of that. So they said there was nothing wrong with that. But they did say that insofar as the defense of property, that defense was concerned, that the use of deadly force there might run afoul the provisions of the Constitution. I did not agree. I sought independent advice, and that independent advice did not concur with the Law Association. And that is the reason why there is no constitutional certificate on the legislation, because we think it is covered by Stuart. And that's it. it's our job to make our best decision on the legislation. We've sought advice on it. We've done the responsible thing. The legislation is before you. And, you know, I make no apologies for it. Now, in terms of the other comments about vigilante justice and Florida, and let's be, it's 11:34, so vigilante justice, black people in Florida being singled out by the police, and so on and so on. This is not Florida. All of our police officers are African American people, most of them, right? They aren't going to be, our sociological circumstances are different. Our sociological conditions are different. And as the Prime Minister says, everything is not about race. We looked at Florida as a model. Not the model, it was a model. We looked at Ireland as well. Why? And then there was a draft prepared by the Law Reform Commission. The draft is before you. It is the best that we can do. It is more than you did in the past 10 years. I say that with confidence because you watched as Rome burned. You saw 650 odd of our citizens die at the hands of gang-related homicides last year. And you did nothing. You have no moral authority to come and speak to us today. None. In 6 months, we have pushed hard to bring the gang-related homicides under control. We have pushed hard to reform, to begin the hard work of reforming the judicial system. There have been changes to personnel in key positions in this country, and we have brought this legislation which we promised to bring. It is not the end, it is a beginning. There is more to come. As my Prime Minister says, promise made, promise kept. Mr. Speaker, with those words, I beg to move.
Honourable members, the question is that a bill entitled An Act to Establish the Offence of Home Invasion, and in that context to provide that a person has no duty to retreat when acting in self-defense or defense of his property, to provide that a person may use defensive force, including deadly force, to protect himself, his property, or another person in his dwelling house, and to provide for related matters, be now read a second time. Those in favor say aye. Those against say no. The ayes have it. The clerk will read the long title of the bill.
A bill entitled An Act to Establish the Offence of Home Invasion and, in that context, to provide that a person has no duty to retreat when acting in self-defense or defense of his property, to provide that a person may use defensive force, including deadly force, to protect himself, his property, or another person in his dwelling house, and to provide for related matters.
Honourable Attorney General.
Mr. Speaker, in accordance with Standing Order 68-1, I beg to move that the Home Invasion, Self-Defense and Defense of Property Bill 2025 be committed to the Committee of the Whole to be considered clause by clause.
Honourable members, the question is that the Home Invasion, Self-Defense and Defence of Property Bill 2025 be committed to the Committee of the Whole to be considered clause by clause. Those in favour say aye. Aye. Those against say no. The ayes have it. This House shall now go into the Committee of the Whole to consider the bill clause by clause.
Clauses 1 to 9.
The question is that clauses 1 to 9 stand part of the bill. The question is that clauses 1 to 9 now stand part of the bill. Those in favour say aye. Aye. Those against say no. No. The ayes have it. Clauses 1 to 9 now stands part of the bill. The question is that the bill be now reported to the House. Those in favour say aye. Aye. Those against say no. The ayes have it. The bill will now be reported to the House. Honourable Attorney General.
Mr. Speaker, I wish to report that the Home Invasion, Self-Defense and Defense of Property Bill 2025 was considered in the Committee of the Whole and approved without amendment. I now beg to move that the House agree with the committee's report.
Honourable members, the question is that this House agree with the committee's report on the Home Invasion, Self-Defense and Defense of Property Bill 2025. Those in favour say aye. Aye. Those against say no. The ayes have it. Honourable Attorney General.
Mr. Speaker, I beg to move that a bill entitled An Act to Establish the Offence of Home Invasion, and in that context to provide that a person has no duty to retreat when acting in self-defense or defense of his property, to provide that a person may use defensive force, including deadly force, to protect himself, his property, or another person in his dwelling house, and to provide for related matters be now read a third time and passed.
Honourable members, the question is that a bill entitled An Act to Establish the Offence of Home Invasion, and in that context, to provide that a person has no duty to retreat when acting in self-defense or defense of his property, to provide that a person may use defensive force, including deadly force, to protect himself, his property, or another person in his dwelling house, and to provide for related matters be now read a third time and passed. Those in favour say aye. Aye. Right, okay. Division having been called for, I have no discretion. The clerk will take the division.
Mr. Padarath,
A resounding yes.
Mrs. Prasad Bisessa,
Yes.
Mr. Tanku,
Absolutely yes.
Dr. Moonilal,
Yes.
Mr. Lee,
Yes.
Miss Amin,
Yes.
Mr. Alexander,
Yes.
Mr. Maharaj,
Absent.
He's not here.
Miss Mohit,
Yes.
Mr. Sturge,
Yes.
Dr. Bodo,
Yes.
Dr. Dowlat,
Yes.
Dr. Ali,
Yes.
Mr. Morris,
Yes.
Miss Benjamin,
Yes.
Mr. Watts,
Yes.
Dr. Sicharan,
Yes.
Mr. Kesar,
Yes.
Mr. Elder,
Yes.
Miss Sam,
Yes.
Dr. Rupnarain,
Yes.
Dr. Gosain,
100% yes.
Mr. Thomas,
Yes.
Mr. Sampson,
Yes.
Mr. Gonzalez,
No.
Mr. Imbert,
No.
Dr. Gadsby Dolly,
No.
Mr. Young,
No.
Mr. Scotland,
No.
Mr. Nobriga,
No.
Mr. Manning,
No.
Mr. Marcelle,
No.
Mr. Birchwood,
No.
Mr. Romaine,
No.
Results of division are as follows: 23 members voted for the bill, 10 members voted against, there were 0 abstentions.
And to announce, members, that the results of the division is 23 members voted in favor of the bill, 10 against with 0 abstentions. I will now invite the clerk to read the long title of the bill. Okay, allow the clerk to do her job.
A bill entitled An Act to Establish the Offence of Home Invasion and, in that context, to provide that a person has no duty to retreat when acting in self-defense or defense of his property, to provide that a person may use defensive force, including deadly force, to protect himself, his property, or another person in his dwelling house, and to provide for related matters.
Leader of the House.
Mr. Speaker, I beg to move that this House do now adjourn to Friday, November 28 at 1:30 p.m. On that day will be Private Members' Day, and we await to hear from our colleagues as to what motion we will be pursuing.
Thank you very much, Mr. Speaker. I wish to serve notice that the opposition will be debating motion number 3 on the order paper.
Honourable members, the question is that this House do now adjourn to Friday, November 28th at 1:30 p.m. All in favour say aye. Aye. Any against? The ayes have it. This House now stands adjourned to Friday, November 28th at 1:30 p.m. Good night, everyone. Thank you all very much.